Section 21.
Section 21. Whereon receipt of information by or of a complaint made to it, the council is prima facie of opinion that any member of the institute has been guilty of any professional or other misconduct, the council shall refer the case to a disciplinary committee, and the disciplinary committee shall thereupon hold such inquiry and in such manner as may be prescribed, and shall report the result of its inquiry to the council. My lord, this was done, my lord. My lord, the council referred the case to the disciplinary committee on 9th April 2008, and the report of the council is dated 3rd February 2010. However, it is to be noted, my lord, it was made over to us only on 4th March 2011. The report is of 3rd February 2010, but communicated only on 4th March 2011, more than 1 year later. Well, then, if on receipt of 21.2, if on receipt of such report, the council finds that the member of the institute is not guilty of any professional or other misconduct, it shall record its finding accordingly and direct the proceedings shall be filed or the complaint shall be dismissed. Well, in this case, the DC, the disciplinary committee, found us to be guilty, so therefore we come under 3. If on receipt of such report, the council finds that the member of the institute is guilty of professional or other misconduct, it shall record a finding accordingly and shall proceed in the manner laid down in the succeeding subsections. One of the finding of guilty by the council is on 16th May 2012. 16th May 2012. Right. Then subsection 4, my lord, where the finding is that a member of the institute has been guilty of a professional misconduct specified in the first schedule. In the instant case, my lord, we've been held guilty under part 3 of first schedule. The council shall afford to the member an opportunity of being heard before the orders are passed against him on the case, and may thereafter make any of the following orders, namely reprimand the member, B, remove the name of the member from the register of such period not exceeding 5 years as the council thinks fit. In our case, my lord, there's a suspension, the removal of the name for 3 months. So less than 5 years.
Yes.
Provided that where it appears to the council that the case is one in which the name of the member ought to be removed from the register for a period exceeding 5 years or permanently, it shall not make any order referred in clause A and B, but shall forward the case to the High Court. That's not the case in this present case, my lord. Then, my lord, 5, where the misconduct in respect of which the council has found any member of the institute guilty of misconduct other than of any such misconduct as referred to in subsection 4, it shall forward the case to the High Court with its recommendation thereon. That's also not the case here. So, my lord, since the order is under 4B, 21(4)B, my lord,
Yes.
Your lordship will take 22 capital A. Appeals. Any member of the institute aggrieved by any order of the council imposing on him any of the penalties referred to in subsection 4 of section 21 may within 30 days of the date on which the order is communicated to him prefer an appeal to the High Court. That's what we have done, my lord, in the present case. And my lord, if I just read the proviso, provided the High Court may entertain any such appeal after the expiry of 30 days, if it is satisfied, we've come within the period, my lord. 2, the High Court may, on its own motion or otherwise, after calling for records as the case, revise any order made by the council under subsection 2 or subsection 4 of section 21 and may A, confirm, modify or set aside the order, impose any penalty or set aside, reduce, confirm, enhance the penalty imposed by the order, remit the case to the council for such further inquiry as the High Court considers proper in the circumstances of the case, pass such other order as the High Court deems things fit, provided that no order of the council shall be modified or set aside unless the council has given an opportunity of being heard. The council is given an opportunity of being heard, and no order imposing or enhancing the penalty shall be passed unless the person concerned shall be given an opportunity of being heard.
Mr. Mukherjee, 1 and 2 operate in separate spheres. One is
Yes,
suo motu, another is appeal.
Yes, my lord.
So this is 1.
Yes, my lord. Great. My lord, sir, if I have a leave for my learned
Yes, yes, sir.
অনির্বাণ ডিস্টার্ব করবে আমাকে
নিয়ে তৈরি করেছেন আপনি
আমার ডিস্টার্ব করবে তুমি আমি the charge
exception to this one.
Pardon?
I take exception to this.
To what?
But he's saying I'll disturb him. My lord.
so I'm making Mr. Mukherjee sit next to me because he will disturb
I'm his chamber junior.
Oh, that's it.
so I know him too well. My lord, the charge which we are the charge which we have been found guilty of is charge 1 and charge 4, both under the schedule. Kindly come to
Page 33.
page 33, the first schedule part 3, page 33,
Yes.
first schedule part 3, 1. Professional misconduct in relation to members of the institute generally. A member of the institute, whether in practice or not, shall be deemed to be guilty of professional misconduct if he, this is the one, I have been held guilty of, only one, includes in any statement, return or form to be submitted to the council any particulars knowing them to be false.
So you will be harping on knowing them to be false.
And no, also on the absolutely on the making them making any statement which is false also. Not false and not knowing to be false.
All right.
Knowing to be false, the other advantage I have is
It is also
they-
not false, you are saying.
not false at all. And my lord, I have a knowing to be false. I have the other advantage that the council also did not find me to be knowing to be false. Now, my lord, before both disciplinary council and calling in TC and the council, lordship, the charge which is against me is that there is a form number 18, form number 18, which is required to be filed by any partner, by any firm whenever there is a reconstitution of the partnership firm.
Page 735.
Page 735, volume 2. Volume 2, page 735. My lord, may I
হাতে
come
দাও।
একটাই volume আছে page 735. Well, there's only one.
এটাই
প্রভিশনটা কোথায়? প্রভিশনটা
ওটা রেগুলেশন
আমার জিমে যাওয়াটা কাজে লাগে।
735B is that form. And I will presently show, my lord, the regulations which require this form to be filed whenever there is a reconstitution of the form. And this is the form in question. To a regulation copy may I hand up the regulations to my lord? Kindly take the regulation where this form is required to be filed. Page
190 and 184.4.
190, that is regulation 190. Page 182. Page 182 is regulation 190.
Regular page
190 sub regulation 5 at page 184.
Yes.
Sub-regulation 5, with effect from such date as the council may decide, the particulars regarding offices or firms shall also be furnished by a chartered accountant in practice or a firm of such chartered accountants whose particulars are already entered in the register of firms in the appropriate form as revised by the appropriate form. Star is given below, form 80. আমার দিয়ে দেবো, আমার দিয়ে দেবো। So this is the form which has to be filed whenever there's a reconstitution.
Yes.
Now here there is a form that was submitted on 31st. This is the page 735. P is the form that was submitted on 31st December 2001.
This form was introduced in 1991.
Oh, this form was introduced in 1991. This is no one is
That is before the entire.
So, so this is the form submitted. According to them,
Page 735.
B, capital B. This is the form.
All right.
And Lordship, just briefly for 2 minutes, what's happened here? What is the charge? The charge is that certain complainants made a case that in April 2002, there was allegedly a partnership deed of Lodha and Company with 3 partners: R.S. Lodha, late R.S. Lodha, Aitavardhan Lodha, and Harshvardhan Lodha. 3 partners. April 2002. Yet, in my form, which was filed in December 2001,
31st December.
I have stated and I have given particulars of 14 partners.
31st January 2000. This form was filed on 31st January 2000.
Oh, 31st, this form is filed in January 2002
It's,
as on 31st December, but then this is filed January 2002 and the partnership deed in question is alleged partnership deed is April 2002, which they produce. So they are saying that being the partnership deed, you have made a false statement.
So you filed the form prior to this.
Partnership, alleged partnership. I'm writing that in bold, alleged partnership deed. Because then what happened before the disciplinary committee, where the extensive trial was there with evidence, the question came up when they produced this photocopy of a document. First thing, show us the original. No response. Then the the DC, disciplinary committee, repeatedly questioned them. Give me the source from which you got this document. Give me the source of this document. They refuse to give. I will place those transcripts. The DC itself says, if you do not at least divulge your source, I cannot rely upon this document. And thereafter, we were asked to show what is this, on what basis are you saying there's a 14-partner partnership. So we produce the original partnership deed with 14 partners, with the caveat that I do not want to give this deed to the complainants. The disciplinary committee does not object to it. I will show the transcript. Disciplinary committee says, okay, produce it. So I produce it. Disciplinary committee considers it, says, very well, take it back. By letter also, I record that if required, I am willing to file it also. That's in the questions also, but so long as it is kept secret. The reason being for this, we not wanting to disclose to the complainants, which is that this is, according to us, a malafide complaint, which Mr. Abhatosh Mojumdar's topic is that, where he will show that this complaint came to light first in the testamentary proceeding. Long before it was served on us. The Birlas produced this in the testamentary proceedings. Then, they have got verbatim, there are photocopies, verbatim statements made by the Birlas in the testamentary, in the proceeding, in the CL company law board proceeding, which they had filed in 2004-5. Verbatim same photocopies used. So to prevent this, which he will explain, he will show the details. So we did not want to disclose this, and the DC did not say anywhere that I will not look into it. And I will show this is not really a adversarial proceeding. It is the complainants really are there to assist the disciplinary committee and the counsel. That there are provisions also, and it is between the counsel and the accused. Be that as it may. So this was the long and short. Then comes the disciplinary committee report, which is strangely enough, this is dated, which is dated
3rd February 2000.
3rd February 3rd February 2010. But the order is communicated to me 11th March 2011. 11th March
March or
2011.
11th or 4th March.
4th March.
4th March. Okay. 4th March.
Served on 11th.
Dated 4th March, served on 11th March. Let's take it as 4th March. 4th March 2011, order of 3rd February 2010 is served on me, where the finding is, in one place it is said, I did not produce. There are 3 different versions so far as the 14-partner partnership deed is concerned. One version is, one paragraph or 2 paragraphs said, I did not produce it at all. Another 2 paragraphs are there where they have said, I have produced it, they have seen and returned it. Anyway, the transcripts are on record, so I will show from that. So that on that score, there are 2 different findings. Then the third finding is, since you did not give it to the other side, I will not rely on it. To the complainant. On this premise, how am I guilty of this charge, this charge 1 is that either I made a false statement. Sorry, well, I should have given the background. The charge is that I have made this Form 18 so as to get more audits. Because with the 14-partner firm, I can get empanelment with banks, RBI. With 3-partner firm, I cannot get it. So to get more audits, I have done this. So the finding is that there is no finding that I given false particulars. There is findings that either you have given false particulars to the institute or to the empaneling authorities.
Pardon? To the
Empaneling authorities like RBI, banks, nationalized banks, public sector undertaking. Now, my lord, so this is the finding so far as charge 1 is concerned. Charge 1 is concerned, that is, the charge is that we have furnished false particulars to the institute. This is the finding. And charge 4 is concerned, the finding is similar, that I have given false particulars to the empaneling authorities. No finding that I give false particulars to the council.
That was on charge 4.
Charge 4.
1 and 4, you were indicted on charge 1 and 4.
1 and 4, but the same part 1. Same
Yes, yes.
part 3, sub-regulation 1. False. And my lord, there is one other part to the story, is that they found an assessment order of the year 2002 or 3, income tax, where income tax assessment order records that there are 3 partners getting profits, earning profits. Now, this assessment was revised in the year 2011, where they accepted that, yes, there are 3 profit-sharing partners and 11 are non-profit-sharing partners. So the non-profit-sharing partners, what was paid to them as share of profit, should not be deducted. So my income was revised, and I had to pay some additional tax. But income tax records also records there are 14 partners. Initially, possibly to save tax, they had done this. Now, my lord, the other
That was revised in 2011.
2011,
Which is subsequent to the complaint. Must be subsequent, subsequent to the report also.
The complaint, but before the order was communicated, but then it is before the council's before the council
Before the report.
before the council's report. So that hearing was
Hmm.
and now, my lord, the other part to the story is
Yes.
I have 3 profit sharing partners and 11 non-profit sharing partners.
Yes.
Whether that is a valid partnership or not, really, whether we can call them partners or not. The DC has found, though there is no, ultimately there is no finding, shouldn't have, they don't qualify as partners because they are not profit sharing.
Does the Partnership Act distinguish between the two? It
And
doesn't.
In fact, kindly see this, since this form 735B is in front of your lordship, or just take a look at that. 735B, kindly see paragraph 3D.
Yes.
Their form requires whether all the partners are sharing the profits of the firm. And the answer written to that is no in the records.
You are indicted on this.
Yes. This deed is
False
incorrect. False particular.
False particulars given in form.
All right.
Because we have given judgments to show that that does not may have some tax implications. Tax implications may be different, but not so far as partnership law is concerned. And anyway, they recognize this concept, and it's very common for all partnership forms.
No, might have been otherwise if subject to hearing them, if there were 14 partners, but you disclosed 3.
Yes.
This is the other way around.
Other
You
way.
disclosed all 14 and said that all were not profit sharing.
And all 14 have signed this document at page 735E.
Yes.
All the 14 have signed.
So what is the falsity according to them?
The
That it should have been
falsity is
3.
you have given false particulars to the income tax authority.
Either or.
May I just show that part because this is little hard
But
to.
that is that covered by the?
Oh, Lordship kindly comes to that straight away. Malor, may I come to the disciplinary committee's finding on that, the DC's finding on that. Lordship, kindly come to page. This is again. This is just the council has accepted it. Lordship kindly comes to
540.
Only Mr. Rai is qualified to handle this sort of a.
546.
Not a paper, it's a petition. That's the difficulty.
546.
No, well,
The appeal. I mean,
Lordship kindly come to page 546. 546. I know it's very cumbersome to. I wish they Lordship had 3-4 volumes.
no, that is not the reason my learned brother is not looking into it.
No, he's like traditionally he's relying on what I'm saying, which your lordship is also doing. But 54.13, page 546, paragraph 54.13. May I place this?
Yes, please.
Page 546. In view of aforesaid, this is the conclusion. In view of aforesaid, the committees of the considered opinion that the respondents are responsible for filing false particulars of partnership of Lodha and Company, Bombay, Lodha and Company, Delhi. In view of above, the committee wishes to point out that the respondents have either filed false particulars with the institute and empaneling authorities, or furnished false particulars with tax authorities to claim salary of partners as expenses, etc., to save tax.
Because before the IT authority, you said 3.
Profit
That's
sharing.
why either. I mean, well,
Accordingly, the committee is of the opinion that
This is unbecoming.
sorry, yes, sorry,
Unbecoming.
this is an act
unbecoming.
of a chartered accountant.
Right.
Accordingly, the committee is of the opinion that the respondents are guilty of professional misconduct falling within the meaning of clause 1. Now, so far as the charge 4 is concerned, then I shall go to the councils. Charge 4 is concerned, the conclusion, Lordship kindly come, the same volume, page 551. Paragraph 63. The committee has carefully considered the submissions and other materials submitted by both the parties and accordingly submits its findings as under. Admittedly, the respondents and their firms have filed same particulars with the impaneling authority, 1440, and which they have filed with the institute in Form 18. In view of the finding, the committee is of opinion that the respondents have filed false particulars with the impaneling authorities too. Now, 63.2, I'm just placing, then I shall play. Because since 2005, we've been plagued with various anonymous complaints. Even CAG had questioned our firm's number of partners. Now, 63.2. So far as the disposal of complaints with the Comptroller and Auditor General and other authorities is concerned, the committee cannot take cognizance of the documents shown to the committee because the same or their copy was neither filed before it nor shown or confronted with by the complainants. Further, the facts and proceedings before C and AG and other authorities are not before the committee, because we got these show cause notices from the Comptroller, the 7, 8 onwards. We had to explain and they had
63.2 is in your favor.
In view of the above, in the opinion of the committee, the respondents are guilty of professional misconduct in terms of clause 1. Now, Lordship, the same thing is the finding of the council.
Council है 5.107. Are you 107?
No, what was the difference in charge 1 and 4? I mean, both are on this non-disclosure of.
May I just show that charge then? Quickly, may I?
These charges are to be looked into.
Yes. Lordship, kindly come to.
The council.
I will be placing this in more detail. Lordship, kindly come to the charge 1 first. In the DC, the DC only is there. Kindly come to charge 1 at
524.
Charge 1. Charge 1, 54.1.
524.
524.
524 এ বলা আছে
What is the charge? Charge 1.
Five?
24.
Yes.
The first charge relates to furnishing of false information to the institute and other impaneling authorities in respect of number of partners of the firms, the new Lodha and Company, Delhi, Bombay, Calcutta, by filing wrong particulars in form number 18. The respondents disclose certain number of partners to the ICAI, CAG, RBI, etc., and some other number of partners to income tax authorities. The misconduct falls under Part 3, Clause 1 of the first schedule to the Chartered Account, which states a member of the institute, whether in practice or not, shall be deemed to be guilty of professional misconduct if he includes any statement, return, or form to be submitted to the council, any particulars knowing them to be false. The complainants furnished that as per documents placed on record by them during the relevant period, there were only 3 partners in Lodha and Company, whereas in the list of firms published by the institute, namely of 14 partners are shown. They stated that as per partnership deed, 1st April 2002 of Lodha and Company, there are only 3 partners. Firstly, I don't know how 1st April 2002 can be the basis of a wrong form in 2001 December, but be that as it may. There are only 3 partners named Rajendra, Aditya Bikram, and Harsh. The said deed further provides that the business in the name as a Lodha and Company shall be carried out by the said 3 partners. The salary shall be paid to the said 3 partners. Entire profit and loss will be shared among the 3 partners. The said deed has been signed by all the 3 partners only. It was further stated that as per balance sheet of Lodha and Company, Kolkata at 31st March, entire capital has been contributed by 3 partners. That's possibly correct. The tax audit reports and computation of income also showed that there are only 3 partners, that is the 3 Lodhas, and the profit sharing ratio mentioned against their respective names was the same as mentioned in the partnership. The complaint stated that as per the list of firms published by the Institute of the Institute of Chartered Accountants, as at for 1st April, Lodha and Company had 14 partners. 14 names of partners were appearing, namely partners. The complainants further stated that as per partnership deed, each of the 3 partners, Lodhas, were entitled to the salary of so and so per month, which aggregates to rupees so and so per annum. The salary to the then para 11, by 32, the complainants emphasized that the remaining 11 partners of the firm were neither parties to the partnership deed, nor they shared any profits or even the fixed remuneration as a partner of the firm. All other documents referred by above corroborated with the partnership deed 1st April, which fully approved that his partnership deed has been duly acted upon. The complainant stated that in case Lodha and Company, Mumbai, as per list of firms published by the Institute, the firm has 8 partners, namely Shanti, so, whereas as per the balance sheet of Lodha and Company as of 31st March, entire capital has been contributed by the 4 partners mentioned in the partners' capital account. As per computation of income under income tax, salary of partners so was 6,000 for the purpose of claiming deduction under Section 40B, and no other remuneration of any other partner was included there. Meaning thereby the other 7 partners shown in Institute's records were not the partners in the said firm. They have neither shared the profits nor were they paid fixed remuneration as partners. And then they go on to this law, etc.
Charge 4 is 549.
Now, charge 4, Lordship wants to know, because I shall be placing this in more detail when I.
No, rather they say that you disclosed 14, but the rest of the 11 were not partners because there was no profits.
That they have said in one place, another place they have said I have not disclosed 14.
That is charge 1 apparently.
Well,
Charge 1 is that apparently.
charge 1 is that there, but there's contradiction.
Disclose 3 only because they are relying on
মানে
2002
কোথায়
partnership.
কোথায় উল্টো টাকা
হ্যাঁ?
যেখানে কন্ট্রি ফাইন্ডিং আছে এক জায়গায় বলেছে যে পার্টনারশিপ দেখায়নি, এক জায়গায়
ও,
বলেছে
সেটা,
দেখিয়েছে।
সেটা।
দুটোই সেম হয়ে গেল কেন?
Change করবে।
ওরা বললো
কোনটাতে চান কোনটা?
But if that be so, probably the finding of the DC would be arguing is a third case. It might be argued probably.
Absolutely.
Whatever, I mean, let us see how it.
Now, Lordship kindly sees.
কি করবে? এটা কি হয় না?
Now, she kindly see 54.12. 54.12, that is at page 546. The respondents could not produce any partnership deed in support of their contention in Form 18 under serial number 3C. Whether the partnership deed is supported by a deed, to which the answer was yes. Now, exactly the opposite is paragraph 62.
While dealing with charge 4,
While dealing with charge 4, that's while dealing with charge 1. Now, page 550. Dealing with charge 4, the DC says, I had produced it. Paragraph 62. The committee asked the respondents to produce evidence showing that the allegations made in the said alleged matter are similar with the cases different authorities, CAG, so and so. In this regard, the respondent requested the committee member that they could produce the same, but those documents would not be parted with the complainants. The respondents produced the documents, including copy of partnership deed, before the committee. Same was returned back to the respondents after perusal by the committee.
ওটা ট্রান্সক্রিপ্ট আপনার ইন্টারনেট
Yes.
অন করে দেবো 1 সেকেন্ড আমি জাস্ট করে দিচ্ছি 1 মিনিট see this note here and the other note here. Okay. Not the only. It's the only.
Now, my lord, may I go? This being the yes, my lord, the council's finding. The council's finding, page 107. Very contradictory বলেছে।
107 এর ফার্স্টে রেকর্ড করেছে, তার ফাইন্ডিংটা ইজ 117 পরে 107 এর ডিসি
107, then charge 1 is set out at
107 এর আগে চার্জ ওয়ান নিয়ে কমিটির কথাটা পুরো বলেছে at 107.
now Lordship kindly comes
the
to the
summarize.
fine to the summarization. It starts at page 100, charge number 1. Charge number 1, page 100, and the now up to paragraph 5.1.10 is really the submission. Paragraph 5.1.11, page 107.
Yes.
Without retracing from the aforesaid finding, without retracting from the aforesaid finding, the committee wishes to point that the respondents have either filed false particulars with the income tax with the institute and empanelling authorities, or furnishes false particulars with the tax authority to claim salary of partners as expenses and to save tax. This is an act unbecoming of a charter court. Then the respondents could not produce any partnership deed in support of their contention in Form 18 under serial number 3C, whether the partnership is supported by a deed, to which the answer was yes. In view of the aforesaid, 5.1.13, in view of the aforesaid, the committee was of the considered opinion that the respondents were responsible for filing false particulars of partnership deed of Lodha Company, Delhi. In view of the above, the committee wishes to point that respondents have either filed false particulars with the institute and empanelling authorities.
It's a bit repetitive.
Repeated that. And then
Not only repetitive inter se, but repetitive of the report also, reflection of the report.
Accepted here at the
And-
decision of the council is at
Report
117.
copy
the
paste.
formal acceptance is at page 117. The
At
decision
123.
117. At 117. Lordship kindly notes now comes page 118.
If your representation is starts from page 117, then how could the findings precede that?
No, that is the finding of the committee which is summarized.
Oh, well, that is the committee's finding. DC's finding summarized by the council.
Oh.
And now comes
So
the
it looked
the
like a
coun-
copy paste. Yes.
Then comes the council's
Yes.
finding, page 117, where they have set out my case first.
I mean,
8.1.6 is the first paragraph of the council's finding.
8.1.6.
absolutely.
But in 8.1.5, you may point that out. The council further noted that complainants did not submit anything with respect to this charge.
Now, may I place from paragraph 8.1.6?
Yes.
8.1.6. On perusal of the documents brought on record, including the disciplinary committee report, the written representation of the complainant, as well as the respondents, and the oral submissions made by the respective counsel for the complainants and the respondents, noted that the papers now relied upon by the respondents are fresh piece of evidence, whereas the respondents have brought on record that the assessment of income of the assessee firm for the assessment year 4-5 was reopened under section 147. The assessing officer, while perusing the documents brought on record by the assessees, were of the view that all the partners who were drawing remuneration or percentage share in the profits and who were drawing remuneration fixed basis were all partners of the assessee firm. In this context, the council was of the view that the fresh evidences which had been brought on record by the respondent are the assessment orders relating to the assessment year 4-5. The limited purpose of these assessment orders is only from the angle of revenue collection by the department, whereas the proceedings before the disciplinary committee, the matter before the council, are separate sets of proceedings. Then why, if I misled the income tax, why am I guilty here? Separate set of proceedings, and the assessment order so passed by the income tax department does not have any bearing on the matter which is before the council of the institute with respect to the number of partners. In this context, the council further noted that the respondents had brought on record before the income tax department partnership deed dated 31st December 2001. Whereas if the respondents had relied upon this so-called partnership deed, then accordingly the same should have been placed on record by them before the committee, and I will show it was placed on record. And if not so, before the committee, or at least for the council for coming to its independent opinion. The council further noted that the returns which had been enclosed by the respondents about the income tax returns filed by the so-called partners are concerned, it was categorically seen that some of the so-called partners, while filing their income tax return, had shown their income as salary from the firm, and in support of this, even the salary certificates were endorsed along with copy of returns, which further strengthens the fact that these so-called partners were in fact drawing salary. It was also observed by the council that though in Form 18 filed by the respondents under serial number 3C, whether partnership supported by deed, the answer was yes. However, the respondents at no point of time produced the said partnership deed, which they have produced before the income tax department. Accordingly, the council accepts the report of the disciplinary committee insofar as the respondents being responsible for filing false particulars of partnership. This is the thing. Who is that 125? The finding taken. The finding. মাঝখানে এটা কি মাঝখানে কি রয়েছে Now, charge number 4 is page 125. Now, Lordship, kindly come to straight away, go to the conclusion at 8 at 126, 8.3.2. The council took into consideration the submissions made by the respondent with respect to discharge, along with the report of the DC, and further noted that since the respondents and their firms have filed different sets of papers before different authorities, however, moreover, the respondents have failed to bring on record as to what papers they have filed before other authorities, since the said information was within their personal knowledge, and thus the onus to prove the same rested with the respondents, which they failed to do so. Accordingly, the council has accepted the report of the DC and held that the respondent. I'll keep going. Give you one bit. Here is the complete defense.
Yes.
Now I shall go point-wise. First point, the form filed on 31st, a form dated 31st December 2001 and filed in January 2002 cannot be supposed to be in sync with a partnership deed, if at all correct, of April 2000.
December. Volume 535B.
The partnership was created in April or reconstituted.
Their case is April 2002 is created. I will show the partnership deed. The form refers to a partnership. But the form at page 735 refers to a partnership deed of 31st December 2001.
সেখানে নিয়ে আলাদা অন্য জায়গায়।
So did you produce that document before the?
That is the document which I produced. Lordship may kindly come straight away to the
transcript.
To the transcript, which is at
353. 353. ওদের যেটা ওদের
You kindly come straight away. Well, may I come? What I produced? You kindly come to
353 আচ্ছা 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 পেজ 4 এ আছে
page 353. That December. We'll come to there. Arrange 2002 a bit later.
এটা দেখেন দুটোই রাখা দুটোই রাখা
No, the 2001 partnership deed contained the name of 14 partners. This composition which you have disclosed.
Lordship kindly comes to page 353.
Yes, 353.
In the middle is very clear, but then its transcript is not perfect. Page
353
353. Or you will see the first at the top in bold, the 3 lines in top. Original documents produced by the respondents before the committee with the request that these documents cannot be part with the complaint. The same was returned back after going through by the committee.
But what document was produced is not referred to there.
That is, yes.
তার নিচেই আছে 353 তে এখানে পার্টনারশিপ ডিড
That is the one below the precedent. Where is the copy of the deed of partnership? Partnership deed produced by the respondent, CAV Lodha, before the committee. Transcript.
আর তবে 483 তে আবার
And anyways, Lordship, at paragraph 64, they have
62
paragraph 62
of the DC
of the DC. It's recorded that the partnership deed was produced. That is at page 550.
and At 483 to CAG. যখন আবার জিজ্ঞেস হয়, are you ready to file all the documents? We said again.
Now, Lordship kindly comes to
ট্রান্সক্রিপ্ট ঠিক আছে,
চিঠি
দেখাচ্ছি পরে আছে।
page 483. Mr. G. Ramaswamy puts this question to Mr. Lodha. If any direction comes, are you ready to file all the documents again? Page 483.
Yes.
The second one, Mr. G. Ramaswamy.
Yes.
Or from top, we see heavy loader. We have all the documents with the institute and those factually the correct documents. We have not made any wrong filing. The charge is that we have filed wrong filing with the institute. With respect, I would submit that not once having made any wrong filing in front of the institute. Mr. G. Ramaswamy, if any direction comes, are you ready to file all the documents again? The whole issue here, sir, I think fundamentally the two parts. If it is institute to whom I have to file, I have no hesitation in filing the documents again. But the proviso is I do not think that this complainant goes for that this complaint goes for bona fide reasons. That this complaint the complaint is mala fide for other purposes. We have submissions on record in this hearing and the papers given to them by the advocates, etc., by advocate. That's as regards if it is restricted to the institute, we have no problems. But give it the other side. I am sorry we are restricted. We do not want this to become mala fide process. With respect, there are several judgments. And there's a specific letter recording this fact also long before the DC report was also. Page 722.
দুটো আছে, প্যারা 3 তে বলেছি, আর তারপরে প্যারাগ্রাফ 75C।
But may I first show paragraph 3 at 723?
This page is page 340, যেটা আমরা দেখালাম, page 353. Page 169 is page 353.
Paragraph 3. In answer to a question of Mr. G. Ramaswamy, learned member of the disciplinary committee, page 169 is 353, which I had placed, as to whether my clients are ready to file the documents.
Sorry, that was the next page. My mistake. 483 যেটা ছিল।
This 483.
483.
As to whether my clients are ready to file the document, that is partnership B 31/7/2001. If direction came from the institute or from the disciplinary committee, members A.V. Lodha replied that he wouldn't do so. My client's objection was all material time to the complainants having access to documents disclosed to the institute, which in the normal course they would not have had access to such documents. Incidentally, we noted that the partnership has also formed the basis of the application for empanelment of CAG. Now, Lordship, 5 and all are on their deed, which is a
So page 483, the part of the minutes, and page 723, the letter recording that, show your intention to produce.
And 725 of the letter, very clearly, we have repeated once more, intention to
Intention, and this coupled with page 753, part of minutes, and 550, the recording that it was produced.
What?
Very good.
So this is so far as production of the 31st December 2001 partnership. Now I come to the so-called partnership deed of April 2002, which is the bulwark of the complainant's case. That document, Lordship, will be finding at page
of ICAI 106.
At the affidavit of Institute of Chartered Accountants.
So that 2001 document you mustn't have filed here also, because you don't want to disclose.
We have it with us.
But you undertake to produce to court similar as very well. Yes.
Of course. Goes without saying, I give it to Institute.
Yes, right. The same line, the logic. Yes.
Not too bad. Because also Lordship has seen in the appeal, there's provision under the Act 22A2. Opportunity of hearing will be given only to the member. There is no provision for hearing.
Maybe you have a point there, Mr. Mitra, because it's between the complainant should be not the complainant's job is finished after he complains.
Because 22A specifically provides.
Yes,
that,
hearing to the respondent.
and also before the counsel also hearing to the accused member.
Accused. Yeah.
And in this case, factual background lordship also perceived that my client was naturally very wary of producing anything which they'll find out something somewhere, some tax violation somewhere.
Now, school, in our school, Calcutta Boys School, we had a teacher, physics teacher, who used to say, something somewhere must be wrong in his own accent. So that is there, according to you, there.
Large business houses, something somewhere maybe
that
wrong.
was directed towards students, but this is towards someone else. Yes.
Lordship kindly comes to the affidavit
Yes.
of
Page.
affidavit in opposition of the institute that is affirmed by, I'll tell you, Lordship, by Tiruvani. Tiruvanai.
Leave the pronunciation out, Mr. Mitra. We'll look into it.
Tiruvani. Tiru. Volume 1. ও আমার opposition.
When this happened, Mr. Lodha was no longer. Mr. R.S. Lodha was no longer. We were not sure whether there is at all such a deed. 2001 or 2. So we asked them to produce number of times. But then they could not produce, they could give their source also. And then we categorically said it's a fabricated document. This is not, we don't have trace of this document. Yes, income tax we had tried to save some tax. That is, there seems to be, that has been revised afterwards.
But the offense under the act is probably schedule is not any other authority.
In fact, the council has said that is revenue purpose. This is our council purpose. So I'm not concerned with the revision of the income tax assessment.
Yes, I cannot issue a 340 if you go previous 340 if you go before the Bombay High Court and show something wrong, false. So it has to be before that council only.
And that's the and that is the Schedule 1, Part 3 also.
Yes.
This is the deed of 1st April 2000.
Which page, Mr.
Page 106.
106.
বডিতে দাঁড়ান দেখে বলছি
Sir, 106 of you.
No, 106 is a part of the balance sheet, profit and PL account.
106
This is affidavit in opposition, volume 1. This is
of Tiruvanai.
no, এটা কার্তিকেয়ান দিয়েছো। অন্য affidavit.
That is the
এই পেছন দিকে ব্যাক শিটে দেখো।
no, sorry. I.T. Karthikeyan. Son of Tiruvanai. Sorry. I shouldn't be trying to. I should not be trying.
Poor Mr. Tiruvaran.
This is affirmed on 30th
Yes,
of.
Tiruvanai.
Oh, this is.
Yes.
25 years. I see it.
Lordship, does it tally with Lordship? Kindly see.
Son of Tiruvaran is written. Come to page 3 with the typewritten. Yes, then it's the same one. But 106 is PL account, profit and loss account in our.
Lordship kindly comes to page 25. Subparagraph 89 এখানে আমাদের 24 or maybe the different well page 25 of the affidavit.
25
the body B.
11B.
The complainant shall rely upon a partnership deed of 1st April. Does it tally? We are looking at the affidavit
Yes.
of Harshvardhan Lodha.
In ACA 5.
In ACA 5.
5. This is 6.
Oh.
Reply of
Anyway, must be tallying.
5 এর affidavit in opposition নেই? 5 এ ফাইলটাই নেই? দুটো তো হিয়ারিং হচ্ছে।
It is the same.
হ্যাঁ?
5 আমি বার করে দিচ্ছি, দাঁড়া ওটা থেকে বার করে দিচ্ছি।
Final?
So page 25 আছে।
There may be sometimes it happens because it
I know, মানে
is written with the
DLL আছে।
Well, page para 11B it tallies.
11B tallies, but
25.
because that was a copy paste up to that.
দেখতে হবে। আর page 106 ওটা ছিল।
There's a page number given at the break.
Oh, 106 is
given in
not
brackets, page
Uh,
26.
Oh, the
If you see
partnership
the
deed,
first line of
101. Partnership deed is at 101. 101.
Yes, yes.
ওটাতে
অন্যটাতে।
এখানে 106
হ্যাঁ, এখানে 106.
কোনটা দেখছিস?
ঠিক আছে আছে পেজে জচে
Yes,
পেজ
there's 6, SCS 6.
That one I have to take instructions for because this is need file.
Difficulty SCS 6 will follow, so 101 must be same.
Opposition ballot.
Must be same. Yes,
so this is the deed.
yes.
This is the deed, supposed deed. Now I'll come to the drama, if I may use the word, regarding this deed. This deed.
Yes.
এটা
অনুসব জায়গাতে মিলবে তো?
Petition সব মিলছে। এও দেখে।
Page 368 in the transcript.
Yes. Okay, এক্ষুনি যদি জিজ্ঞেস করি, তারপর mention একটা করতে পারি। এটা
368
বলতে গেলেই আবার mentioning শুরু করবে। Sorry, yes.
regarding this 2002 deed. In the middle, Mr. G. Ramaswamy.
No, sorry, we missed out. Yes,
So this is 368 of volume
This-
of the petition.
of the volume.
Of the petition.
Of the volume.
এখানে বার করে দাও না। 368. G. Ramaswamy. Third,
368.
8.
Yes.
He can rely upon photocopy and the council will take note of it. 368, the third paragraph.
Yes.
Mr. G. Ramaswamy,
Yes.
DC member. First of all, you have to disclose the documents which you have obtained.
এটা complainant কে বলছে।
He's telling the complainant, which you have obtained from where you have obtained. The committee's direction, you should disclose the documents wherever documents have filed with partnership deed or the source. You may kindly disclose, or in case you are not giving anything, and then clearly you mention that I will not disclose it. The complainant is not in a position to disclose. Counsel for complaint. I have already made it clear that the complainants are not required to disclose in law. Then Lordship kindly comes to 359. When the complainants are being examined. At the bottom of 359, G. Ramaswamy at the bottom. The G. Ramaswamy.
They gave a photocopy of the 2002 deed. Only that.
And from where they got it also, that's the
Source
whole
they're
thing.
not disclosing. They say not in a position to disclose. And they have no obligation to disclose.
Then he goes, I'm not in a position to disclose the same. That
Yes,
is-
last
that is
sentence.
359, then 360. Some papers collected and some of the papers other complainants collected. Now I cannot recall, so I will not. What about group?
He's deflecting the questions.
He's deflecting the question.
Yeah.
Then 361. Sir, we are not disrespecting the committee. It is the joint effort, all came together. Do you agree that all the documents have been given by all the three members, which have been taken on the income tax department and given to the council? Collectively, these were not there. Some of the documents he has procured, some of the documents I have procured. What sum? We are unable to recall now. You have filed the complaint, a serious complaint against a professional, and you are aware of Chartered Accountants Act and regulations. You're also aware of the specific clauses under which you are charging. When you are not able to produce all the details, how can you substantiate all this in your complaint with good contention?
The last sentence of that page is interesting. Page 361.
Now I will show the icing of the cake. I will show. Well, just
Now, what was the context of this?
কোনটা কথা বলছো?
From where you
Regarding
have
this-
collected, you're not giving, you are withholding disclosures. If you're relying, you remove those documents, you withdraw those documents.
if you are not relying on documents, you remove those documents, you withdraw those documents. Complaint regarding this MP Birla group and all that.
তো here is the first charge.
How does the MP Birla group
We
come
are
in here?
restricting ourselves, first charge, and all other MP Birla group and everything. If you are withdrawing all these documents, then we have to go ahead based on the charge. You have to explain that if you are not in a position to
এখানে-
disclose, you are not in a position.
So what is this MP Birla group business?
সব documents based from the
Well,
file.
They have got all these documents from
Yes.
Khaitan and Company. And I will show that
No, but that is a different thing. But what is the context in which
there were
MP?
some other charges that Mr. Lodha had audited MP Birla group companies. Those have not been held against charge 2-3,
So this must be on those charges.
possibly on those charges. But Lordship kindly
362.
now Lordship kindly comes to question 362. Page 362. Which I just now showed, Mother 362. After that, then the complainant Mr. Sharma on top. Regarding this, we have written to Khaitan and Company. From there, we got these documents. Who is Khaitan and Company? Solicitor to my employer. So you collected from some solicitor? Yes. Then you filed the complaint? Yes.
412. This question. এখানে I'll just mark the portions. এইখানটা most interesting আছে। The court document. এগুলো সব
Page 412. The submission of the council.
Yes.
Or 412. This is in the context of the other charge. Sir, clause 11 of first schedule, part 1 says engage in any business or occupation other than the profession of chartered accountants unless permitted by the council. So to engage, nothing contained herein shall disentitle a chartered accountant consultant from being a director of a company unless he or any of his partner is interested in such company as an auditor. Sir, the directorship has been explained by the institute to be directorship simpliciter. It's not a case of directorship simpliciter because having regard to the background which has been presenting since yesterday and also present before your honor even today through various affidavits and other things, I would like to submit that this is not a case of directorship simpliciter. Now, be that as it may I draw your honor's attention to some of the very important pages which I consider to be important for your honor's kind consideration. Kindly take paper book volume 2. Sir, while I am at volume 2 and while I am referring to certain matters, I am making certain certification. Clarification. Yesterday, a question has been raised, and my complainants were asked certain questions by the Honorable Committee, and my complainants refer to certain papers having been obtained from Khaitan Company. Now I wish to clarify, because it is their statement that your honors will file volume 2. The respondents has written a letter to the Honorable Disciplinary Committee saying that the documents has been filed in piecemeal fashion since the complete documents has not been filed, and there is certified copy. I mean certified copy. I'm answering for the purpose of our record that we have got complete set of documents duly certified by Calcutta and Company. We have obtained officially those documents from Calcutta and Company, who have given those documents to us.
No, but if there was a charge of any corruption regarding the accounts of the Birla, that company, Khaitan is the solicitor of that company.
Oh, Lodha and Company's accounts, Lodha and Company's income tax returns.
No, you said there was an allegation regarding this.
Regarding my directorship of not my RS Lodha or the maybe Ash Lodha, directorship of certain companies of MP Birla Group, while they were auditors also. That is the charge.
Yes, your certain acts of yours as auditor of the Birla company. So therefore, that was also part of the allegations.
No, not certain acts that I couldn't have audited the accounts of certain certain MP Birla Group companies.
Very well. If that be so, then Birla accounts become important. Birla company account becomes important, and Khaitan and Company, as the solicitor of Birla and Company, could very well have
But Lordship kindly
on the other charges.
On the other charges, but what is being shown is page 413. Kindly see the precedent on top.
Yes.
Income tax papers, he said that he received from Khaitan and Company is not there. Yesterday we were inquired. That is the income tax return and my balance sheet, which and my firm partnership deed of 2002, which they're saying I filed with the income tax department. Your Honor is very right. In fact, I was trying to interfere at that point of time, but since this one, still our questions have not been answered by the complaint from where got the paper, what they said Khaitan and Company. It is court document from Khaitan Company. It is still on record. Nobody is clear that from where they got the paper and is submitted by you. Well, one thing, well, what I am showing is that they have been provided with documents from Khaitan.
And yes, the company is the lawyer of their employer.
And these chartered accountants were employees of certain concerns where Khaitan and Company was there.
Yes.
Very important.
Now, so far as our deed is concerned, kindly come this December 2001. $379. After the initial part regarding the partnership, profit sharing and all, kindly come to the middle. Sri G. Ramaswamy, page 379. It was when we were arguing.
Yes.
Now you should file your partnership deed in the middle. Counsel for the respondent. It is not an adversarial proceeding hearing, and they are aggrieved by and they are bringing to notice of the institute certain misdeclaration by us. Now we have disclosed to the institute whatever is the fact. We have filed Form 18, which refers to the first two partnership deeds. The Institute Regulations Act do not require partnership deed to disclose. When you asked, we will show you. So it is not something of 2002 or 2003 deed which required to be disclosed to the institute. We have given reference to the deed and we have said that there is a column in Form 8 which says that all are profit sharing partners. So it contemplates non-profit sharing partnership also, whether all the partners. So where is any misdescription Here it is not the question of my not disclosing in the partnership. It is the institute who do not require that. There is no bis declaration, suppression by us by not disclosing. The institute requires only to be mentioned the deed we have that. Deed date which we have that. CAG query also give you the date. Now, next thing is G. Ramaswamy, you have filed with us, but filed that copy, sir. Council correspondence. You have very kindly agreed that it was a confidential document, which as per CA regulations is not required to be filed. So we have shown you the document. Even the Form 18 does not require the partnership deed to be filed.
No, but because there's an allegation that there is a misstatement, so the council might have looked into it.
What is the problem in filing the same?
So it appears that you have shown, which was not denied by Mr. Ramaswamy. He says, what is the problem in filing the same?
And ours is this is a confidential document.
Yes, they've also argued that Partnership Act does not require a written partnership deed. That also you have argued. I mean,
The finding আছে তো একটা। This is finding আছে তো দেখতে।
The required written, but that is there is a written deed. Partnership.
Contrary to what they're saying.
no, that does not mean that there is no written deed, but that was one of your arguments.
এটা কি? এটা কি? Sorry. এটা কি? 752?
তো এটা তো আমাদের এম্প্যানেলিং অথরিটিতে ফাইল করতাম সেটা। এম্প্যানেলিং অথরিটিতে এম্প্যানেলিং
Very. So therefore, you produce the deed, did not file it, and there are contrary findings in the DC report that once it says you have produced, once it says you have produced and taken back, not produced. So contrary findings.
And so far as profit sharing partners go,
Yes.
now Lordship, they were about profit sharing partner decision.
1078
একটা So, Mr. Mitra, apparently the tenor of your argument is that, see, 14 partners, we disclosed on the date, relevant date, it was the 2001 deed which was prevalent. April 2022, 2002 deed came later on. 2001 deed had 14 partners, we disclosed 14 partners. There is no distinction in the Partnership Act or the Chartered Accountants Act probably regarding profit sharing or not profit sharing, insofar as disclosure is concerned in Form 18. That disclosure may be relevant for the income tax purposes, where subsequently previously we had said 3, but subsequently to 2011 there was a revision and all these things, so it was rectified. First, secondly, for non-disclosure even before the income tax authorities, that does not come under the offense under this act. So therefore, there was no wrong information given by you. So you do not come under the offense basically. 14 partners, there were 14 partners, you disclosed 14 partners. And profit sharing also, you in the relevant column you had said not all are profit sharing. So there is no wrong information given. So we think that is, I mean,
That is now I'll have
regarding charge 1, charge 4, what is the distinction between 1 and 4?
charge 4. Lordship kindly comes to charge 4.
এম্প্যানেলিং অথরিটিতে আমি ভুল কথা বলেছি।
That is the charge 4, whether I've given some false information to the empanelling authority.
Whether that is an offense under the act, let us see that.
Because Lordship kindly sees the act. They are holding me guilty under part 3, under
Part 3 schedule
part
clause 1
schedule, yes, schedule 1, part 3, clause 1, page 33. Page 33, right hand side. It specifically says to be
here is the
page
charge
33.
to the CAG empanelling authorities.
Now, part 2, Roman 2, was that also included?
Part 2, Roman,
Page 35.
page 35. No, that is not fine.
The finding is
Because misconduct has been defined in one of the sections, section 20.
Finding is only of
এই যে,
that I'm guilty of part 3.
charge 4.
Both charge 4 and the charge 1. Actually, charge 4 is page 126.
দেখছি স্যার।
আমার মাপ করাটা করে চলে গেল।
আপনার এখানে ব্রিফের সঙ্গে নেই?
Only part 3 of the first schedule, yes.
Part 3. Clause 1 of part 3.
Second schedule is not even referred to.
Not even referred to.
No, not even referred.
Charge 4 comes under which serial number of part 3?
Same one.
Same. Lordship,
Same,
kindly see
same.
page 126 of that paper, of that petition.
This says statement written or form to be submitted to the council, any particulars knowing them to be false.
Lordship,
How
kindly
does
see
the
this
income tax authorities and all this come in?
charge 4.
If it was general misconduct under second schedule, we could have understood. Second schedule part 2 could be there. Misconduct is defined in section 22 probably as of a more general nature.
That is
Unbecoming of.
written by High Court. That is not.
Oh, right. All right. Right.
So,
Correct.
my lord, may I cut short a bit and then
No,
go
1 and 4, what is the difference? Please.
One
Income
and
tax
four,
authorities
when
and.
this, charge 4 where it's quoted, charge 4 is here,
এখানে কোড
Page-
আছে এখানে।
Page 551 probably.
549. The DC, na?
DC
DC.
এখানেও কোড করা আছে। এতেও আছে।
কখনো জীবনে আমি এই জিনিসটা ইউজ করবো লিকুইড টেক্সট জীবনে 549 para 58
Institute and other impairment. It's a in a broad sense.
and but the finding lordship will find
126 এখানে এখানে। পুরো finding ওখানে।
finding is 551 আর আমি আর বলবো না ভাই charge 551
Charge 1, where is charge 1 quoted?
charge 1 is quoted
একটু আগে আছে।
charge 1.
1 second, sir. Let's go. Give me one.
190.
এমনি it is. না ওর এর মধ্যে
কি বলবো মানে এইসব বলিস না টেনশন হয়ে যাচ্ছে তুই এসব বলিস না ইউজ করবো
524.
524 para 28 there also say
রাখি যেন একটা দিয়েছিলেন 191
এখানে বলে দিয়েছে এখানে
আছে 191
they overlap, rather overlap. We'll come back in 5-6 months.
They replied that. How many replied that?
আমাদের রিপ্লাই আছে।
Only other document
Yes.
I shall place before I go into the law is that the assessment order of 2011. Page 667. So, of course, these are so whatever benefit I had derived by showing less partners to income tax and saved tax, that was also undone before the রেকর্ড করেছি।
অ্যাবসলিউটলি ম্যালাফিডে
Yes, 667.
ওটা দেখার পরে করছি। মানে
Yes, ma'am. 667.
এখানে প্রফিট শেয়ারিং বলা আছে না? বলেছে answer is no. It should council is relying as a same are normally not subject to scrutiny. As if that just to prejudice.
Assessment order lordship returned to second paragraph. Later, it came to notice that partner's salary amounting to 63 lakhs only was considered for the purpose of calculating the limit under 40. This is the advantage of them making complaints to too many authorities. So they complained to income tax also. So that was the result of which I pay something more, but at least this part got clarified. Later it came notice that that partner salary amount of 63 lakhs only was considered for the purpose of calculating the limits of under 40B. It was discovered that payment made to certain partners were not considered for the purpose of allowability of the partner's salary under 40B, and accordingly, there were reasons to believe that the income has escaped assessment through wrong computation under section 40B by excluding the remuneration of working partners during the assessment year 4-5, but subsequently taken into consideration for later assessment years. Accordingly, approval for reopening the said assessment order under 147 of the Act was sought from the additional CIT. Additional say by letter dated so gave the necessary approval. Now, Lordship, the certified copy as required by the SSC was issued on simultaneous notice of 142.1, 143.2 were issued asking for the following documents. Copy of the latest partnership year of Lodhan Company as of 31st March 2004. This is. In response to the above, the Indonil Chaudhary partner, an authorized representative of assessee firm, appeared on behalf of the assessee and produced a copy of the partnership deed of 2018 December 2003, which replaced the previous partnership deed of 31st December 2001. That's the impugned one, which was also produced. The partnership deed was perused and examined. Further, as requested, the documents, including the copy of certificate issued by ICI, confirming the constitution of the firm as on 1/1/2004, as well as cash book, ledger, books of accounts, and other details were produced for examination by AR. It was seen that as per the constitution certificate issued by ICAI on 1st January 2004, 17 individuals were shown to be partners. Where is the constitution certificate? 17 individuals were shown to be partners of Lodha and Company. And all individuals shown as partners in the said certificate and signed as partners in the partnership deed of 18 December 2003. The course of hearing, it was requested that constitution certificate as on 31st March 2004 be produced, whereupon Mr. Chaudhary stated that ICAI issues the constitution certificate every year as on January 1. As per cash book ledger, this constitution certificate is at page 735J, which I 735J. As per cash book ledger, so Lordship kindly comes to 669, fourth paragraph, on perusing all documents. On perusing all documents, necessary details, papers, etc., it is observed that during the year 3-4, relating to assessment year 4-5, there has been a change in the constitution on 18 December 2003, which is evident from the deed of 18 December 2003, signed by all the 17 partners. The earlier partnership deed was executed by 14 partners on 31st December 2001, copy of which was also produced before the undersigned. It's evident from the details so furnished that only 3 partners had a percentage share in the profits of the firm, and there are other partners who were given remuneration in specific sums in lieu of profits of the firm. In other words, they were salaried partners. For the purpose of cross-checking, instruction was given to the inspector to visit ICAI's office in Calcutta to independently ascertain the names of the partners of the assessee firm. The report of the inspector was obtained and accordingly kept on record, wherefrom it was confirmed that the names of the individuals shown as partners in the list of firms issued by ICAI are the same as per the partnership deed of 18 December 2003. Further notices were issued, etc. So, Lordship, the second paragraph at page 670, after considering all documents produced, books of accounts, details, is found that individuals named in the partnership deed dated 18 December and signed by all of them were indeed partners of the firm. This also applies to those whose names appear as partners in the deed of December 2001. The partnership deed clearly showed that there is an agreement between all the persons to carry on the profession in a partnership. Further, the partners were also paid out of the profits of the firm, either by way of percentage share or by way of fixed sums. In other words, they were partners who were drawing remuneration on percentage share in the profits, and there were other partners who were drawing remuneration on fixed basis in lieu of the profits. Further, on perusal of both the partnership deeds signed by the partners and the contents thereof, it is found that all the partners of Lodha and Company have an interest in the performance and growth of the entire firm. The deed covers so and so and so. In view of the second last paragraph, the last 6 lines, in view of the above, the tests laid down as provision of the Partnership Act have duly been satisfied. The above exclusively and so then the income was recomputed.
Mr. Mitro, before going further, while formulating charges 1 and 4, the disciplinary committee had also taken note of other provisions. If you please come to page 496 and 498, we'll move on then. But because you are arguing on part 3 specifically, so if you please come to page 496, para 1.5.
The aforesaid charges, if proved, would render the respondents guilty of professional misconduct.
Clause 1 of part 3, as you said, read with section 22. And also page 490 is charge 4, which says part 1 clause 5 and clause 1 of part 3. The additional is part 1 clause 5 and section 22.
224 1B of the company.
22 speaks about professional misconduct in general and defined as any act or omission specified in any of the schedules, but nothing in this section shall be construed. But yes, any act or omission specified in the schedule. So it's also circumscribed by the schedules. Therefore, if you move on to the schedule, but 22 also says, but nothing in this section shall be construed to limit or abridge any way power, conferred or duty cast on council under subsection 1 of 21 to inquire into the conduct of any member under any other circumstances, which is more general. Any other circumstances more general. And while formulating charge 4, council also includes part 1, item 5, which is secures either through the services of a person not qualified, that does not apply, or by means which are not open to a chartered accountant any professional business.
If you're looking at
Apparently
charge,
meaning that you solicited business by showing that there are more or less partners.
schedule, first schedule.
Yes, because page 496 is the formulation of charge 1, which speaks about part 3 clause 1 and section 22.
Hmm.
22 will be coming to later. If you come to 498, there the charge is actually formulated. Violation of clause 5 of part 1 is also included apart from part
498.
page 498.
Therefore, violation of clause 5 of part 1 and clause 1 of part 3. But this is not the finding ultimately. Ultimately, finding is part 3 only.
Page about
All right.
126.
Kindly see that the finding is ultimately
The scope of inquiry was also part 1, clause 5,
part 1, clause 5,
which is procuring business by means which are not open to a chartered accountant.
secures either through services of a person not qualified to be a partner or by means which are not open to a chartered or any professional business.
Apparently meaning that because you gave out that you had more partners, you obtained business from others. Therefore, the impanelling authorities angle comes in. And section 22 has been clubbed with both. Section 22 is a bit wider than the schedule because it says nothing in this section shall be 22 specifies it to the schedule, but says nothing in that section shall be construed to limit or abridge the inquiry under any other circumstances. Generally, professional misconduct.
Yes, Lordship, but the Lordship will see this was this schedule 1, this first schedule part 1,
Yes.
5. There is no finding on that.
No concern.
All right.
Frankly, sir, there's no discussion also.
There's no discussion, and ultimately I am found guilty of
Yes.
Lordship, page 126.
Very much clear.
No discussion.
And there is no finding that any of these 11 partners were not qualified to be a partner. There is no finding that any professional business Lordship, because see, 126, it is counsel's finding so far as charge 4 is concerned, only part 3, clause 1. Even DC also.
All right. All right.
And that possibly they
Yes.
cannot say, Lordship kindly sees that institute's own certificate, which is part of my affidavit in reply.
No, but if you come to page 126, 8.3.2,
Yes.
if you read the last sentence of that, Mr. Mitro, it says, accordingly, the council has accepted the DC report and held you to be guilty of profession falling under part 3, clause 1 of first schedule. Read with sections 21 and 22 is vague.
That's
It can be anything under the
could be
sun.
anything under.
Right.
There could be something where High Court's
Yes, true,
proceeding is
true,
also
true, true.
required.
Yes, yes.
So which is not.
Yes, it could, it cannot be so broad. Then you have to formulate what is there. Very well.
I must know the charge too.
Right.
Especially for the disciplinary for the council, when the disciplinary committee gives a report.
Right.
Report is based on that. So for the council, I meet those charges only.
Yes.
Council लिखे नहीं था
You have a right of hearing before the council also.
Malan?
You have a right of hearing before the council also. Both.
Council only chartered accountant can appear, not through advocate. Before the disciplinary committee, advocates can.
This is income tax. Assistant Commissioner income tax. This is
And-
dated
ঠিক আছে, এটা
10th May 2012. It is subsequent.
ছেড়ে দাও, ছেড়ে দাও।
Yes, so the assessment order you have placed.
Actually, I have nothing more to add. Now I have to go to
Yes, judgments.
some of the judgments, Lordship. So far as though there is no finding
Hmm.
that there can be no non-profit sharing partner
Paragraph আছে
on for which I am guilty of having non-profit sharing partner, they cannot be because the only form also provides.
DC date
But still, I shall cover this aspect only because of council.
হ্যাঁ এটা কাউন্সিল যেখানে ডিসির পয়েন্টস গুলো ফর্মুলেট করছে সেখানটা
This is about in the disciplinary committee.
Yes.
There is one paragraph where this talks about this (54.8), page 545. Raman, na?
1.48 is an essential ingredient of partners.
Oh yes, sorry, a page. No, this is the charge and then the
No,
finding.
এটাই ফাইন্ডিং ফোর্স চার্জ ইজ
If proved, Lordship kindly sees. I will come.
Okay, right, you're right.
There is a para 54.8. The respondents contend that it is not essential to share the profits of a partnership on a percentage basis, and a fixed remuneration can be paid to partners. They have cited certain case laws. The committee carefully noted that the facts of the present case are different from the cases cited. The cases cited, it is clear that there was an agreement between the partners and the fixed remuneration was in lieu of profits. In the present case, the agreement is between three partners and only the remuneration paid to the others was not in lieu of profit, out of profit. Rather, it was a charge to profit, which is clear from the documents and tax records of the firm. As per Indian Partnership Act, sharing of profit may not be lost. It's an important element of partnership. This element is clearly missing in this case.
This is a finding. This is the finding. This is a finding. If you see, এখান থেকে 54 এ
This is the finding.
No, what was the council driving at? I mean, you should have disclosed three partners only.
That is something we don't know.
It could only mean that. Otherwise, I mean,
I should disclose three
otherwise, why is this important? The professional
partners.
relation?
Especially when the form itself requires the non-profit sharing partner.
Yes, your partnership. It's a registered
Nothing.
partnership firm
Yes, registered partner.
with 14 partners. So you have disclosed 14 partners, and in the appropriate column, unregistered firm. Unregistered firm. Unregistered firm. Very good.
But there is no
But you have a deed which you have produced.
I produced the deed. Income tax records also show that. Impending authorities all have 14 partnership deeds.
Hmm.
Now, one document which
Before the income tax authorities only, you said three. Everywhere
the return we had shown three originally.
Very good.
In the income tax return, we showed the three part because the other partners, which is the salaried partners, we had charged to the profit and loss account, and we had taken deduction for those salaries, which we couldn't
Yes.
have taken because they were salaried partners.
Right, because they were they were acting in the capacity of, say, like employees. I mean, they were salaried.
So that's
So regarding, they did not have any share according to you in the profit sharing ratio, in the
no
profits.
income tax returns, but complaints were
But that
made,
was subsequently reverted. Yes.
discovered because there were some complaints made, and they found that they were partners.
What we mean to say that there might have been a bona fides in that. I mean, if it was arguable whether three partners could be shown on 14 could be shown, it cannot be said that you misrepresented or made a false statement knowingly. We are on that only.
We did not misrepresent the institute for sure. We
No,
may have
that is there.
we
We
may
are
have
even on the
misrepresented the income tax, trying to save some money, save some tax.
tax evasion and tax avoidance are different concepts. So we'll have to anyway. Very good.
That is not really germane to the.
Not general, but you cited judgments on percentage basis and profit sharing basis. You had cited judgments and those were considered.
Those were considered.
We were thinking why you cited those judgments and why were those considered. And could these
Because-
questions be gone
because
into?
because we were not sure at that time whether we would be held guilty of showing 14 partners when there were actually 3 profit sharing partners. 11 salaried partners, whether that was the offense by us.
Yes.
Because everything was so fluid. So we covered that the 11 partner salaried partners can also be partners.
But
and
at the end, we suppose the premise on which you were held guilty was that you made different representations before different authorities. Before the institute, you had said 14, but before other authorities, including the impaneling bodies and
impaneling body is also
14,
because
14.
that is a
Only the income tax authority
income tax.
return, you showed 3 partners.
And that is their finding, paragraph 5.1.13, page 107. Income tax you have shown, only income tax. Page 107. We have one to everybody, institute, impaneling authorities, everybody, we have shown 14,
Yes.
5.1.30.
Yes.
Income tax, separate category to avoid tax.
Right.
To save tax or avoid tax.
Both on 1 and 4.
No,
Four.
4 is,
No, 4.
4 is very unique. 4 is I had
To the impaneling authority.
to the impaneling authorities, I had shown more. If you kindly see 109,
109, yes.
that is contrary to charge 1. So, if I have given the impaneling authorities right information and I am guilty of saving tax by showing something wrong to income tax, how can I be guilty of 5.3.1 also? Just the opposite.
One was that either you have misrepresented before institute or the impaneling authority, but 4, it is crystallized and said that no, you gave a false misrepresentation before the institute and impaneling, because
Impaneling.
institute and impaneling authority are on the same.
But then there's no question of saving tax.
But 1 and 4 are apparently contradictory. If it's either of the two, but then it crystallizes and it says that 4 says no, you misrepresented before the institute and the impaneling authority.
But the finding is only impaneling authorities. What you can see, 5.3.1,
Yes.
in view of the finding, the committee was of the opinion that the respondents have filed false predicate with the impaneling authorities, not institute,
2. TWO.
TWO. But then where is it to the institute? And I will show the DCs, DC Barker, DC Barker. If this is so, then 5.1.13 goes.
Hmm.
And this whole thing,
Yes.
unbecoming of a C.
5.1.13 vitiates probably 5.3.1, 3.3. Because if it's either or, then you cannot say that you positively misrepresented before the impaneling authorities. Because anyway,
That is the contradiction.
We found with 2E actually.
And then the unbecoming of a chartered accountant in saving tax. What is unbecoming? Saving tax. That is
saving tax is becoming of a chartered accountant. Chartered accountants are appointed for that.
tax sheet. 2. Tax planning is the
Tax planning.
it on charge
No,
1.
no, তারপর in view the charge code है 2 same saving code করা
Rectify নিজে করেছি, rectify সেটা বলছি না তো।
Yes.
Hugely lacking is the mens rea. Hugely lacking is the finding on that I miss. So it's 5.13 is that I intentionally misled the income tax so as to save tax. And that's unbecoming of a CA.
intentionally filed false particular before the institute.
That I intentionally filed knowing them to be false before the institute. That is, I mean, that fact's also not there. Leave aside the finding. But of course, the finding is very important. After all, you are slurring a professional's career by 3 years, by 3 months suspension is a very serious slur on a professional.
Yes.
And the council could not have said so, because before the council we had placed the income tax assessment revision order. So saving tax had been undone. So intention may have been to save tax, but that was fully undone. Income tax authority did not take any action, but some tax and interest.
Yes.
Lordship, mainly by my judgment will be mainly on this mens rea, but then
Yes, mens rea is exactly
is
what
the
we are
main
thinking
thing. Here, firstly,
about. That has to be there.
there is nothing false.
Knowledge and knowingly,
Knowing to be false.
and it has to be false beyond doubt. I mean, falsity is
Hey.
something.
And the authority as the person who's holding me guilty should give reasons why I'm false. You just can't say you made a false statement, because after all, there has to be.
If there was a scope of interpretation,
Yes.
then it cannot be false as such.
Their scope for interpretation is evident from 5.13, and where you can, if you yourself interpret it one way in one paragraph, interpret it opposite way in the other paragraph.
All right.
এখানে ওরা নিজেরাই ওদের এটাকে বলেছে never subject to scrutiny, নিজেদের ফর্মেই এটা আছে। Part of the 730 type of form. ওরা বলেছে
Just cite the judgments if you want to.
Well, may I come to mens rea straight away?
Yes.
10.9 assisted up.
Now don't look at Mr. Saurabh Mukherjee. Because he will be adding some other
But
point.
this
You look right now.
He is to blame because he made
Absolutely.
me
Yes. He's the main culprit.
liquid text on this one. I've never done. So I'm at a complete loss. I have not used it. So I made a condition. You have to be the next to me.
Yes. He has been. He has kept his word.
Of course, that he always does. If I request him something, and same applies to Mr. all of them. All of them. Mr. John Gupta, Mr.
That's to disarm you.
I'm lucky to have juniors like
Absolutely. Yes.
2010 9 SCC 630. Paragraph 37. First. In view of the above, we have the considered opinion that the use of the expression falsely represents is indicative of the fact that the offense under 10b comes into existence only where a dealer acts deliberately in defiance of law or is guilty of contumacious or dishonest conduct. Ours is a much stronger language. Therefore, therefore, proceedings for levy of penalty under 10a, burden would be on the revenue to prove the existence of circumstances constituting the said offense. Furthermore, it is evident from the heading of section 10a of the Act that for breach of any provision of the Act constituting an offense under section 10 of the Act, ordinary remedy is prosecution, which may entail a sentence of imprisonment and the penalty under 10a of the Act.
You may also rely on say para 35 probably, Mr. Mitra.
The court in cement marketing finally held that it was elementary, that 43 of the State Act, which provided for imposition of penalties, penal in character, unless the filing of an inaccurate return is accompanied by a guilty mind. The section cannot be invoked.
That guilty mind part.
Guilty
Accurate
mind.
return has to be accompanied by a guilty mind.
If at all there was guilty mind, would have been income tax, which I was.
Yes,
If at all, if that was a.
yes.
In light of the language employed in the section and the nature of penalty contemplated, we find it difficult to hold that all types of omissions and commissions in the use of form will be embraced in the expression false representation. In our opinion, therefore, finding of mens rea is a condition precedent for levying.
Yes,
Finding
yes.
of mens rea. I'm on finding of mens rea. One Delhi High Court judgment, very illustrative.
Yes.
Would copy দাও ওদের copy দিয়ে দাও কি নামটা জানো কি নাম হ্যাঁ দিয়ে দিয়েছি Densu Marcus.
0237 2019.
Paragraph 10 first.
Yes.
Questioning the above orders of the appellate authority, the respondent PF authority filed WP so and so before the single judge. The learned single judge in the impugned order noted that the circular of 28 November issued by PF authority inter alia limited the period within which recovery proceedings would be initiated to 3 years prior to show cause notice. And that referring to the decision in Hindustan Times, the learned single judge observed that on the delay aspect alone, the authority could not be maintained. As the issue of mens rea is a determinative factor in the instant proceeding, it was observed that neither the competent authority nor the appellate authority had gone into this vital aspect of mens rea. And even if the communication of 21st April stood excluded from consideration, still the validity of the revised calculation sheet to be determined by the competent authority. Consequently, the learned single judge of the view that the appellate authority, while setting aside the competent authority order, ought to have remanded the matter to the competent for a fresh decision. Now, Lordship kindly comes to paragraph 15.
15 years. Mens rea. No finding on mens rea.
No finding on it. Seriously, I will not.
Essential requirement and
Finding on it.
yes.
And just one judgment on that partnership detail, but do दरकार नहीं, but still देखिए what Lordship allows me on the salaried partner, if they try to argue this case, there can be no part, though there is no finding on that. I cited those before the DC because at that time we are not sure what way they will go. Now there is no finding on there, though there is one finding, but the charge is not upheld on the ground that I have made false statement in showing 14 partners when actually there were 3 partners, because 11 non-salaried salaried partners are not partners. So I should have said 3 in the form 18.
It does not even specify as to whether we are wrong in saying 3 or saying 14. I mean, because if it's a false statement before the tax authorities, it will be stating 3 partners. But under charge 4, it has been held you made a false statement before the impanelling authority. Then 14, the number 14 would be the magic number in a negative sense. So it's not even clear whether you were wrong in saying 3 or 14. It was ambiguous in one
It's
also.
14,
Either
then
this or that. I mean,
14, then income tax I have misled. If it's 3, then you have misled us.
heads you win, tails you lose, sort of. Yes.
That is, I will not unnecessarily extend. Mr. Abdul Mujumdar will be showing those aspects on malafide, how that is the more enjoyable part. That is how these complaints featured before in the affidavits, in the testamentary suit before it was even served on me. We came to know of the complaint from testamentary proceedings, then how the same photocopies went in there, which were part of the complaint.
He will try to justify the assignment before this bench. So we conclude here today in this matter because Mr. Mujumdar has sought first. You will give a composite reply, obviously.
Yes, Father.
You are in, Mr. Mitra, you are in ACA number 5.
Fine.
Both are together, I suppose.
Issue is same. So we have divided amongst ourselves.
They have divided the issues, my lord. They have not divided the matter. They are now dividing the issues.
So I am in Harshvardhan Lok.
And in 6, Avrotosh Majumdar is leading.
Yeah, that's why we'll have to say something that Learned Senior Counsel.
Up together.
But both taken.
Yes, we'll conclude arguments of the
malafide part is there in both,
Not
and
is
this
concluded
legal
because
part
the
is there
malafide is also common in both 5 and 6.
Yeah.
So Mr. What I believe, my lord, Mr. Mitra has submitted for both 5 and 6.
Very well.
He's doing that, but he's
We
He's
don't
getting
want to
his speech
repeat
in
the
time.
argument.
That's
Heard
right.
hearing of the heard Mr. Abhrojit Mitra, comma, the learned senior advocate appearing on behalf of the appellants in both the matters. First up, on the prayer of the appellants, comma, the matter is adjourned for the day and shall be listed for further hearing on July 8, 2025.
8, 9, my lord.
9, sorry.
Grateful, my lord.
9, 2025.
Both of us are not
It's on the left hand side.
Both of us are not here.
On the left-hand
Yes,
side,
yes,
yes.
my lord. But I have broken a rib of the right hand side, so I'm good with that.
Breaking a rib is not for the court, cannot be for the court.
No, no.
You can break ribs for other reasons.
But I
Bole daw,
generally
ki kore
fall
bole
down
daw.
from the bed, my lord, most of the times nowadays. So I fell and
Sir,
broke.
Rai have to do something about that. Yeah.
But we have been ordered a railing for me now.
That is railing is that is the but he has to do something about it.
Really?
Grateful. এই বইগুলো নিন।
পরের লোকের মাথায় হাত পড়বে।
তার সত্ত্বেও কারওয়ান বিলেতে একটা ভঙ্গেন
Quarter Item 4, who is appearing?
Milord, I am there, Milord, but
Yes.
Milord, suddenly, Milord, it collapsed. Milord, I am told, Milord, Mr. Pradeep Datta has come to court. Milord, I mentioned, Milord, at the morning that,
Yes,
Milord,
yes.
he may not come, but I'm told his schedule, Milord, has, Milord, been changed, Milord, he has come to court. If Milord takes up, Milord, in the next, because I don't think, Milord, he will not be able to come now, because he is in, or Milord, or may I start, Milord, or Milord takes up in the next Wednesday, Milord, I leave it to...
If it's uncertain, Mr. Dashgupta, then we'll take it up next Wednesday.
Mr. Datta has come.
Mr.
Mr.
is
Datta has
there.
come.
Yes.
Yes,
So
yes, yes.
we can start.
Yes. Very good.
Thank you, Mr. Datta. Yes.
My lord, today morning it was mentioned by my
So,
lord,
Mr. Dashgupta clarified that you have since arrived and change in schedule or whatever. Mr. Mitra is also there.
No.
Next
He was-
matter.
He was taking chance. If in case,
I'm coming down. I'm coming down. Milord.
He's coming down. So, Mr. Chaudhary,
my lord,
you go up if he comes down.
the next matter.
Yeah, that's why.
My lord, a very short point is involved in the matter. It's a suit for eviction. I am for the defendant.
Acha.
The point was taken in the written statement that I am a thicker tenant.
Shoot for eviction, you are the defendant.
Yes.
Eviction on what ground, Mr. Datta?
Eviction on the ground that reasonable requirement or whatever.
Premises tenant.
Premises tenancy act. And I had taken the point that I am a thicker tenant.
Has to go before the controller then.
Absolutely. Issue was raised. There is a specific provision in the act that civil court does not have any jurisdiction. So, my lord, the learned trial judge, my lord, had proceeded on the basis of a judgment, which judgment was based on the Calcutta Thicker Tenancy Act.
Now it's West Bengal.
That is the only point in
Calcutta Thicker Tenancy did not have an equivalent provision.
No, it was not. It was not.
We have forgotten actually. So, very well. So, have you got copies of those acts?
I have. I will.
West Bengal Thicker Tenancy Act or Calcutta Thicker Tenancy Act হচ্ছে আগে।
And that judgment was not at all, my lord.
Almost similar. So let us see the relevant portion, Mr. Datta. You can.
Yes. Now, before that, my lord, if I can take your
West Bengal Thicker Tenancy Act. এখানে থাকার কথা।
The judgment is from page 60, my lord. Page 60 and
No internal pages are there in the judgment. No.
page 60 of the paper book, my lord.
Oh yes, paper books are there.
Part 1.
Yes, Mr.
Kindly come to page 63. Your lordship will find the issues.
Yes.
Whether the defendant is a Thika tenant in respect of the suit property under the provisions of the Calcutta Thika Tenancy Act 1981. That was the issue.
First issue.
I need not go to the other issues.
Very.
Now, my lord, the learned judge has held this issue at the same page 63, towards the bottom. The first issue is taken up for consideration.
Yes.
An affirmative answer to the first issue and in favor of defendant would not entitle the plaintiffs to any relief in the suit. Mr. Ghosh, learned senior advocate for the defendant, contends that the suit premises is vested with the state of West Bengal under the provisions of the Calcutta Thika and Other Tenancy Lands Act 1981 and the subsequent amendments thereof. He points out that the state of West Bengal has issued a notice dated so under the provisions of the West Bengal Thika Tenancy Acquisition and Regulation Act 2001 in respect of the suit premises being Exhibit 1. The defendant has deposited rent in respect of the suit premises with the Thika Tenancy Controller. He refers to a challan dated 1st February 2020 being Exhibit 2, showing a deposit of rupees 1. In such respect, he also refers to Exhibit 3 being a summons dated 12th May 2012 issued by the Controller of Calcutta Thika Tenancy in miscase number so in respect of the suit premises and submits that the summons was sent both to the plaintiffs as well as the defendant. So, my lord, this was the proceedings pending before that court. Mr. Shah, and senior advocate for the plaintiff, submits the parties never treated the suit property to have vested with the state of West Bengal under the provisions of the Calcutta Thika and Other Tenancy and Lands Act 1981 or the subsequent amendments thereof. He points out that the defendant applied for and obtained extension of deed of lease that was prior to prior period. In fact, in July 1994, the defendant had entered into negotiations for a new lease. He submits that the unilateral deposit of rent with the Thika Controller does not vest the suit property with the state of West Bengal under the provisions of the Calcutta Thika and Other Tenancies and Lands Acquisition and Regulation Act 81 or any statutory amendment thereof. He contends that the plaintiffs are the owners of the land and that the suit property did not vest with the state of West Bengal in any manner whatsoever. He submits that the state of West Bengal did not declare the suit property to have vested with it under the provisions of any act. He relies upon 2011 Volume 3 Calcutta High Court Notes, page so and so, Shobita Rani's case, and submits that the Thika Controller is to decide the right of Thika tenancy. In the instant case, such decision has not been taken by the Thika Controller. That is the contention of the defendant. Next.
Yes.
The claim of vesting of the suit property requires consideration in the light of the evidence on record and the law cited at the bar. There is no document on record declaring the suit property to be a property vested with the state of West Bengal under the Calcutta Thika and Other Tenancies and Lands of the West Bengal Thika Tenancy Acquisition and Regulation Act 2001. Exhibit 1 is a notice under the West Bengal Thika Tenancy Act 2001. Exhibit 3 is a summons dated 2010. But it has been marked as May 12, 2012. It should be 2010. Issued. Neither Exhibit 1 nor Exhibit 3 declare or establish that the suit property is vested with the state of West Bengal under the provisions of the said Act or the Act of 2001. Unilateral deposit of rent by the defendant with the Thika Controller without reference to the plaintiff would not bind the plaintiff to such unilateral act of the defendant. The plaintiff had granted lease to the defendant in 1963 in respect of the suit property where the defendant had carried on the business of a petrol pump. There is no evidence on record to suggest the structures at the suit premises are kacha in nature so as to attract the provisions of vesting under the Thika tenancy laws. The defendant has failed to establish the suit premises stands vested with the state of West Bengal, and the plaintiff cannot claim a decree for eviction of the defendant thereof. In Sobita Rani's case, that is 2011 volume 3, the question before the division bench was whether the Thika controller had the jurisdiction to decide Thika tenancy right of any person who allegedly filed a return under the Calcutta Thika and Other Tenancies Lands Act 1981. Huh? ঠিক আছে. Such question was answered by holding that a proceeding initiated in respect of a return filed under the Act of 81 was saved under subsection 2 of section 27 of the Act of 2001. That was only in respect of the Calcutta Thika tenancy.
Yes.
So, my lord, on this basis, my lord, the learned trial judge said, I have not found any material to come to a finding that the suit property is a Thika tenancy. This is the, my lord, issue number 1 was answered. Now, my lord, if your lordship kindly sees this document, the summons which was issued by the Thika controller for consideration of this claim as to whether it is a Thika land or not Thika land, my lord, that has to be decided by them on the basis of that summons. That summons your lordship will get.
একটা কপি এসছে হ্যাঁ এটা আপনি নিন আমার কাছে ইয়ে রয়েছে এতে আছে
সামান্সটা বার করো না, সামান্সটা বার করো না।
মাঝি পার্ট 2
Exhibit 2, part 2.
থাকা উচিত
Exhibit 2 is the challan, and my lord, Exhibit 3 is the summons dated 12th May 2012. Exhibit 3 to the
index of part 2 does not say which are which exhibits. Should have reflected.
সঙ্গে সঙ্গে দিবি তো ভাই, Exhibit 12 though.
But the
174. My lord, it is 174,
all right.
first volume.
Should have been more, I mean, enumerated which is which exhibit.
My lord,
Should have been enumerated in the paper book which is which exhibit.
absolutely, that should have been.
Now, Mr. Dotto, this is the 174 is exhibit 1.
Exhibit 1, this is a notice from the government of West Bengal,
But that was dated 20th of May 2010.
2010.
Exhibit A1, this is August 1995.
170. Exhibit 3 is 176. This is the summons, 12th May 2010. At page 176.
176
Yes,
of part 2.
part 1. Part 1. Towards the end of that.
Last.
No, not last. Towards the end.
Yes.
Therefore, a hearing has been fixed on 25th June 2010 at about 12:30 p.m. in respect of the above subject premises in the office of the undersigned. So, my lord,
This is exhibit 3.
this is Exhibit 3. This is Exhibit 3. So, my lord, it establishes that a proceeding is pending for determination of this issue, for which the summons was issued, and the date of hearing was fixed on 25th June 2010. However, the hearing had not taken place on that date. It was adjourned from time to time. The fact remains that the proceeding was there. Now, in view of this pendency of the proceedings, my lord, the act, my lord, if you now lordships kindly see the act,
Yes.
বার করো না তোমার তাড়াতাড়ি করে। Which একটা সেকশনটা বার করো। ওই যে যেটা jurisdiction
21.
কেন? Yes, my lord. Section 21. May I hand over a copy of
We have.
bar to jurisdiction? No, my lord has got it. Section 21.
No,
ছাড়বো না রে, 2 মিনিটের জন্য।
yes.
The bar to jurisdiction, no civil court shall have jurisdiction to decide or to deal with any question or to determine any matter which by or under this act is required to be or has been decided or dealt with, or which is to be or has been determined by the controller or the appellate or other authority specified in the provisions of this act, and no order of judgment passed or proceeding, including execution proceedings commenced under the provisions of this act, shall be called in question in any civil suit. So, my lord, specifically, my lord, the civil court does not have any jurisdiction in case of pendency of that matter. And now, my lord, the question whether I am a tika tenant or not, that power is only with that authority to decide, not by the court. But on the in the line of this specific provision under the act, the issue was framed as to whether the court has jurisdiction or the court has held that jurisdiction. The ground of the learned trial judge which has taken that it has not yet been decided. My lord has seen the language. I'm sorry, my lord, my throat is giving some trouble. The court has held that it has not been established that whether I am a tika tenant or not, and it has not yet been decided. So,
5.3 clearly says that the controller has to decide.
yes,
And if it has to be or can be determined, then also that's covered by 21.
absolutely, absolutely.
Who is appearing for the other side?
Mr. Shah, Jishnu Shah is appearing for the other side.
Why is he not there?
তুমি তো প্রসিডিংতে পড়ো দেখো
স্যার অবস্থি অ্যাপিয়ার করছে আমাদের একে অবস্থি
কি অবস্থায়। I
Mr.
can
Chaudhary, if you
notice.
could bring your namesake, the matter would be over and your matter could be taken. Now see, you have not done it and
I request you, I say half of it is the same. The name is the same.
yes. Which is the better half?
This surname is the better one.
It's very clear. Even the first issue could not have been formulated probably. The first issue, I mean, subject to what Mr. Shah says, obviously, probably the first issue should have been whether the suit is maintainable before
It is
this.
maintainable or not.
Because if the first issue is formulated by the court to be whether it's a ticket tenancy, that is covered by 5.3 and barred by 21. Even the first issue.
Absolutely, absolutely. Well, either of the way, the point is as to whether the civil court has jurisdiction with regard to this question to decide.
Mr. Datta, for the sake of completion, would you like to cite the judgment which the learned civil judge relied on?
Learned single judge
Yes.
has relied on a judgment which I had already shown to your lordship. Now, that is Shobita Rani's case.
Yes.
I have got my book. একটা বইতে কি করে সাহেবদের দেবো?
What is the relevant paragraph? I mean,
Yes.
what was held there? Just tell us. You can read out from the. Give us the relevant paragraph, Mr. Datta, and just tell us what is there.
মামলা হচ্ছে বই কই?
এটাই
Mr. Dasgupta is entirely to blame if the book is not.
আবার কোথায় যাচ্ছে? My lord, this is reported in 2011,
Yes,
volume 3, CHN, Calcutta,
534.
534. Paragraph 5, paragraph 4, I am just reading for your lordship. May I
Mr.
read?
Doctor, can you just please hand over the book for
Yes,
5 minutes
yes,
and just
my
take
lord,
your seat? Yes.
my lord.
We'll just give and we'll ask
Very
you.
short judgment, my lord.
Yes, we'll ask you questions after. Tika, hey, এটা ফেরত দিয়ে দাও. Here it has been held that the Tika controller has the power, which he has.
Which yes,
There is no doubt on that. Let us just revisit the first issue framed by the learned single judge.
my lord.
The then first issue, but first issue is, I mean, contrary to that judgment. First issue at page 63 is whether the defendant is a Tika tenant.
That's right. And that
But
cannot
it's contrary to that judgment also.
absolutely is contrary to this judgment.
This is a 1 minute matter. Where is Mr. Shah?
That is why I told you, lordship, it's a very short question is involved, short point is involved.
I beg your lordship's pardon.
Give the answer. Why
But-
shouldn't this be set aside and sent to the Tika controller?
My lord,
Take your breath.
Take-
Take 2 minutes. You will get 2 minutes, and you'll have to finish within the next 3 minutes.
my lord. My lord, at the outset, my lord, may I be permitted to say this, my lord?
Take your breath
Reported
first. Yes,
Led by Mr. Jishnu Shah,
that we know by now.
led by Mr. Senior Avasti. My lord, point remains. The
What
new
is your
act,
defense? What is your defense?
New Act Section 27 says proceedings which were pending will not be governed under the new act. Lord, this is
We are relying on the old act, 2001.
well, Lord, that is what it is. These proceedings were pending and they are kept out of the purview of the new
Sir,
act.
have you got a copy of the act?
Well, Lord, may I be permitted to come?
I have got.
Just come to section 5.3. If you are convinced, we are convinced.
My Lord, I'm led by Mr.
Convince
Shah.
yourself first. No, Mr. Shah will come later.
My Lord, I'm in some personal difficulty, my Lord. In some personal difficulty, both my father and myself, I've come running, my Lord, in some personal difficulty.
Mr. Shah is in court.
My Lord, I could not contact him. Mr. Avasti would have been here. Both of us are in some difficulty, my Lord.
Third learned senior counsel appearing for the appellant. Full stop. At this juncture, an adjournment is sought on behalf of the respondent. Full stop. Let the matter be listed for further hearing on July 8, 2025.
My Lord, I'm so grateful, my Lord. So grateful, my Lord. July 8, my Lord, will come.
July 9, July 9.
July 9, my Lord.
Yes,
July, my Lord.
July 9th. Yeah. এটা একটু রেখে দিও এর সঙ্গে।
আর হবে না, just উঠবে।
ওটা
No,
ভুল, এদিকে
Judicial time is
এদিকে
over.
দেখো,
Judicial time is over.
আমি দেখো 3 মিনিট
No,
আছে,
no, no, no.
Judicial time is
Two
over.
minutes are left.
3 মিনিটস আর লেফট, ওটা ফাস্ট ঘড়িটা।
এটাতেই চলে যাবে। কল করো, কল করো। কোর্টে কল। Yes, what is the matter?
Milord, the appeal,
Yes, the appeal.
the appeal, Milord,
Part one.
arises out of addition of, Milord, 5 subsidiaries of the defendant number 79 in a suit for partition. Partition between members of a particular family, Milord.
You oppose the addition.
Yes, I am
You're the
opposing.
defendant.
Yes, my lord, I am the added, my lord, 5 subsidiaries of the different number
So
79.
you're opposing your own addition.
Yes.
What was the premise of the addition?
That I am an alienee of a property which belongs to the joint family.
What is the ground for opposing that?
2 grounds. Number, admitted that I am an alienee.
May I? I'm sorry to
Yes.
interrupt, Bali.
Yes.
From the same order, it was another appeal was preferred, which was disposed of by your lordships by sending it back before the court below, my lord, on 11th of June. In their presence. I mean,
It from refusal to grant interim order.
Oh, this is against an injunction order.
No,
But this is different.
they wanted,
That was
no,
an-
no, no. They wanted
Same.
2 things. They wanted addition, they wanted injunction. Injunction was refused, addition was granted.
No, this is on a different footing, Mr. Vittu. This was the ad interim stage, it was sent down.
it's a composite order. That's
No, but
what-
this is a different issue altogether. We'll take this up.
The scope of the appeal would be different.
You are an alienee, but what is your... Yes, scope is different. We are...
Property of the different number 79 mentioned, my lord, in the plaint is, my lord, different number 79 is a company. My lord, a family cannot be the owner of a property belonging to a company. So, my lord, this is absolutely without jurisdiction.
Who sold to you? Who transferred to you?
Different number 79.
The company itself?
Company itself transferred to me.
So we don't understand your question. You are also an individual.
No, I am also a company. I am the subsidiary of the different number 79.
So it transferred to you. So you are a necessary party. Why not?
No, the point is, my lord, that the defendant number 79 is a company.
Right.
My lord, this property, my lord, belong to the company.
Is the asset of the company.
Asset of the company.
Company
Asset-
transferred to you.
Yes, company transferred to me. In a partition suit pertaining to some of the shareholders, this company cannot be, my lord, made this property cannot be made the subject matter on the principle that shareholders are not, my lord, owners of properties of the company.
No, the other parties were shareholders.
My lord, I'll come back on the next day and explain.
But if the company is a joint owner, it's a
Company
jurisdiction.
79 is the sole owner of the property. Different number 79 is the sole owner of the property. I am, my lord, a subsidiary of the defendant number 79. The property has been transferred to me. Now, some of the shareholders of the defendant number 79 say that this is a family company and therefore we members of the family and also shareholders are owner of that
As
property.
per the frame of the suit, Mr. Chaudhary, you are a necessary party. As per the frame of the suit, because the question which you now raise is the issue involved in the suit itself.
Yes, raised by the defendant number 79,
Right.
not
Right.
considered, raised by me in an application, not considered, but I am added.
No, you have to be added because Mr. Chaudhary, whatever relief is sought against 79, that has come to you now. So therefore, you are a necessary party. It will be open for you to take that point, but that will be decided in the suit itself at the Order 1 Rule 10 stage, if you decide that issue. But that will hit the merit of the suit.
Yes,
Order 1 Rule 10 is decided by the frame of the suit, right? Whatever is the frame of the suit. Maintainability point is one of the points that it
Yes.
may not be maintainable. Definitely, we keep that open. But you are definitely a necessary party because of the frame of the suit. If the relief sought is against the company and it has transferred to you, you are now in the shoes of the company and you can take all the points taken
but
by the
Milord, if I am
Order 1
added
Rule 10 is all
today,
right. Yes.
if I am added today, subsequently when I come back and say delete me because there's no cause of action disclosed against me.
Whatever fate would befall the company 79 would befall you also. The outcome would affect equally.
But I want to raise this point and have it decided. For which, Milord, I
At the
believe.
Order 1 Rule 10 stage, you cannot. Because Order 1 Rule 10 is only on whether you are a necessary party.
Yes,
Your necessity as a party would be decided by the frame of the suit.
frame of the suit.
As per the reliefs claimed in the suit, whether you are a proper or necessary.
Absolutely.
So now, as per the relief claimed in the suit, the relief is partition against the company.
Acquisition of the property of the company.
Property. Oh, achha.
That's the
But
Milord, on the next day I'll come and
Very well.
indicate.
Well,
Well, a question of maintainability of the appeal also.
Order 1 Rule 10 added, not a judgment. At the outset,
No,
an objection as to maintainability of the appeal is raised by learned senior counsel appearing for the which respondent?
But not on that point.
Which respondent?
One.
One.
Plaintiff respondent number 1.
Yes, yes,
For the
yes.
plaintiff respondent number 1. Full stop. However, comma, since the hearing cannot be concluded today, comma, let the matter stand adjourned till July 9, 2025. Yes.
My lord, may I have my lord's leave to, my lord, move an appeal urgently tomorrow, my lord. This is a refusal of an ad interim order, my lord. 24 June is the impugned order. We've applied for
Yes, leave is
settlement copy.
granted.
My lord, may we come back tomorrow? And it's a refusal of an ad interim, my lord. I wish to move this
File
ex
it and
parte.
give the number to our officer.
Yes, my lord, but then leave to file without certified copy. I've applied
Yes,
for it on
leave is
25th.
granted.
Oblige, my lord.
After you file it, give the number to our officer. এটা যদি ফাইল আনতে পারেন তাহলে কালকে order
Oblige.
On order 41.
Yes.
My lord, for inclusion underwriting application.
Yes. আচ্ছা কালকে তো অ্যাপিলের ডেট। Yes.
My lord, I beg to mention two application, one under section.
Application, yes.
Much obliged.
I'm waiting.
No, yes.
Stay application, my lord.
Application.
Order 40.
Yes, Your Honor. We are permitted to mention
Yes.
which there is an unavoidable, inevitable
Can't
circumstance.
hear you, please use the mic.
Your Lordship, some unavoidable circumstances are there. I am not able to compliance the order dated 21 April of 2020.
What was the order?
The order was extension of the interim order and Your Lordship requisite postal fees and cost of service of postal notice of appeal.
Now you have put in.
Your Lordship, on the you paper books have to be filed within the after 8 weeks thereafter.
So you're not prepared with the paper books?
You know, no, Lordship.
Appearance to be mentioned. Hand over the slip, right to be mentioned, and handovers.
Lordship, I'm mentioning for inclusion in the list, Lordship.
What?
This is a matrimonial dispute, Lordship.
Application or order? What?
Appeal, Lordship, appeal.
Appeal, no, not right now. Yes.
My lord, kind leave of Justice Kumar, my lord, kindly don't take me amiss for bothering a lordship for a single bench matter.
Yes.
My lord, on 23rd November 2023, my lord and my lord had passed an while my lord was taking up Group 9 matters, had passed an injunction on the railways that not to act on the show cause notice. My lord, that order was confirmed by lordship in January 2024. Now, my lord, that writ is pending, affidavits are complete. Suddenly, my lord, yesterday we received a notice, my lord, banning all businesses on the basis of same show cause notice.
File a contempt.
My lord, I filed, my lord, this, my lord, I am told, my lord, list of, my lord, Thursday, Fridays usually being prepared in advance until a leave.
You have filed a contempt.
My lord, leave is granted to be by your office so that they can include it in the list. My lord, already served on Delhi. My lord, my client.
Contempt application has been filed.
My lord, leave has to be granted so that it can appear on 4th because usually, my lord, the list are prepared, my lord, in advance. It, my lord, my entire project is being jeopardized.
Without getting a number, how can you give that leave?
My lord, gives the leave to be listed, will get it filed and
Very
the number
good.
will
Leave
be
is granted. Kalke.
Very good. I mean, I have already served on the contempt.
You want to mention something?
No, my lord, we are
together. বলুন আপনার উকিল বাবু কি এখনো আছেন না নো অবজেকশন নিয়েছেন? যদি নো অবজেকশন না পাওয়া যায় কি ম্যাটার এটা?
ম্যাটার হচ্ছে আমার
কি স্টেজে আছে এটা? অ্যাপ্লিকেশন?
এই বন্টন নামার যে অ্যানেক্সটা হয়েছে আপনি
দেখি দাও দিন। আপনার উকিল বাবুকে আপনি নিয়ে আসুন এখন, যখনই আনবেন যে ম্যাটার চলছে সেটা হয়ে গেলে মেনশন করবেন। উকিল বাবুকে বলুন কোর্ট একবার ডেকেছে ওনাকে। আপনার উকিল বাবু কে আছেন?
8 ভলিউম আছে
পুরোটাই
দিচ্ছি।
ইরশাদ মেট্রো তো অ্যাডভোকেট আরফিন বেগমকে আপনি বলুন যে কোর্ট ডেকেছে একবার, ওনাকে নিয়ে একবার আসুন। যখনই আপনারা আসবেন যে ম্যাটার চলছে সেটা শেষ হওয়ার পর আপনাদেরটা শুনুন।
May it be included on 4th list, my lord.
Yes. But when you file, give the number to our office.
Yes. I have already served. My lord, today my client has gone to Delhi.
Number.
I'll give the number. Oblige.
Call on the list.
Item number 1, my lord, lordship might recall that matter yesterday, my lord, I firstly submitted that's a preliminary decree which was challenged in appeal.
Yes.
There was some confusion. That's why.
Right.
And my lord, I have served, my lord, my other side, the appellant, so that they can clarify. My lord, I have even now some doubts. Kindly have a look at
What do you want now, Mr. Dev?
My lord, basically, I want, my lord, the dismissal because what they have challenged, my lord, is the final decree that would be evident from the memorandum of appeal. This is what I find. But when the matter was, my lord, interim application was filed for stay, submission was possibly made on behalf of the appellant that they have challenged the preliminary decree.
What order was passed by us?
My lordship, my lord, did not entertain because kindly comes to the order dated order, my lord,
November.
page 58 of the paper book. Lordship did not grant any stay because final decree passed and execution, my lord, already been complied with. Kindly have a look at this.
Yes, we were given the impression, Mr. Chattopadhyay, that you have challenged the preliminary degree, but you have challenged the final degree.
Kindly come to the memorandum. I was also confused, my lord.
Yes, that was the impression given to
Yes,
us.
absolutely. I also submitted that. Now kindly come to the memorandum of appeal. But I thought, Milord, I should point out, Milord. Grounds of appeal, everything, Milord. Now kindly come to page 53. I'm sorry, Milord, for troubling your lordship.
Memorandum of appeal.
Page 53 of the paper book.
Paper books have been prepared.
Yes, all.
Paper books are not with us.
Not with your lordship, Milord.
पेपर बुक तो है
They have served me, Milord. Kindly seize, Milord, the memorandum of appeal, what they have challenged. I can give your lordship, Milord, my copy, if my lord's permit. Akbar Devan, if lordship permits, Milord, then my lords can have a look at
the
this.
appellant shall prepare
That's why, Milord, I subsequently said possibly.
the requisite number of paper books within 8 weeks from the date of service of notice of arrival of
Kindly
In the memo, they have written preliminary decree.
No, first, Milord, agreed by 6th October
6th October, arising out
Yes.
of the judgment preliminary decree. They have stated.
challenge.
See the memo.
final
দেখান একবার না। They have written preliminary degree.
Milord, I'm sorry, Milord. Being agreed by and thoroughly decided with the judgment and decree dated 6th October. That is the final decree, Milord. My understanding, Milord. Then they refer to the preliminary decree and grounds of appeal all relates to the final decree. In any event, Milord, now the execution is complete. In their presence, Milord, they have got the materials in a partition suit. So
Yes,
nothing
you have
remains.
filed in the memo. You have stated preliminary degree. You have challenged the final degree.
In this, that's why, Milord,
yes, Milord. But,
in fact, nothing remains, Milord.
Final hearing.
So why nothing remains?
I tell you, Lordship. Just have a look at this.
Final degree, they have a right to challenge.
No.
They may be agreed with the allocation of shares.
Yes, Milord.
They have a right.
They can.
After passing of the final degree, maybe there would be some doubt if they could prefer. That
Milord,
was a ground for refusal.
Milord, 2018 is the final decree.
Yes.
Saying for a moment they can't.
Huh.
Now, in the execution, they have accepted their share. That is what would be evident from the order. That's what I want to point out. If my learned friend wants to proceed, even thereafter, I have nothing to say. Kindly have a look at one order, Milord. Lordship has referred
No,
to.
the appeal was filed. Was there a section 5 filed along with it?
Milord,
Yes, Milord.
I don't know.
It was allowed.
Allowed.
When?
Subject to cost of 5,000.
Allowed to copy.
I was not there, Milord, so I would not be able to tell you, Lordship.
When was it allowed, Mr. Chaturvedi?
Yes. Right.
Appeal and application were directed to be fixed together.
And kindly, Milord, if Lordship
Yes,
considers.
condonation was done.
Yes. Just have a look.
What is the scope of the appeal? What is your ground of challenge?
Milord, the ground of challenge, Milord, that the final degree was made.
He is dictating to you the grounds of challenge.
Yes, Milord.
Your client is dictating. He is your client or clerk?
Clerk.
Clerk is telling you what are the grounds. We had to see this day also, Mr. Chaturvedi.
Suffering from Milord fever only.
You are persistently suffering from fever. That's a perennial event, Mr. Chaturvedi. We know. But what is the ground of your appeal?
Ground of the appeal, Milord.
Take the microphone a bit closer. What is the ground of challenge?
I am challenging that appeal, Milord, due to the
in the memo, you have stated preliminary degree. You gave us the impression while moving the stay application, we didn't even look into. We looked at the memo, but the preamble says preliminary degree. It's a final degree.
Final degree.
So, what is the ground for challenge? On what ground are you challenging?
Challenging is, Milord, that the portion of the land is myself. 5 brothers, 1 feet, 2 feet, 2 feet.
Preliminary degree cannot be reopened. Shares have been declared. Partition commissioner's report filed.
No
what is your challenge to the commissioner's report?
Commissioner's report without any notice, without any signature, that is done. That illegality was done.
Paper books are prepared.
They have served me, Milord.
You have filed the paper books?
Milord, I have not. They have filed in a
Very well.
Served with a copy of the paper book.
Since the appeal is otherwise ready for hearing, let the same be listed under the appropriate heading tomorrow.
No, tomorrow will only
It will appear in the list tomorrow. It will be in its own place, not as a specially fixed matter.
Only one thing, Milord, Lordship should kindly permit me, Milord, to bring all the orders of the execution
All the
orders of the execution proceeding.
if you have got certified copies, you bring extra copies and bring
Yes,
this.
we have the copies, Lordship.
Yes.
Grateful, my lord.
Give advance copies to Mr. Chakraborty if you can.
Lord, the orders
No,
we
not in court. You can do that.
They have also obtained the very well. I'm giving, my lord, the copies of all the orders of the execution.
Yes,
which are
Mr.
not part of
Chakraborty. Yes. Next matter.
And, my lord, grateful, my lord.
Thank you. What is the correction, sir?
My lord, I have prepared, my lord, two copies of the judgment, my lord. My lord, we have, my lord, made certain corrections, my lord, in the judgment, my lord, with pencil.
Give a copy to him also, so that he.
Copy chahiye
My lord, others, how will he know what corrections you say?
As way back as on 7th of May, my lord, I had sought from my learned friends, advocate on record, my lord, as to what is the correction. Till date, my lord, they have not bothered to inform me.
This is
In fact, my lord, this matter was mentioned and
improper,
lordship directed them to inform me, my lord. Till date,
No,
they have not.
correction, they have a right to know.
We have, my lord, my instruction is that.
Let my learned friend show as to how they've informed.
We find one correction at page 17. What are the other corrections?
There are other corrections, my lord. Page 3, my lord.
Page?
Page 3, my lord. It starts from page 3.
Now give a copy at least to him.
I don't have a copy. I can give a copy, my lord. I can indicate immediately right now. Without me,
It will appear tomorrow under the heading, same heading to be mentioned. Learned counsel for the, you are for the respondents. You are for the
I'm
respondents.
for the respondent of one plaintiff, my lord. Yes.
Learned counsel for the respondent number 1 seeks certain corrections to the judgment dated May 1, 2025. Full stop. A copy of the copies of the proposed corrections are handed over in are filed in court. Full stop. Let copies thereof be circulated to the
My lord,
as a copies thereof are circulated to learned counsel for the appellant here and now. Mr. Jain, you can go through the. What are the page numbers? Give the page numbers.
Yes, my lord. Page number 3, my lord, it starts.
Give us the page
Before that, my
numbers.
lord, I just
3.
need to
Page number 3.
Sorry, my lord, lordship will kindly pardon me, my lord. I just need to inform it to your lordship, my lord. I have already collected the certified copy of the order, my lord, and that certified copy of the order, my lord, to the as per the instruction, my lord, has been sent to Delhi, my lord.
Maybe.
Preferring
3 and
especially petition.
My lord, page number 3, my lord. Page number 4. Page number 7.
3, 4, 7. Give the numbers.
17, 24, 20, 23. I'm sorry for my jumbling it up. 20, 23, and 24.
3, 4, 7, 17, 20, 23, 24.
20, 23, 24. 21, 21.
70.
21 কিছু নেই 21 পেজ নাম্বার দিচ্ছি আমি প্যারাগ্রাফ দিচ্ছি না
যা বলেছি সেই পর্যন্ত let the matter be listed tomorrow under the same heading. Mr. Jain, go through the corrections. If you have any objection, take it tomorrow.
Pardon me, my lord.
Tomorrow under the same headings.
3, 4, 7.
বলে দিচ্ছি সব বলে দিচ্ছি
এগুলোতেই থাকবে। Next.
আমি
না একটা বলেছে since birth. Page 17 ওইটা দেখতে হবে।
I'm filing affidavit of permission. This application extension of interim order, my lord, passed on 9 January and thereafter, my lord, extended on 26th February 2025, my lord. Interim order was up to 30th June 2025, my lord. Application is filed within time, my lord.
Mr. Gupta, what is the nature of the extension of the stay?
The stay is, my lord, it was the decree had been stayed, my lord, till 30th was exempted.
What is the decree in the nature of?
Decree was, my lord, it was passed on the application under order 6 rule 12, my lord. No, sorry, order 12 rule 6, my lord. That was passed ex parte, my lord, without serving the copy upon the appellant, my lord.
What is the stage of the appeal? You are appealing for, you are the only respondent?
Yes,
ma'am.
No, two respondents. You are appealing for both of the respondents.
Yes,
What it happens on 9th January 2025, while your lordships passed the order on Can 2 of 2024, your lordships denied to pass any occupational charge. Since this is a judgment on admission, this application along with appeal, I have to dispose it of. Now, 8th April 2024, lower court passed the judgment and decree. From February 2011 to till date, not a single farthing they have been paid. And flat has been locked and they have left from September 2024. Lock and key, and they have left the flat from September 2024. That's why I have filed one application with Can 6 for some occupational charges, Can 5, which is pending.
We'll extend the interim order, we'll direct the application along with the appeal to appear under the heading application. We had already expressed our opinion that in view of the short conspectus of the appeal, the appeal can be taken up along with the application. Full stop. Next para. We take the affidavit of service filed today be kept on record. Full stop. Let the appeal along with the application be listed under the heading application on July 7, 2025.
My lord, kindly.
July 8, 2025.
No, my lord. Kindly. But after 14, my lord. Because
Why?
I will be out of station, my lord.
Very well. July 15, 2025.
My lord.
Full stop. The interim order granted earlier is extended till July 31, 2025 or until further order, whichever is earlier. Can 6 of 2025 is disposed of accordingly.
Obliged.
The paper books have already been filed.
Yes, we'll take along with lock, stock, barrel, we'll just dispose of. It will appear on 15th of July under the heading application, along with the appeal.
But item number 4, my lord, I appear for the appellant, my lord. Appeal is against the preliminary decree, my lord. There's an application for stay, my lord. Can 2 of 2018, my lord.
You're enjoying an ad interim order?
No. This is the
First time.
But only, my lord, the defendant respondent number 1 needs to be served, my lord. She is the plaintiff, my lord. But unusual interim order, my lord.
Yes, we are directing the continuation of this suit. Preliminary degree will not be passed without a leave. And you are appealing for which of the respondent? 1.
Respondent number 2 ABC series.
2 ABC. 2 ABC. Substitution has been effected. Memo has been corrected, Mr. When the matter is taken up for hearing, comma. No, we are directed you to serve copy of the stay application.
Stay application.
You had served.
No, my lord. Stay application was not moved.
For the first time.
First time.
Yes, one thing.
One thing I am concerned with, my lord, is the early disposal of the matter, my lord. What happened?
Early disposal, unless the other respondents are served, we cannot. Particularly the plaintiff.
Plaintiff, he needs to
and
be served,
the
my lord.
partition suit, all have to serve.
Yes, my
You
lord.
are for 3 series, you said on the last
2
of it.
series.
No, my lord, that was a mistake.
Mistake.
My
Acha.
lord. I am for 2 series. Sri
Uh,
Prabhat Kumar Das died and I am his legal heirs.
Very well.
Minoti Das, Kollol Das and Kaushik Das. I am
Although the respondent number 2 series is represented today, comma, the other respondents have not yet been served, comma, since there was no prior direction of service. Full stop. The appeal arises out of a preliminary degree of partition. Full stop. Upon hearing learned counsel present today, comma, we direct the learned trial judge to continue with the final degree proceedings, semicolon, however, comma, no final degree shall be drawn up without prior leave of this court till disposal of the application. Full stop. The application shall serve the petitioner shall serve copies of the application on all the unserved respondents. Now, on all the respondents, barring respondent number 2 series, indicating that the application shall be listed for hearing on July 15, 2025, when an affidavit of service to that effect shall be filed by the appellant. Full stop. Next, acha, এই সবকিছুর গোড়াতে একটা করে দাও. We noticed from the order dated June 30, 2025 that we had recorded that Mr. Kajol Rai along with Mr. Shumon Nundi had appeared for respondent number 3 series. Full stop. However, comma, since it is pointed out that they are appearing for the respondent number 2 series, comma, let the order dated June 30, 2025 be deemed to read respondent number 3 series double inverted মধ্যে, comma, wherever it is appearing in the said order, comma, as respondent number 2 series.
Or we have filed a supplementary affidavit, my lord, that also needs to be
আচ্ছা,
served.
যেখানে বললাম shall serve copies of the along
Application
with along with copy of the supplementary affidavit. আর একদম প্রথমে করে দাও, leave is granted to the appellant to file a supplementary affidavit which is filed today and kept on record.
Wait,
হয়ে যাওয়ার পরে বলছেন ওরা চলে গেছে এখন।
Lord, five, Lord, may I come back next week, Lord?
Why?
There are two, Lord, exhibited document, Lord, which I do not have, Lord, that may be relevant, Lord. I have sought, Lord, for
Second appeal. Why before us? This is a second appeal.
41.
Restoration application.
One is a restoration application, one is substitution.
So restoration substitution, what is, you can move those.
Can 2, Lord, is restoration. Lord, can 1.
Restoration within restoration, no, substitution we have to take
No, can 1, Lord, is a application for taking note of the death of Haradun Haldar being the appellant number 1.
You're allowing that first?
Yes.
Heirs are on record.
Yes.
Can 1 of 2022 is an application for recording the demise of the original appellant number 1, namely late Haradhan Haldar. Next para, it is pointed out and pleaded in the application that his sole heirs and legal representatives are already on record, comma, as enumerated in paragraph number 2 of the application. Next para, since the application is otherwise in form, comma, can 1 of 2022 is allowed, comma, thereby recording the death of the appellant number 1, Haradhan Haldar, and granting leave to the learned advocate on record for the appellant to carry out the necessary correction, deleting the name of the appellant number 1 from the cause title of the memorandum of appeal and renumbering the other appellants accordingly. Mr. Bhattacharya, you have to renumber. One starts from 2.
Serially.
Yes. No orders to cost.
Can 2
can 2 filed in time?
Huge delay.
What is the delay?
Milord, just before Milord lockdown, Milord, it was dismissed. Milord, no, and Milord, I should not, Milord, level allegation against the court, Milord.
Use the microphone, Mr.
Milord, I could not, Milord, level any allegation against the court, Milord. This bench could not have, Milord, taken up the matter at all. This was filed from the Cheresta of Milord.
You are deliberately.
Milord, I have taken the blame upon me, Milord. And in the meantime, the Haradhan Haldar had although Milord expired, Milord, he was in touch with the Milord advocate on record.
Have you seen the bench?
That's why, Milord, I'm saying, Milord.
The name of the bench also. Serve copies and come back.
Before admission.
Before admission, but beyond time.
Much 58 days. One.
How much?
15.
No, serve copy. Although the appeal is yet to be admitted, comma, since the application for restoration bearing can 2 of 2024 is much beyond time, comma, for the ends of justice, comma, the appellants shall serve a copy of the application on the respondent, indicating that the application shall be listed under the same heading on July 15, 2025, when an affidavit of service to that effect shall be filed. If the appeal is admitted, you save costs for postal requisite.
Just before Milord lockdown, this was done, and now Milord, the sole appellant expired. Nobody.
We did not know that the learned second judge sat with him. So if you knew that, then we'd be cautious of. Yes.
Just Milord after elevation, immediately after elevation.
Therefore, you have to suffer. Yes.
My lord, I am for the appellant, my lord.
Yes.
This is a appeal from the probate proceeding, my lord. My lord, in the
probate allowed or dismissed?
Dismissed, my lord.
Your probate application dismissed. Yes. On what ground? Could not prove the will.
My lord, in that, my lord, situation, the executor died. That's why, my lord, the can 6 has been filed, my lord, for application for conversion of the probate proceeding into the letter of administration. And another, the can number 5, that is for the appointment of administrator, my lord.
What is the ground in the appeal? Administrative penalty, you have to make out a very high case.
My lord.
Why should administrator be appointed?
My lord, at present.
Have you got a copy of both the applications?
Memo of appeal not received.
No, applications you have got. Administrator, you agree to that?
No, my lord. The administrative, my lord, there is a two brothers.
No,
and
they
four
will come to
sisters.
you. If you don't agree, then yes. What is the ground? Why should we appoint a? Why,
But-
first of all, why was the probate proceeding dismissed?
My lord, there is, my lord, some discrepancy in the witness. They have five. They have, my lord, there is
Between the evidences of the attesting witness, one attesting witness.
no one. There is the attesting witness. They have some, my lord, said that in his presence, my lord.
What was the discrepancy according to the court?
My lord, that is, my lord.
You are not even prepared on the grounds of the appeal, and you have come to move an administrative penalty application.
My lord, at present, my lord, as the executor died, my lord. That's why, my lord, until and unless the application has been converted into the,
Can 6 is that application?
my lord, the late conversion of letter
Mr.
of.
Mr. Chakrabarty, we are allowing Can 6 and it has to be done.
My lord, problem is that, my lord, kindly see, my lord, appeal, my probate dismissed. No full level that they are, who are the legal heirs. There are the four sisters, two brothers. So kindly see the order dated 26th September.
No, Can 6 is for conversion of into letters of administration. If the executor is no longer alive, that is the only
In
procedure.
the content application file, knowing full level interim order not to transfer the property, the two brothers.
Chakrabarty, you should know by now this is a matter of course.
In this matter, my lord, they submitted before this court, they not pressed the appeal.
No. Then I never
Kindly
said,
see
my
the
lord.
26th September 2022.
No, my lord, I have never said.
And court also, my lord, opined that we are very happy when the amicable settlement.
No,
And
no,
will you kindly note
that process was, my lord, but my lord, the settlement process has been failed.
Yes.
We are
My
not
lord,
failed.
kindly see the order, my lord.
Both the parties.
I
agree,
never
we
said, my
agree,
lord, that has
till
been
today.
resolved.
That is a
Unnecessary.
What is the date of that order?
26th September 2022.
My lord, 16/11/2022, my lord. The contempt application has been dropped.
No.
16 November.
There was a chance of settlement. If settlement failed, what happens?
No, my lord, I don't know, my lord, but they
My lord,
submitted
this is 16
when the content
November.
application court, my lord, asked
No,
for the
I
jail
have never
because
said.
during interim order they transferred the property to the third party. That's why
This is entirely irrelevant for the purpose of Can 6. Can 6 of 2029 of 2019 is an application for conversion of the proceeding to a proceeding for letters of administration in view of the demise of the sole executor. Push up next para. We find from the records and the averments made in the application that since the executor has died, comma, let this appeal be deemed to be an appeal from a proceeding for grant of letters of administration. Full stop. Can 6 of 2019 is allowed in terms of the above observations without any orders to cost. Full stop. Next para. Learned counsel for the respondent submits that the appellant had gave out before the court on September 26, 2022 that they do not want to proceed with the appeal. Full stop, such contention is disputed by learned counsel for the appellant. Full stop, we find from the order dated September 26, 2022 that the submission of learned counsel for the respondent is incorrect. Full stop, in the said order, comma, it was recorded that as requested by learned advocates for the parties, comma, the matter be listed again on November 15, 2022. Full stop, the court expressed sincere hope that the petitioners and the alleged contemners, who are the only legal heirs of late Haradhan, comma, would resolve the dispute amicably. Full stop. As such, comma, there was no concession on the part of the appellant at that juncture not to proceed with the appeal, but only the possibility of amicable settlement was being explored. Full stop. Since learned counsel for the appellant submits that the settlement could not be arrived at, comma, there is no question of dismissing the appeal at this juncture. Full stop. Next para. When we take up Can 5 of 2019 for hearing, comma, we find that the same is an application for appointment of administrator pendentity. Full stop. Next para. Since the same is opposed by learned counsel for the respondents, comma, the respondents are directed to file their affidavit in opposition to the said application within a fortnight, Mr. Chakrabarty. Within a fortnight from date, reply if any shall be filed within a week thereafter. The application shall be listed along with the other pending applications on July 29, 2025. Yes. If you prepare yourself, Mr. Lahir, in the meantime.
My lord, on behalf of the my lord 1, 3 and 4, my lord 2 on behalf of not 2 my
For
lord.
respondent numbers যেটা বললাম, তন্ময়,
There is a 4 respondent
give a slip. ওই স্লিপটা দেখে তুমি লিখে দিও respondent number such and such. Very well, Mr.
who not appearing, my lord.
Yes, you have brought your advocate.
Yes, my lord. I've been
What is the matter? She's coming every day and disturbing us.
zero intimation that she would be mentioning before.
We
your
thought
lordship.
so. We thought so. That's why we asked her to bring you.
I spoke to Mr. Rishad Methora. He's leading me in this matter. Even he had zero intimation. He said that he has spoken to her the day before yesterday for half an hour. He had zero idea that if she
Yes, আপনি নিজে নিজে আসছেন কেন? আপনার অ্যাডভোকেট রয়েছে।
matter herself, I told.
আমরা নিচ্ছি না কোনো মেনশনিং ইনক্লুশন করছি না। Is it a hearing matter?
Admission of appeal, your lordship.
Write on a slip of paper. We'll put it on the list. You have got your payments.
My lord, we have appointed, we have filed a supplementary affidavit because she had filed a stay application. We had filed a supplementary affidavit, we have served. Now I was awaiting instruction from my senior when we will be mentioning the matter so that it can be heard out.
She's coming every alternate day and
She did not inform us.
Obviously, that's why you asked. আপনি নিজে আসবেন না, কোর্টে আসতে পারেন, কিন্তু আপনার লয়ার রয়েছে। আমরা কিন্তু ভবিষ্যতে আপনাকে আর
জমি জমাগুলো বিক্রি করে দিচ্ছি।
আমরা ভবিষ্যতে আপনাকে আর এন্টারটেইন করব না। আপনি পরিষ্কার বুঝে নিন, যদি অ্যাডভোকেট দিয়ে অ্যাপিয়ার করেন, অ্যাডভোকেট দিয়ে অ্যাপিয়ার করবেন, নিজেরাও আসবেন, সেটা হবে না। হয় আপনি অ্যাডভোকেটদের থেকে নো অবজেকশন নিয়ে নিজে অ্যাপিয়ার করুন, নয় অ্যাডভোকেটদের দিয়ে অ্যাপিয়ার করুন। রোজ সকালে এসে আপনি দাঁড়িয়ে থাকেন, আমাদের তো খারাপ লাগে। আপনি কি ভাবেন যে আপনি নিজে এলে আপনি বেশি বেনিফিট পাবেন?
না, সেটা কেন হবে?
তাহলে অ্যাডভোকেট দিয়ে কেন আপনি নিজে আসেন রোজ? আপনার অ্যাডভোকেটদের আপনি বলেননি?
মাইলট, আপনি বুঝতে পারছেন না
আমরা ফুল বুঝতে পেরেছি আপনি কি বলতে চাইছেন। আপনার ম্যাটারে মেরিটে আমরা ঢুকবো না যতক্ষণ না ম্যাটার লিস্টে থাকছে। আপনি বুঝে নিন, এটা প্লেগ্রাউন্ড নয়। আপনি এসে বলবেন আমাকে অন্যায় করা হচ্ছে আর আমরা সেটা মেনে নেবো। আপনার আদার সাইডকে না শুনে কেন মানবো? আপনি একতরফা মামলা করতে চাইছেন, আপনার অপরপক্ষকেও তো শুনতে হবে আমাদের। যদি আমরা অ্যাপিলটা অ্যাডমিট করি অল, আপনার অ্যাপিল যদি আমরা মনে করি ডিসমিস করে দেবো, তাহলে কেন আদার সাইডকে শুনবো? শুনবোই না। আপনি বুঝতে পেরেছেন? হ্যাঁ, আপনি আর নিজে আসবেন না। যদি অ্যাডভোকেট দিয়ে অ্যাপিয়ার করেন, দুটোর মধ্যে একটা চুজ করুন, হয় অ্যাডভোকেট দিয়ে অ্যাপিয়ার করেন, নন নিজে অ্যাপিয়ার করুন। যদি নিজে অ্যাপিয়ার করেন, নো অবজেকশন নিয়ে, অ্যাডভোকেটকে কোনো ইনস্ট্রাকশন দেননি, আপনি নিজে চলে আসছেন, ওদের এম্বারাস করছেন। আমরা যেন ফার্দার আর এটা না দেখি। আপনি নিজে যদি আসতে চান, তাহলে আপনাকে নো অবজেকশন নিয়ে অ্যাডভোকেটের থেকে ওদের ফুল পেমেন্ট করে আপনি নিজে এসে অ্যাপিয়ার করবেন।
High Court Legal Services Committee.
Legal services matter. Then, ma'am, you should be more cautious. You should be more cautious.
My lord.
Hand over a slip, we'll let the matter be listed today.
My lord,
right now, just give the details before the court rises. Give the details to our officer. It will. আপনার matter appear করবে লিস্টে সোমবার. Give the details.
Yes, sir.
Legal aid matter, you should be more cautious, ma'am.
My lord, we have already served.
Anyway, we don't want to.
সোমবার দিনও আসতে চাই।
এলে পেছনে বসে থাকবেন, আপনার উকিল বাবু ওরা মামলা করবেন। বেশ, নেক্সট। Yes.
From Mr. Rishad Methora. Great.
Give a slip, but
Yes,
you have to give the slip.
Yes.
And please take her with you. Yes. You are for the appellant. What is the matter?
There is section 5 application, my lord.
Use the mic, Mr. Dey.
Already had your lordship.
Section 5.
This is your lordship's last order yesterday.
Oh, she was appearing.
Yes.
Now we know the reason why you are not appearing.
The application, my lord.
Odisha doctor, what was the occasion?
Petition on number 3. Other application.
We were rejecting the application, but she would be embarrassed because you are leading her.
My lord,
that's why we did not.
I am withdrawing the section 5 application. My lord, kindly give liberty to file application.
Why? No. Not after findings.
My lord,
we have found, we have gone against you. We would have dismissed that.
With regard to, my lord, other appellants, my lord, the delay for filing the appeal has not been properly explained, my lord.
We'll grant it. Learned counsel appearing for the appellant submits that the explanations furnished in Can 1 of 2025 for the delay in preferring the appeal have not been properly explained due to bona fide inadvertence, and seeks to withdraw the said application and file a fresh application for condonation of delay. Full stop. Keeping in view the fact that a litigant should not suffer unnecessarily for communication gaps between the advocate and the litigants, comma, we permit such prayer. Full stop. Accordingly, Can 1 of 2024 is dismissed as withdrawn with liberty to file a fresh application for condonation of delay in preferring FAT 24 of 2024. within a week from date. Full stop. Upon such filing, comma, a copy thereof shall be handed over to the learned advocate for the appearing respondent numbers 1 to 4. Full stop. Liberty to the appellants to mention the application for inclusion in the list as and when the same is filed. Full stop. The matter let the matter go out of the list for the present. Whenever you file it, give a copy, mention.
Subject to correction, so far as I recollect the appellate side rules, in such a situation, department has to return the memorandum of appeal to the applicant for refiling the same with section 5. So far as I can recollect in that situation. Because as of today, my lord, there is no section 5, there is no appeal. My lord has kept the appeal on board, but liberty to given to my lord them.
It goes out of the list, whatever they have to do there. Yes.
Department has to my lord return the memorandum of appeal to them for refiling. That is the.
We are not very strict on those things. You know us. Call on the next. Yes, who is appearing? Yes, Mr. Pal.
I have taken instruction, my lord, that my client is ready for mediation.
My instruction is, my lord, so far as
Now you are not ready.
no mediation is concerned, my lord. If the mediation is for the
Either way.
for modalities of the
No, you cannot determine the outcome of the mediation. Mediation has to be unqualified. We can keep it clear, make it clear that the mediation will be on both counts. Both options will be explored. Whether the parties should go apart or they should join. This is against a divorce decree. The challenge. Upon query of court, comma, learned counsel for the both for both parties, comma, on instruction, comma, apprise the court that the parties are ready for mediation. Full stop. It is made clear by learned counsel that the scope of mediation will range upon both avenues to be explored, hyphen, whether the parties shall continue to live together upon the divorce decree being set aside, or the parties should part ways by maintaining the divorce decree. Full stop. In the light of the above observations, comma, let the matter be sent to the mediation to the concerned committee of the concerned mediation committee of this court for the purpose of mediation. Full stop. The file be sent to the mediation center accordingly. Full stop. Liberty to the parties to mention the matter for inclusion in the list in the event the process of mediation fails.
In the meantime, there should be a second contract of marriage.
No, don't. We will pass that.
Instruction is, my lord, he has not married.
একটা order record করে দিন. The respondent shall not contract any remarriage till disposal of the application. এটা can 1 এর উপর order.
But the appellant be also question.
If the appellant marries, you are happy. You instigate the appellant to marry someone else. What are you saying? You want to part ways, you want to remarry.
Some matters, my lord, both the parties are restrained from marrying. In an appeal against.
We have never passed any order restraining both parties not to marry. If one of the parties marry, you have obtained a divorce decree, you will be the happiest person in the world. You won't be the happiest person. Your litigant would be. You won't be the happiest person. Session. Yes.
Thank my lord. I am for the defendant appellant.
Yes. Can you please take the microphone a bit closer to your mouth? Yes. What is the matter about? Appearing for the first time.
First time.
Appeal against?
Appeal against suit for eviction was allowed. I am the suit was on the ground that the landlord needs the for reasonable requirement, my lord.
Yes.
But I have not defaulted any time, my lord.
Reasonable. What is your ground of challenge?
Ground for challenge that the lady is a divorcee lady. She
means the respondent, landlord.
The landlord.
Divorcee
the
lady,
plaintiff respondent is the divorcee lady, and she stated that she need the house for her son, but the son is from her husband's first wife, not his own son.
Husband is alive.
Husband is alive. And the son resides with the husband.
Very well. Will grant stay for the time being without any condition, but We'll keep it open for occupation charges.
My lord.
Any execution has been levied?
Yes, yes. Execution has been filed, and in the execution, they have preferred an application for correction, but that was dismissed
For
correction. But that was dismissed because in execution, degree can't be altered or
correction of the decree they wanted.
decree.
Very. The present appeal arises out of an eviction decree. Full stop. Since a prima facie case for hearing the appeal on merits has been made out, there shall be stay of all further proceedings in title execution case number 43 of 2024 pending before the learned civil judge, senior division, 4th court at Alipur, district South 24 Parganas, levied in connection with levied L-E-V-I-E-D, levied in connection with title suit number 565 of 2019 till disposal of the application. Full stop. Next para, the appellant shall serve a copy of the application on the respondent indicating that the application shall be listed for hearing on July 22, 2025. July 29, 2025. Full stop. Next para, an affidavit of service shall be filed on the returnable date. Full stop. Affidavit in opposition, if any, shall be filed by the respondent within July 22, 2025. Full stop. Reply, if any, shall be filed by the returnable date. Full stop. Next para, it is made clear that the question of imposition of occupation charges, and if so imposed, the quantum thereof, is kept open for being decided at the time of final hearing of the application.
Grateful, my lord.
Thank you. What is the defect? Yeah, thank you. Oh, yes. You should check up the defects before moving it. Let's see.
Pardon, my lord.
Oh, in the memorandum, you have stated memorandum of appeal from original order. That order will be decree. We are granting you leave. You are the advocate on record.
Lord,
The learned advocate. Thank you. Meghna, thank you. The learned advocate on record for the appellant is granted leave to carry out the necessary correction to the classification of the appeal in the memorandum of appeal by describing the appeal as one from original decree instead of original order, during the course of the day. Do it right now.
my lord.
Side de din no kore. Yes, what is the matter? Appearing for the first time, this matter?
First time, and the defect is there.
What is the defect?
I think, my lord,
court fees.
Court fees.
Plus beyond time, the beyond time is section 5 is there.
Court fees is also
44,880. Put in the deficit court fees first.
That has been paid.
You have paid?
Yes, yes.
The junior is very serious on that.
Yes. And it is left to your lordship for deciding those.
No, we'll
delay in paying the.
We'll seek a report from the office, revised report. In the meantime, we'll direct you to soft copy of this application. Achha, one other thing, classification of appeal furnished in words is erroneous. Let us see. What is the appeal against?
Against, my lord, money suit. The first.
Oh, you also have done the same thing.
Same thing, yes.
You advise him from original judgment and order. Judgment and order should go. Decree should come in. Not judgment and only decree. Original decree. Very well. Leave is granted to the learned advocate on record for the appellant to carry out the necessary correction by classifying the appeal appropriately, during the course of the day. Full stop. Next para. It is submitted by learned counsel for the appellant that the deficit court fees have already been paid. Full stop. A revised report in that regard shall be furnished by the. One second. Sorry, the report is already there.
Left to your lordship.
Yes. So, however, we find from the revised office report that such deficit court fees have indeed been put in. Full stop. Next para. Hence the appeal, hence the defect regarding deficit court fees is already removed. Full stop. The appellant shall serve a copy of the application on the respondent indicating that the matter shall be listed on July 15, 2025 when an affidavit of service shall be filed by the appellant.
Right.
What is the delay? The period of delay?
555 days.
550.
Much.
Ashok, other second. Yes.
But I applied for the respondent. I was to produce one certificate copy of the development agreement which I had and my father had entered into. But due to a communication gap, only the power of attorney could be obtained. Lordship will kindly give me 7 days more time. We had applied for the certified copy today, my lord. I'm told
For what?
for the development agreement. Which
You are the respondent.
I'm the respondent defendant in the suit. My lord, it is an order my lord, disposing of or rejecting an application under Order 38 Rule 5, against which this appeal has been preferred. But on the first day, I had indicated, my lord, I'll not address your lordship on the merits. But my lord, they sought an injunction on my share of the property, which I will get after the property is developed. So, my lord, for that, your lordship, my lord, asked me for production of the development agreement so that the share could be ascertained. My lord, there was a communication.
What is the decree? Impugned decree?
It's not a decree, my lord. It's an order rejecting an
Oh,
application.
38.5 has been rejected.
38.5 has been rejected. Against which this appeal has
What
been.
is the interim prayer? Appointment of the same attachment?
Yes, my lord.
Yes, my lord.
Same
My lord, your
press
lordships have passed an order, my lord, on 16 June, my lord. If your lordships kindly take that up. My lord, paragraph 9 and 10 of the order.
Yes. Yes, you have entered into development agreements.
My lord, that is an admitted case. I have
You
entered.
will grant that injunction now. You cannot further deal with the property.
Yes, my
or the share of the construction as paid for by.
Yes, my lord, that was the prayer to ascertain what is the exact share which I'll get after the property is developed. My lord, that development.
You require how much more time?
My lord, today it has been applied for. I'm told by say within 7 days we'll get it. If your lordship could keep the matter.
You are for respondent numbers?
All the respondents.
Learned counsel for the respondent submits that some time will be required to obtain the certified copy of the development agreement in question, comma, for the perusal of which the matter has been adjourned previously. Full stop next para. Accordingly, we adjourn the matter till July 15, 2025. Full stop next para. However, comma, we mold the prayer for ad interim relief sought in the present application in order to protect the property in the meantime and grant an order of injunction restraining the respondents from further transferring and or dealing with their shares of the suit property and or their share in the constructed portion of the suit property after development, comma, if any, comma, till disposal of the application.
Grateful. It has not been constructed. Construction has not even commenced.
If any and or
Yes, lordship has amended
but
it.
what so many prepositions, it will cover everything. Yes.
Grateful, my lord.
Thank you. Yes.
For the respondent. On the last day, your lordship directed my lord, the reports to be circulated with the my lord, structural engineer that has been appointed from the channel of this honorable court. And if the parties in the meantime, my lord, wants to my lord, file their
4 feet space from boundary wall and all.
Yes, yes. It is only my lord, with regard to that boundary wall construction. My lord, the report kindly once looks at. It's an extensive report, my lord, filed. It's on 9th of June 2025 dated.
The remuneration has been paid now.
No, my lord, your lordship directed us to inquire whether any rate chart is there, my lord, maintained with the Registrar General. My lord, that is not there. But my lord, the surveyor has raised a bill. My lord, we are ready and agreeable. My lord, we shall.
No, report ta kothay? Eta ki? Eta to copy of the order. এটার মধ্যে ঢোকানো রয়েছে কেন? রিপোর্টটা তো আগের দিন বার করা হয়েছে।
অরিজিনালটা থাক।
অর্ডারের কপি। দেখি।
Caption my lord, inspection report.
হ্যাঁ। ঠিক পাচ্ছিলাম। ঠিক আছে, thank you. Yes, now both of you have got copies of the report. So it is possible. Let us see what.
You know, there are certain yardstick that has been given to be maintained after monsoon season. My lord, according to the chartered engineer, this can be done, but with certain precautions that we have to maintain.
Just remind us of the scope of the appeal. You have challenged what?
Lord, I have challenged the decree, Lord, the wherein the declaration of right title interest in respect of his Lord property as well as a common boundary and Lord the common passage is
His common right on the boundary and passage.
Boundary and passage that has been Lord maintained. What I propose is at the very first day of the Lord appeal that a common boundary wall is just Lord facing with the construction of mine. So I cannot Lord construct according to the learned trial judge, disturbing the boundary wall and also without leaving Lord this passage, Lord 4 feet Lord passage, Lord that is the common white passage, but prior to making any construction. So I say I will do that. I will admire to whatever the direction that has been passed by.
You will keep a 4 feet wide space.
Yes, while I will make construction, but since the construction is just not adjoining to the boundary wall, so for the purpose of demolishing my part of the property, which is not disturbed by the learned trial judge also, for the time being, the boundary wall needs to be demolished, and I will reconstruct it as it is where it was. And I will in future make construction.
So what do you say to this, Ms. Ram?
And according to that, your lordship appointed the special officer.
And this report has come.
This report
It is possible subject to these things.
Yes, and your lordship also granted us, both of us, since we have not gone to the report.
Yes, obviously.
To file any exception, not by virtue of.
Yes,
my
Ms.
lord's
Mukherjee Roy Chaudhary, what is your?
May I hand over?
It's very difficult to choose one of the. Choose a portion of your surname. Every time calling you Ms. Mukherjee Roy Chaudhary is very difficult. Roy Chaudhary, very yes.
Lordship, kindly I will hand over this photograph. I will.
You could have filed a proper objection then if you want.
There is no really objections, Lordship. Kindly, if you.
We are not specialists. We won't understand whether it's structurally possible.
Lordship, the first page of the report.
Yes.
The last 4 lines. This demolition is for the making the site clear for new construction, which is to be, here I am, it should be, which is to be done after getting sanction plan. Monsoon, okay, obviously the 100 years old property monsoon. After getting sanction plan from the civic body KMC and keeping mandatory open space clearance from.
Yes, yes, that they have to adhere to.
For future construction, I must have to.
Lordship, kindly observe, Lordship, that my client should be intimated that they have obtained a sanction plan.
Why?
Lordship,
What is your interest in their proportion of the property?
in my portion, Lordship. So
in their portion of the property, whether they have obtained a sanction plan, why?
demolition will be done only after getting sanction.
No. This demolition.
No, Lordship.
That is for future construction.
No, this demolition is for making the site clear.
Yes.
For new construction,
Which is to be done after.
his site will be made clear from the boundary wall, keeping 4 feet passage. For what purpose? For making new construction, which they'll do after getting the sanction plan. For this demolition, no sanction plan is necessary.
The language is this demolition is for
No, we are not bound by the surveyor's language on sanction plan.
from the civic. Lordship,
Surveyor was appointed not to advise us. Surveyor was appointed only to see whether this was feasible or not. It has been said to be feasible, to let them demolish.
Lordship, if it is demolished, Lordship, then.
But Mr. Mukherjee, you have to make it in accordance with law. We don't know whether for this demolition sanction is required from the government. Permission is probably required.
For the purpose of erection of boundary wall, that is
demolition work.
Demolition is also in respect of boundary wall, no existing structure.
Yes.
No, we don't know whether.
Yes, that is there. That is there.
No, there is. Before demolishing outside face of staircase wall of property be courtyard. Because it's joined with the bound.
Necessary, my lord, your lordship mentioned
if
that.
necessary, we'll say that.
Yes. Photograph will
kindly do that also.
No, we'll say if necessary, they'll have to obtain sanction plan. And very well, you will intimate to them also because it concerns their property. She has a point there. So we'll permit them in terms of this plan.
And we'll not adjourn the matter for few months because after monsoon, this entire work has to be done.
Adjourn sine die. You will come and mention after it is done.
I'm great.
So we are. Should we dispose of the can with this appropriate order? Can is for appropriate order.
Yes,
what?
yes.
This is
That
the
is
appropriate
for
order.
the, yes, appointment.
Very well. The inspection report filed by the structural engineer appointed by us for the purpose of holding such inspection is before us. Footstop copies thereof have been circulated between the parties. Footstop learned counsel for the parties. Learned counsel for the respondent submits that in principle, the respondents do not have any objection to the demolition work being sought to be made by the appellants, subject, however, to the appellants strictly adhering to the suggestions given in the inspection report as well as obtaining a sanction plan for making such demolition stroke construction, comma, if required by law. Full stop. Next para, accordingly, upon hearing learned counsel for the parties, comma, can 1 of 2025 is disposed of by granting leave to the appellants to carry out the necessary construction stroke demolition work in respect of the portion of the appellant's property which is adjoining the boundary wall between the appellants and the respondent's property. Full stop. Such construction shall be made strictly in accordance with the bullet points enumerated in the inspection report, comma, which is a part of the record and copies whereof has been circulated between the appellants, comma, authored by Mr. Debashish Sengupta, comma, civil engineering consultant. Full stop. Next para. It is made clear, it is made further clear that in the event a sanction plan stroke permission from the it's Kolkata Municipal Corporation. Kolkata Municipal Corporation for the purpose of carrying out such demolition stroke construction work, comma, such sanction stroke permission shall be obtained by the appellants prior to carrying out such construction. Full stop. Next para. In the event such permission stroke sanction plan has to be obtained and is obtained, comma, the particulars thereof shall be furnished to the respondents to their learned advocate on record in this court by the appellants. Full stop. Next para. It is expected that the entire work shall be concluded within 4 months.
4 months, Your Lordship.
Within 4 months. Within 4 months from date.
This will be done under the supervision of the special officer appointed, the civil engineer, because he has already raised bill, my lord, including his supervision charges. So this is the bill, Your Lordship made it clear, my lord, I shall pay that also.
Push up. The said construction stroke demolition work shall be done under the periodical supervision of Mr. Debashish Sengupta, comma, the above named civil engineer, comma, who shall visit the property at regular intervals as deemed required by him. Full stop. The appellant shall pay the charges in terms of the bill raised by the said structural engineer. How soon should you pay it, Mr. Mukherjee? Pay it within a fortnight. Within a fortnight from date. Full stop. Next para. In the event the number of supervisory visits exceeds 8, comma, it will be open to the structural engineer to raise further bills on the appellants, which shall also be cleared by the appellants.
Great.
Achha, we'll pass the usual directions also, paper books and all. You have for all the respondents.
Only one respondent.
Only one? No, there are several respondents.
Lordship, there is a error, mistake in the cause title. It is not as per the decree. The pro forma defendants have not been made parties.
There are
pro forma municipality director or executive.
And pro forma defendants are your one of your sister is also there. Lovely Mishra. And my brothers and sisters. Somorendra and Kalpana.
You are appearing for Rabindranath Bhattacharya?
Rabindranath. Because at that time my father's will was not probated. So as executor, but once the probate was granted.
Yes, Mr. Mukherjee.
The Alpona, from the decree I find Alpona, Jyotsna and Shopna, their name has been expunged.
After, no, Kalpana is there. Who are the beneficiaries? তারপরে কল্পনাকে আপনি পার্টি করেননি, লাভলিকে আপনি পার্টি করেননি, আপনারই
Lovely has been তোমায় করতে হবে প্রপার that
Somorendra has not been made a party.
Yes.
Those who have been deleted are not. Somorendra
নিচের কোর্টে ডিডি অ্যাপ্লিকেশন করেছে রবীন্দ্রনাথ কে পেয়েছে
No.
But I have to check it up. This my friend contention is that by application, this Somorendra's name has been expunged, but I have not seen it.
I had applied for deletion after the grant of probate.
Is it reflected in the decree?
In the decree, reflected regarding the deletion of all Alpona, Jyotsna and Shopna.
And while order deleted 19th of February 2024, once the probate was granted.
Your Lordship grants me leave, my lord, if
On the prayer of the appellants, leave is granted to the appellant to implead the left out parties as pro forma respondents. Full stop. Next para. Necessary corrections to the memorandum of appeal in that regard shall be carried out by the learned advocate in record for the appellants by tomorrow. Full stop. Next para. In view of the appearance of, you are for respondent number 1 only. In view of the appearance of respondent number 1 through his learned advocate, service of notice of the appeal on the said respondent is dispensed with. Full stop. The appellant shall put in all the others are pro forma respondents.
he is the plaintiff.
Very well. Since no relief has been sought against the pro forma respondents or the proposed added pro forma respondents, service of notice on the pro forma respondents is dispensed with. Full stop. The appeal be treated to be ready as regards service. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
I'm grateful.
Thank you.
Item number appear for the appellant, my lord. Item number 13, there were directions to file affidavits to the supplementary affidavit which have been filed by them. No, they have filed a reply. They have served us with the reply just now. We got it. Just keep it any other day. Let us consider the points which they have taken in the reply, and we
the affidavit in reply to the opposition in connection with the supplementary affidavit filed to be kept on record. Full stop. Since learned counsel for the respondents,
it was served through mail last night. Today, I got
for the respondents that copies thereof has been served only last night, on the prayer of the respondents, let the matter stand adjourned till July 7, 2025. Full stop. আচ্ছা প্রথমে যেখানে বললাম the affidavits in opposition and reply filed to be kept on.
But let it be taken on 9th, my lord.
আচ্ছা adjourned till next be listed on 9th, July 9, 2025.
If my lord 9th, I have some difficulty any other day, man. I have a matter with the green mail.
Have a meeting.
10th is Thursday, my lord. 10th, then my lord, let it be on 8th.
8th. Give it, both of you sign and give a date to my office. 8th করে দিন 8th. 8th এ থাকবে অন্যদিকে।
I am the respondent, though I am standing on this side.
Yes.
The application is, my lord, for vacating of the interim order. My lord, I am led by Mr. Jishnu Chaudhary. He will be joining soon.
Yes, vacated the other court and is running. Vacating? Well, what interim order was passed that you were vacating? Wanting to vacate?
Lord, I'm successful in obtaining a money decree. Lord, there's an interim order, my lord, and my for stay of the decree, my learned friend has put in a bank guarantee for the, my lord, decretal amount. Now,
what was the condition by the court imposed by the court?
To furnish the bank guarantee.
Furnish the bank guarantee.
Furnishing the bank
Now, my lord, with the passage of time, I have, my lord, filed an application saying that interest runs, but there's no accretion to the bank guarantee. So please vacate the order. That's a contention. But, my lord, kindly, my lord, don't go into that.
That's not the contention.
No, I'm
He's
I'm saying, my lord, please don't go into that. The my lord, it's a very small appeal. Maybe, my lord, do it. Mr. Shomo Mujumdar is leading him. If
You are appearing on one side, Mr. Shomo Mujumdar is appearing on other side, and it will be a very short appeal, Mr. Chaudhary.
Very short. My lord, I promise not more than 10 minutes. My lord, husband and wife have fallen apart. The most interesting and the most fantastic statement, my lord, I have found is in the appeal. Yesterday, my lord,
you are the husband.
Yes.
What is
I think
interesting?
the sentence goes
that the plaintiff is the husband and the respondent is the wife in the bondage of marriage. That sentence is so fantastic.
That's a Freudian slip.
Yes.
Disposes of the
What about
application,
her?
this
No, no.
application.
May I on this?
You agree with
matter-
dispose of the appeal?
Yes,
part ways?
exactly. Exactly.
There's a fit case for sending to mediation. We have grown a habit of sending matters to mediation.
This is a different mediation.
But this is money.
Yes, they have asked for
In a written statement,
money
Radha.
slip.
No, no.
Milord,
They
I
have asked for money
The
degree.
husband filed a money suit against
money
that.
suit. Reason is, I'll tell
That
you.
is also
Lordship,
very interesting.
divorce is separate. This is not separate. I gave my wife money to buy a flat. My wife didn't buy a flat. She's kept Milord the money with herself. So, Milord, I filed this suit asking for recovery of
Just
money.
this with alimony, Mr. Chaudhary.
No, no.
Just wait for
No.
This
Now,
court has
No,
had
the
this
divorce suit is pending.
I think so, Milord. Now, what has
There is no
happened?
divorce suit.
No, no, there is. Pending, no?
pending.
Now, the defense is A, it's a Sridhan, which is not possible. B, it was given as a gift. Now, evidence was analyzed in the form of 4 letters, and it was found that this can't be a gift. This is the decree.
We shall address your lordship.
But-
Kindly peruse the
Hey, we
application
sentence
first.
the quota in
It's an
bondage
application
of
for
marriage.
vacating the interim order on the ground that paperwork was not filed within the stipulated.
Oh, that is the ground, Mr. Chaudhary.
Milord, may I read, Milord, one sentence? I am so, Milord,
The application
I'm so
Sentence in what? Your vacating application?
Keep quiet.
Sentence in what? Your vacating application?
No, Milord.
Kindly have a look
It-
at the
this
prayer,
is
my lord.
page 18, Milord.
My lord, paper book filed within time, my lord, as per the direction of
আরে
this
তুই দাঁড়া,
honorable
আমি
court.
order চাইছি না, 2 মিনিট দাঁড়া। Milord, page
Vic-
18, paragraph 2,
Victorian marriage.
that the petitioner and the respondent are a couple being united under the bondage of marriage, registered on 30th May
No,
2000.
Bond was nuptial bond was wrongly.
My lord, this
But
was-
Victorian marriage seems to be more
Yes.
interesting to me.
Milord, kindly, Milord, take up the appeal whenever your lordship on these
No, but
paper,
this
everything is-
appears to be the money suit has been converted to a matrimonial suit
No.
by the
My
Learned
lord,
Trial.
of
Should
the-
we set aside on that ground?
I have a cross appeal also that interest should also have been awarded.
Cross appeal against those findings.
You know, that no interest was given.
No, you said you have filed the vacating application because they have not filed paper books.
was filed within time, my lord, as stipulated by this honorable court.
Then I am not asking ever any order.
Purport of the application, my lord.
Can one was disposed of? Can one was disposed of?
That
Milord,
is the
may I,
application that
may
has
I,
been disposed.
Milord, I believe paper books have also
Yes,
been
my lord,
received.
Can 2 of
Let me do it.
2023 is an application for vacating the interim order on the ground that paper books were not filed within time. Full stop. Learned senior counsel for the appellant further submits that the order of stay which was obtained, the order of stay obtained in respect of the impugned money decree was on condition of furnishing bank guarantee. Full stop. However, the increasing interest accruing on the decretal sum has not been taken care of. Full stop. Next para. Be that as it may, learned senior counsel submits that the appeal is on a short conspectus and paper books are already ready by now, and as such the appeal may be listed for hearing. Full stop. Learned counsel for the respondent also submits that the paper books have been filed within time, and as such there is no scope for vacating. Full stop. Since the paper books are ready and the parties are before this court, let the appeal be listed for hearing in the monthly list of August 2025.
ঠিক আছে দাদা।
With the hope and trust that this court takes up something. Oh, yes. Can 2 of such and such is disposed of accordingly without any orders to cost.
Milord, but wasn't that a very compelling sentence?
Which one?
The one I read out, Milord.
That bondage. So what about the bondage? It's in progression. The severance of
Bondage
the
was severe. I don't know why what these people
divorce
do.
suit has been no.
No, it has not been decreed, man. It's pending.
You can,
Your divorce suit.
Yes.
you can send it to mediation, Milord. I really encourage, Milord.
We cannot send this. That should be sent to. You can approach it, district judge, and say that.
Both of us can agree, take everything.
Yes,
to
you agree.
mediation,
In fact,
finish
yes.
it up.
Not a farthing paid for maintenance.
I
If you pay a farthing, you won't be able to have an exchange of that. But better to pay in rupees.
I shall
Yeah, you
talk to
you
him.
take
You don't
your-
pay in farthings. You pay in rupees. Some amount. Decide among yourselves. Get it solved.
Milord, if we don't live together and if we had decided that we are never going to live together, might as well get divorced. And agree like gentlemen on an alimony.
She cannot agree like a gentleman. It's physically impossible.
Lady.
Yes, next. 16.
Yes, my lord, I am
Yes.
for the appellant.
Yes, sir. What is the matter?
Yes. My lord, senior.
Condonation has been allowed.
Yes, my
What,
lord.
what is you are for the respondent?
Yes, ma'am. On consent, the decree was passed. Kindly see.
Consent decree?
Yes, ma'am. Kindly see, my lord, page 8, last paragraph.
What is the nature of the decree?
Preliminary decree, my lord.
Preliminary report. Acha, consent. Page 8 of the judgment. Judgment.
Judgment, yes, ma'am. Last paragraph. DW1 during his cross-examination has admitted that the plaintiff is the rightful owner.
Not a consent decree, but in evidence he admitted.
My lord, appellant suffering from hearing problem. Already I submitted the medical certificate.
Yes, you have
Somehow he could not
admitted to their share. So what is the scope of challenge?
He is suffering from hearing problem. So somehow he could not tackle the advocate's questions, my lord. This is the fact. Fact is simply difference.
We'll ask the appellant to come here and
issue.
test whether he's suffering from a.
No issues. He is 76 years old, suffering from various also issues is there, my lord.
No, selective hearing problem or
selective hearing problem. No. These.
Did you had to take this point on the same date when the evidence was recorded before signing the deposition? Did you do that? If you did not do that, then the evidence remains on record.
Yes,
so there's an admission. Why should he admit the appeal? Or rather, why should he let us dispose of the appeal?
Different, my lord. Entire suit properties.
You admitted during cross-examination that the plaintiff is the rightful owner to the extent of 4 decimals of land and 3 decimals of land totaling 7. The preliminary degree has been passed on the line of this admission.
Yes, my.
What is your prima facie case? Tell us.
Actually, my lord, the suit plot 957 and 950 is entirely either owner and the possession holder last 1949, from 1949. Originally, suit plot belongs to the Gostovihari Ponda and Pulinbihari Ponda. I got 7 decimal from my father, Pulinbihari Ponda, and rest 7 decimal I possesses from the by a exchange of deed of exchange of heirs of the Gostovihari Ponda.
You are absolute owner. The plaintiff is absolute owner of 7 decimal by UFO.
Respondent is the absolute owner, my lord.
He is also.
Sorry, yes, plaintiff you are saying.
Total land 14 decimals.
Respondent was the plaintiff. You are the plaintiff. You are saying the plaintiff. The plaintiff is the absolute owner of 7 decimals of land by way of gift and purchase. That is the finding of the court, which you have admitted in evidence. There is a gift deed and a purchase deed.
My lord, raised 7 decimal already I got from my father, the Pulinbihari Ponda. He is the, they are the 2 brothers, Gostovihari Ponda and Pulinbihari Ponda. Pulinbihari Ponda possesses 7 decimal, what I got from my father's. Raised 7 decimal I possesses from the deed of exchange of heirs of the Gostovihari Ponda. Upon that, we are residing over there last 50 years without any disputings by any.
Residence is does not give you title.
No, my lord, I admit, my lord.
We have pondered upon the dispute between the Pondas and we have come to the conclusion that your residence does not give you title.
My lord.
So, what is there in the appeal? They have produced deed of gift. They have produced deed of sale also.
Yes,
exhibits have been mentioned.
Yes.
And court has held that they have title and you have admitted in your evidence. What remains? We'll decide the appeal and the application right now. We'll say that we'll record your argument that you are saying that you have been in exclusive possession of the property, but we'll say that that exclusive possession itself does not confer right. You did not prove any ouster. There is no case of ouster, no case discussed about ouster.
Yes,
then we are disposing of the appeal application instead of prolonging the agony of both of your clients.
At this time, I have to oust due to this preliminary decree. Actually, at this time, I have to be oust due to the preliminary decree, as because my residence.
You will not be ousted. You have been given a share.
No, there is the share, but my residential building is along with the 14 decimals.
Yes, you are occupying their property. Obviously, you will be ousted from a portion of the property.
That will be demolished at the end. Due to until demolished, we could not just segregate the portions.
That the court will decide in the final degree proceedings. You can take OLT money and or they can take OLT money also. Court can consider those things, but that is not a ground of challenge to the preliminary degree. In view of the short conspectus, in view of the short conspectus of the appeal, we take up the appeal along with the application. Full stop. Next para. A preliminary degree passed in a partition suit has been challenged by the defendant therein. Full stop. Next para. Learned counsel appearing for the appellant submits that the appellant has been in exclusive possession over the entire suit property since long, and as such, the decree passed in favor of the plaintiff is bad in law. Full stop. Next para. Learned counsel appearing for the respondent, plaintiff stroke respondent points out to the findings of the impugned judgment to the effect that that the defendant stroke appellant, comma, as DW1, comma, during his cross-examination, comma, admitted that the plaintiff is the rightful owner to the extent of 4 decimals of land and 3 decimals of land, comma, totaling an area of 7 decimals of land in the suit plots number 957 and 958. Full stop. He had further admitted that he had no objection if the suit property is partitioned by metes and bounds between himself and the plaintiff. Full stop. Next para. Upon a careful perusal of the materials on record, comma, we find that such admission not only binds the defendant but also corroborates the exhibits in the corroborates the deed of gift and deed of sale in favor of the plaintiff, comma, which were also marked as exhibits in the suit. Full stop. Thus, comma, the finding of the learned trial judge while passing the preliminary decree to the effect that the plaintiff is entitled to declaration of his right, title, and interest over 7 decimals of land by virtue of the gift and sale in his favor is absolutely justified. Full stop. Next para. Although learned counsel for the defendant stroke appellant seeks to submit before the court that the defendant stroke appellant is of advanced years and is hard of hearing, and as such was not exactly aware of the tenor of the recording of the cross-examination, comma, we find that there is no scope of such misunderstanding, comma, since the law is very clear on the subject that in the event a witness has any objection to the recording of the evidence adduced by him stroke her, comma, it is for the said witness, comma, directly and or through her or his advocate to immediately file an application objecting to such recording in the trial court itself. Full stop. Next para. Having not done so, comma, the appellant cannot take the said point for the first time in appeal. Full stop. We also find that the said issue was not raised before the learned trial judge at the time of hearing, and hence, comma, cannot give any cannot lend any credence thereto. Full stop. Thus, comma, there is no scope of interference in the appeal. Full stop. Accordingly, FAT 125 of 2025 is dismissed on contest, thereby affirming the impugned judgment and preliminary decree dated August 30, 2023, passed by the learned Civil Judge, Senior Division, First Court at Tomluk, District Purbo Medinipur, in title suit number 100 of 2021. Full stop. There will be no rise to cost. Can 1 of 2020, can 2 of 2025 is also disposed of consequentially. Full stop. A formal decree be drawn up accordingly.
I'm good. Fine.
Formal decree পরে ক্যানটা করুক।
My again section 5.
Similar?
No.
Same order?
No. 156 days delay. Now, my lord, I will not go any my application or
I'd like to file the objection to the
Objection to section 5?
to both the appeals.
To both the applications?
Yes.
Madam, second applicant, your lordship has not yet.
This is only one affidavit in opposition.
Yes. Yes.
This opposition is to the which can? You have not written the can in the opposition.
Oh, no, it is a mistake. But actually, in page 3 at paragraph 12, it is written that paragraph can 1 of 2000.
But I will not rely upon his opposition. Kindly see once. Kindly see once the plaint.
Composite opposition to 1 and 2.
Yes, my lord.
Was there a direction?
Only section 5 opposition was, he was directed to file opposition against the section 5 application, because unless section 5 is allowed, no question of stay.
How is the how are they what is the dispute in their opposition to the section 5?
I'm telling you. But before that, my lord, only thing, my lord, the plaint. But kindly see, the wife filed a suit for divorce. The address is given, my lord, village Kistipur, post office.
What pur?
Kistipur.
Kishti.
Not Kisti.
I. No. Why are you laughing, Mr. Mukherjee?
Kistipur.
I. Starting with the I.
C.
Chistipur, acha. Yes.
Now, my lord, kindly state, my lord, come to paragraph 9.
Yes. Paragraph 9.
Paragraph 9, according to her own case, the respondent used to return the house late.
What was the
I'm telling.
what was the menu which was in your dinner? We just want to know the dish. Is this white? I mean,
No.
what sort of oil is this?
No. I'll take back. May I take back?
No. We love oil. Yes.
Yes.
Anyway, 9, gradually such degree of both
Now, my lord,
torture increased.
Now, my lord, torture increase. Now, next page, paragraph 11. It is the own statement that since 30 November 11, 2019, the respondent has been residing in different place. Paragraph 11, page 4.
Yes.
And one of the ground is desertion. And the next paragraph, if you actually go through paragraph 12, 13, it is an admitted fact that the respondent has been residing in other place.
Oh, but you were served in
that place. And my lord, not only that, this has been corroborated by the evidence of the brother of
expertise degree.
Expertise degree. Now, my lord, if you actually see the cross-examination of the brother, in the cross-examination also, brother has my lord stated that she also came to learn.
Whose brother? Her brother.
Her brother.
What did he say?
But she took my paragraph 11, my lord, in the cross-examination certificate copy, that since 30th November.
They have corroborated the plaint case.
And therefore, my summons has been served there. Now, what happened, my lord? I filed a section 5 application, my lord. I stated that I don't have the knowledge, because my lord, the copy has never been served upon that address, and copy has been served this address, and someone has received. And
someone was received.
But it has been in the report, my lord, it has been stated. If you let's see the order sheet.
Yes. There was substituted service.
Substituted service in the area, my lord. But Ajkal, my lord.
Anandabazar.
Anandabayan, Ajkal.
Not Ajkal.
Anandabayan, my lord. That, my lord.
Not going into any value judgment between Ajkal and Anandabazar, but both are circulated.
Now, my lord, ultimately, my admitted fact, my lord, the notice was sent in that address.
But where have you been roaming around?
I am residing permanent. Now I am
then
residing.
Mr. Mukherjee, in the same breath, you cannot say, if you say that you were not there, you had gone elsewhere, then you are admitting to the desertion.
But that is a
so we say that yes, it should not have been past ex parte, but support the conclusion and affirm that.
But
you admit your ground in the section 5 is that they say that you have been roaming around elsewhere.
I am residing in my
So you deserted her. That's admitted, established.
Not like
they allow the section 5 and dismiss the appeal.
That your lordship, that there are
that is your ground.
In the written statement, if I be permitted, if I can, because every time when I have to put the vote, my lord, I used to go there. I used to see the children, my lord. There is no dispute now. They are also aged, and if you have
deserted the wife, then
not at all, my lord. They are not. She is not permitting me to enter the house. It is my house. It is my house. She is not permitting me to enter. And now, my lord, in the section 5 application, my lord, I have annexed the, my lord.
What have they said in their opposition?
Opposition, my lord, one mistake has been committed by my junior, because my rent receipt where I am residing, in the rent receipt, page 6, my lord, but the first one is correct. Second one is, my lord, the signature part, instead of 2025, it was put 2022.
So your junior put the signature?
No. Signature, my lord, the rent receipt has been.
What was the mistake of your junior?
It should not be annexed. It should not be annexed.
That would be suppression then. Should not be annexed.
because my two rent receipt has been annexed.
Favor by annexing.
That second rent receipt is in respect of where?
No,
Within
same-
this police station?
No, same place, same place. Admitted fact, he is residing in Kolkata. No dispute about that. Only
What
thing,
about the date? Second rent receipt?
rent receipt 31st March 2025. That is for March 2025. But signature, the landlord has given the date 22.
In 2022, she signed the
Earlier one is there. All the rent receipts are there. There is a mistake.
manufactured, obviously.
But
Yes,
I am taking the food from the home delivery. All receipts are there. That is
those are not a part of the Section 5.
no, not part of this. But admitted fact from the plain case that.
Yes, what do you say to the Section 5? What is your opposition?
My lord, to the section 5, my lord, I'd like to, in order to oppose the section 5, I would like to draw attention to the can 2, my lord. Although it is not a section 5 application.
Can 2, I'm not pressing now.
No, I need to point out certain things.
Yes, can 2, what have they done?
My lord, may kindly be pleased to come to the paragraph 6. That the petitioner states that it is the knowledge of the wife opposite party that since April 22, your petitioner is residing as a tenant at premises of 2A, Ramkrishna, Kolkata, 7,03,000.
Yes.
Of the rent receipt is annexure P1.
Right.
My lord, it is their rent receipt, their rent receipt to their landlord. To that, how can I have the knowledge? It is between.
If you can't have the knowledge, you cannot deny also then.
You can't have the. I cannot have the knowledge that they are residing there.
One having no knowledge cannot deny also. Cannot affirm or deny.
No.
If you don't have knowledge, then we accept that and allow.
My lord, also another thing, my lord, the notice was sent to the last known address. Last known address which was known to me, which was within my knowledge. Your lordship is aware of the section 12 of the General Causes Act, my lord. General Causes Act, section 12 of the General Causes Act. From the ID card and summons was served to the last known address.
Last known address.
So if the last known address, if he's saying, then why he is written in the plain that I am residing since 2019 in other place?
No, you are right. Last known address, but that is on the summons.
Yes.
That may be a good ground for defending the decree,
Yes.
expert decree. But for Section 5, that is sufficient because the summons might have been good at the last known address.
Yes.
But at the same time, since you have admitted in the plain that he has not been residing in the suit premises.
Yes.
Therefore, if you served at that address only, then he might have a good ground in Section 5.
My lord, I don't know the change address. He did not inform me.
No, not your fault, but we allow this. How did you come to know what is the mistake on that averment?
No, that is here no mistake.
Let us see that averment. How did you come to know?
Yes.
A bird was flying by with the certified copy in its mouth. Dropped it in your home. You reside elsewhere. How did you come to know?
Page 2, paragraph 2. Page 2, paragraph 1 first. That your petitioner states that on 14th March 25, the daughter of the petitioner informed him that her mother filed an application such 13(1)(a) in the Marriage Act against your petitioner, obtained a decree for divorce and requested your petitioner not to enter the house situated at village.
So you knew about the filing of the divorce chapter?
When, 14th March.
After the decree?
After the decree.
The affidavit in opposition, the composite affidavit in opposition filed in respect of Can 1 of 2025 as well as Can 2 of 2025 be kept on record. Full stop. Next para. Learned counsel for the appellant submits that the petitioner was never served with a summons of the suit and came to know of the impugned decree only on March 14, 2025, and the appeal was filed within a month, after about a month thereafter, comma, upon contacting learned advocates and the memorandum and the applications being drafted. Full stop. Next para. Learned counsel for the appellant further submits that it is evident from the plaint, comma, copies of which are handed up in court today, comma, that as per the allegation of the respondent wife herself, comma, since November 30, 2019, the present appellant, within bracket respondent in the suit, bracket closed, had been residing elsewhere than the matrimonial home. Full stop. Next para. Although the appellant husband alleges that he was not permitted to enter the house by the respondent wife, comma, fact remains, comma, it is submitted, comma, that admittedly the appellant was not residing at the address of the matrimonial home, comma, where the summons were served. Full stop. Next para. Learned counsel appearing for the respondent wife submits that the summons were served at the last known address and as such, comma, There was no fault on the part of the respondent wife in having the ex parte decree. Full stop. Next para. Be that as it may, comma, even without going into the question as to the reason for the husband not residing in his matrimonial home, comma, since it is an admitted position from the plaint of the wife that the husband was not residing at the suit premises, comma, at the matrimonial premises, comma, it is a credible ground of condonation of delay that the husband did not have any knowledge of the service of summons or the pendency of the suit and so got the ex parte degree prior to being informed by his daughter, comma, who has been residing with the respondent wife. Full stop. Next para. Accordingly, can 1 of 2025 is allowed, comma, thereby condoning the delay, allowed on contest, comma, thereby condoning the delay in preferring FAT 179 of 2025, full stop. The appeal be deemed to stand registered and admitted. There will be no address to cost. You have remarried in the meantime?
No.
We'll restrain you from can 2 of 2025 is an application for injunction, full stop, since the appeal arises out of a suit for divorce, comma, the same would be rendered infructuous in the event the respondent wife is permitted to remarry in the meantime. Full stop. Accordingly, can 2 of 2025 is allowed on contest, thereby restraining the respondent wife from contracting any remarriage during pendency of the appeal. In view of the appeal, next, there will be no address to cost. In view of the appearance of the respondent through her learned advocate, service of notice of the appeal be dispensed with, and the appeal be treated to be ready as regards service. Stop. Next para. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Puts up liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Grateful. May I take back the certificate of the evidence?
Evidence, yes. Certified evidence is certified copy of paper.
Same can one after.
সার্টিফিকেট কমে যাচ্ছে যা যখন
সার্টিফিকেট কপি যেটা হ্যান্ড ওভার করলে খুঁজে হ্যাঁ আবার yes who is appearing? You are for the
My lord, I am appearing. I'm appearing for the appellant, my lord. May I be permitted to appear online?
Yes.
My lord,
Provided you don't
this
have
is my.
anything, provided you don't have anything in your hand and you are not in Gujarat.
No, I'm very much in Calcutta outside for a medical.
And your hands are
round,
empty,
my
we
lord.
suppose. Yes. Very well, yes.
Except with the camera, my lord. I have my brief in my hand.
Very well, Mr. Yes. What is it?
Yeah, my lord, this is an appeal from allowing an Order 7 Rule 11. I was for the plaintiff. The plaintiff was a trust who had filed a suit for declaration and injunction against a third party. The trial court, my lord, held that section 92 leave was not obtained by the plaintiff while suing a third party, and hence, my lord, rejected my plaint. Kindly takes the impugned order from the stay petition. It's at page 71. The learned court, my lord, holds that if I may just place this order.
What can be done?
Where is the plaint? Show us the prayer in the plaint.
Page 45 is the plaint, 49 are the prayers.
Yes, we are disposing of the appeal as well as the application. Why keep it pending unnecessarily?
There's only one thing.
What one thing?
It cannot be done when I know that.
Obviously.
Only one thing. Where the property which is the suit property, my lord.
Just take the microphone a bit closer to you so that he can also.
The suit property, my lord, is not a trust property. The trust deed has been annexed.
No, that your.
In the meantime, we have also filed a suit against them, and we are enjoying an injunction. After the suit,
Maybe we will dispose of the suit because if you say it's not a trust property, it all the more supports their case. Anyway, that will be a valid point. You can take all points. We are not entering into the merits at all.
That's the only takeaway I have.
Definitely. Right. That's the only takeaway we have. In view of the appeal, in view of the scope of the appeal being very limited, comma, we take up the appeal along with the application for hearing together. By dispensing with all, you are for which respondent?
All the response.
By dispensing with all other formalities. Yes?
My lord will be kind enough to examine one thing at least. Well, section 92, the third proviso, my lord.
Yes.
My lord, the prayer in the plaint, my lord, is for whether the property is a trust property. This is the prayer in the plaint. Kindly have a look once. The public charitable trust that is admitted in the plaint. That's there. Section 92. There is C. Like in this regard, my lord, the leave is required. 92C. 1C.
3.
Whether vesting of a property in a trust, my lord. Kindly now looks at the prayer of the plaintiff.
92.3.
92.3, section 92, CPC.
3. The court may alter the original
1C, 1C.
1C, yes. Vesting any property in a trustee.
In a, since, my lord, the prayer has been couched in such a manner, this is cleverly drafted. What I find, my lord, kindly have a look at the prayer once in the plaint, my lord.
Yes.
My lord, the prayer is, I'll just indicate.
Plaintiff number 1 is the absolute owner.
Yes, my lord. My lord, now the trust deed annexed to the plaint, which is also be annexed here in the appeal, my lord. My lord, it says that this property is not in the trust.
Well, there was a subsequent transfer of this property to the trust, my lord. That is what I was.
After the demise of the settler, this cannot be done. My lord, what is in the original trust deed? This only a trust was created without any property.
That is an arguable question in the suit.
Understand that. Kindly have a look. This is a manner, my lord, with which
92(1)(c) does not prevent it.
You know, the vesting of a property in the trust.
They have not asked for vesting of property. If they ask for
The property is couched in such a manner, my lord.
no, not couched in any manner. The trust, it has the declaration of title of the trust only has been sought.
Correctly so. My lord,
But they could not seek a vesting of the property.
The question is whether the property has vested in the trust or not.
No, they could not seek such a relief for vesting. That is 1C. 1C is they cannot seek a vesting of the trust property. They have not sought that. They have sought a declaration.
Made to be understood.
Next para, by the impugned judgment and deemed decree, comma, the learned trial judge has rejected the plaint of the suit filed by the plaintiff's appellants, comma, for declaration that the plaintiff number 1-trust is the absolute owner of the suit premises and for consequential permanent injunction. First of the only premise of rejection of plaint was that the suit was barred by law, comma, specifically section 92 of the Code of Civil Procedure, comma, in view of no leave being sought under the said provision. First of next para, upon hearing learned counsel for the parties, comma, we find that the learned trial judge entirely misdirected herself in holding that a leave under section 92 is required, comma, since the present suit has been instituted in the name of the trust itself, seeking declaration of title of the trust as against a third party and consequential relief by way of permanent injunction. Full stop. Thus, comma, the suit does not come within the ambit of section 92 of the Code of Civil Procedure at all. Full stop. Hence, comma, the impugned judgment and deemed decree cannot be sustained in the eye of law. Full stop. Accordingly, FAT 197 of 2025 is allowed on contest, thereby setting aside the impugned judgment and deemed decree dated January 29, 2025, passed by the learned judge, 12th bench, City Civil Court at Calcutta, in title suit number 91 of 2021 and 91 of 2021, full stop. Next para. The learned trial judge shall now take up the suit for hearing on merits in accordance with law. First up, we make it abundantly clear that we have not entered into the respective contentions. We have not entered into the merits of the respective contentions of the parties in the suit, and it will be open to the learned trial judge to decide all issues upon proper trial and giving opportunity of hearing to all parties in accordance with law.
The decree was annexed to the appeal.
No order as to cost.
Grateful.
It's a deemed decree. Deemed decree. Rejection of plaintiff is a deemed decree, need not be annexed.
Much obliged.
Thank you. Shanko, judgment from she disposed of accordingly as well. A decree
For a very short passover.
item number
19 and 20.
why passover.
Mr. Shubhankar Nag is appearing, my lord, for the respondents.
Shobhanaga was there a few minutes back.
Yes, my lord.
What is the matter about, Mr.
But in this, Lordship had intervened and passed orders. But the order was, the matter was referred to mediation. Lordship would kindly come to page number 140.
Mediation has failed.
Yes. Mediation has failed. Malad, there was a direction not to change the nature and character of the suit property, and there was a further direction not to proceed with the execution. But in the meantime, what they have done, they have locked the main door of the property. Malad, we are both co-sharers. I have been allotted a portion in the property. They have also been allotted a portion in the property. But the main entrance
The
door,
challenge is against a final degree.
no. Malad, a title suit was filed. In the title suit, a decree was passed that they have an order of eviction against me.
No, title should filed by them.
Them.
For what? Declaration?
No, the title suit was filed by my client,
For?
in which, for a declaration that declaration and injunction, they cannot make illegal constructions in my portion of the property. They filed a counterclaim in the suit.
Portions are admittedly separated.
Malad, as per the settlement deed. But there is no partition up till
But the
now.
premise of your suit is that it's separated. Otherwise, you could not claim exclusive title.
No.
Your portion, you are saying. How can you say your portion?
The portions that I am occupying in the property, the father was there. Father.
But you say that it's a joint property.
Yes, it's still a joint property. That is the contention.
Now, how can you claim your right over a portion of the suit property that they cannot disturb you?
But these portions have not been specified as yet. These have not been partitioned and exclusively allotted to either
Yes,
of the parties.
exactly. That is why, Mr. Banerjee, how can you claim that he cannot disturb?
Bathrooms are common, but common areas are there.
So you sought a declaration that they cannot make construction over a particular portion.
On various portions of the property.
They were making construction.
Yes.
Well.
But this, my suit was dismissed. Their counterclaim was allowed.
Counterclaim for?
Decreed. Counterclaim for my eviction in respect of certain portions of the property. But that was...
The trial court held that properties were demarcated.
Trial court did not hold that. Trial court only said, as per the partition, as per the settlement deed executed by the father, they are the owners in respect of that portion, and we are the owners. Did not say anything about that. But on that aspect, Lordship passed these two orders. Now, in the meantime, my lord, the main door has been closed, but there was a threat letter by a learned advocate stating that you are supposed to abide by the judgment and decree passed by the trial court. Otherwise, we will do that. And they have done it. We
Put it on oath, Mr. Banerjee.
Lordship, we have.
There's a supplementary affidavit.
No, in this application only. Can 3 is the subsequent application.
You have filed a
Let this stay.
No, my lord, if your lordship grant us opportunity to file an opposition to this, because there are allegations against us, my lord, we have closed down the door.
You say it is not closed.
No, it was closed, my lord, prior to passing of your lordship's order. My lord,
You did not point that out.
my instruction is that because they even did not point, my lord, that the door is closed. My lord, we thought, my lord, that was not.
We passed an order of injunction restraining you from disturbing what? Disturbing their possession.
No. The order, my lord.
Yes, let us see.
42 of the application.
Lordship.
I'm sorry, my lord, it's page 140.
140, 142. Lordship, 141 and 142.
No, their assurance was recorded.
Yes.
Assurance that not change the nature and character and disturb the existing possession. Yes.
Existing possession is also there.
Yes. How can you put a padlock on the main entrance, Mr. Nag?
File suppression of fact. Well, Lord, I need to file one supplementary affidavit. This prayer was made before the civil court. There was a specific rejection of their prayer. Specific rejection.
By us or trial court?
Trial court. That was, well, Lord, achieve finality.
But you had given an assurance that
No.
Where I
that was recorded in your order. What are you saying?
Well, I tell you, Lordship, well,
Come to page 142 of can 3. Mr. Arindam Banerjee had appeared with Trinath Gangopadhyay and Anindya Haldar.
no, the question is,
Assurance was given by counsel that
it was given prior to that the padlock was there.
no. That should have been pointed out then.
Well,
This was based on the basis of their application. In their application, they had claimed that you were trying to disturb their possession in their possession. Padlock on the entrance, that means they don't have any possession.
well, there are 3 entrances. Well, I tell you, Lordship, can I have a look at the supplementary affidavit? Well, there are 3 entrances. Well, one main and 2 other entrances. Now, well, the main entrance is, well, in my possession, exclusive possession. And, well, they are going at the lower court records that, and that was the status.
There, how are they? They are going into the property and coming out.
Coming out.
Where? Through the other doors.
Door. I am also using another door. Well, can you take my supplementary affidavit? I am giving a copy to the other.
Supplementary affidavit to what?
To the can, well, just to
Can is there, can?
There, can I am filing a supplementary affidavit to assist this court. Well, I am giving a copy to themselves. Well, kindly have a look at the photographs I have annexed.
No, if you want to use a supplementary affidavit, you should have given copies in advance.
Well,
how can you suddenly all of a sudden spring up a surprise on it?
If I can claim only on the basis of the records, kindly have a look at page 53. This is not my violation of my. This is the starts from page 52. This order they have suppressed. Here they have filed an application under Order 41 Rule 5. Lordship sees the third paragraph, middle. He stated, before expiry of such 2 months, defendants illegally and unauthorizedly have blocked the main entrance for which the plaintiff and his family members are suffering. They refer to a later dated such and such. Then, last paragraph, the learned advocates for the defendants number 1 and 2 stated, Order 41, when the execution proceeding was filed, he emphasized the case of execution is not. He referred to the police complaint by the plaintiff and stated that wife of the plaintiff herself out of own will did not come out of the come to the hospital, and it was nothing to do with restriction of ingress and egress. He stated that there is separate entry for the plaintiff which is sufficient to enter the stretcher and carry out medical exigence. Well, he is creating a problem there. Kindly come to page 53. Lordship sees 2, the provisions stay actually 3 from the medical documents.
Nothing else helps you. No adjudication apart from 4 at page 50.
There is.
It is not disputed during arguments that there is another entrance which the plaintiff.
Now the situation has not changed from January 11. But what he did, only one letter of 4th April was created, deposited, and a new cause of action was created, and came back with saying that I have a problem in respect of the take. Now, kindly have a photograph. I will annex that. Now, Lordship sees the photographs at page 49. 49. This is the old house. Now, Lordship will find the 49.
Yes.
The green entrance is in his area, demarcated as per decree. He is using that. Now, kindly come to the photographs on the right hand side where a car is situated. Now, Lordship says there is a.
You have the blue car and the brown door.
Brown.
And he has the red car and the green door.
Yes, red car and the green door. So this is the situation. Now,
what you say?
Now, Lordship, kindly come to the map. So, this situation was there in the court below, and situation still exists.
You will treat this as an opposition and you use and reply to this. Rejoinder.
Lordship.
Mr. Banerjee, come back with a rejoinder.
Yes.
A supplementary affidavit
But
is...
in the
Yes.
May I make my submissions and complete it?
Yes.
Well, in the property, there are 3 doors. One is the main door in between that is used by the parties for over 100 years. It's a very old family. Well, now they have locked the main door, which is at the middle. Lordship may kindly come to the photograph that my learned other side has given. That is the main decorated door in between.
Yes.
And the side doors, those are meant for the house helps.
For the?
House helps. But that is the door that they are using. We had been using this door since my birth and whatever. Now, Lordship will kindly come to one of the threat letters given by
Mr. Banerjee, the trial court's order records that you have
I will show
admitted that
that.
you have separate entrances.
I will show that.
After that, why should you
I
resign
will
from the-
show that to your Lordship, my lord. That was an order passed after the decree was passed. My lord, we did not get the certified copy of the order to present it
No,
before
the other, that's why we said, told Mr. Nag that the other findings are not on merits. But
Yes.
it records that you do not dispute that you have other entrances.
I cannot dispute that. My lord, but there is no
Why should it-
partition. My lord,
Yes.
there is no partition of
How can we be sure that it has been done in violation of their assurance?
But I'm showing
that
it.
position was prevalent at least before the appeal was
I'm
filed.
showing that to your Lordship, my lord. I will show only one letter. My lord, this is at page
Your
number-
letter?
No, the letter given by the other side advocate.
Shows.
They are saying we will do this, and they have done it.
Let us see that.
Yes. My lord will kindly come to page number 114
Of this
Ajgir application go. Kindly comes to page 114. It's a very longish letter by an advocate
Yes.
given to the judgment debtor. My lord,
Right.
saying page 114, my lord, last paragraph.
Yes.
But so many things have been stated, how I will implement, how I will do. Therefore, I have been specifically instructed by my client to intimate you that in order to avoid any legal complications, kindly obey the order of the learned court as mentioned above, and do not disturb my client's possession over the portion of the premises number 8B Jagannath Shur Lane, Calcutta, measuring about such and such, consists of main entrance leading from the common passage, 2 rooms, such and such.
Yes.
But this categorically states,
symbol letter.
No, they say that the main entrance falls within their portion.
this is what they say. But that order, that the judgment that has been passed by the trial court, my lord, this has been kept in abeyance by your lordship.
That's
My
a
lord,
different thing.
that
But
is-
you say that they have threatened that they will close this door and they've
Yes,
done it.
my lord,
That is not
this
reflected here.
language categorically says, kindly see the last line.
Yes.
They say all these things, and lastly they say, by intruding any of the above portions
Yes.
wherein my clients have the exclusive right of ownership.
Right.
They do not say possession.
No.
They say right of ownership.
This is not a threat and they execute that. No. They rather
they have-
claim that they have possession of that portion.
No, my lord.
No.
My lord kindly appreciates. They
They
have,
have stated they are in possession. Please read the first sentence.
but we have also stated we are in possession. That is not a,
denied. That is defied by the trial court's order. The order clearly says that you have not disputed. You have different entrance. How do we know? What is the proof that they have defied the order after their assurance before
Lordship
us?
kindly appreciates the sequence of events. Firstly, the trial court passes an order.
Trial court passes an order, Mr. Banerjee. It's recorded that you don't dispute. You have another entrance. A similar prayer was made there by you.
Well, in the trial court, this main common entrance passage was never an issue.
No, 100% it was issue.
Malad, it was never an issue.
100%.
It
Malad,
was
Malad,
it was only regarding declaration that Malad, kindly see the nature of the declaration.
If the property is in issue, then the entrance has
May I
to be in
show it,
issue.
Malad?
How can the property be without?
May I show Malad what decree has been granted? Lordship will kindly have a look. What decree has been
If
granted?
Mr. Banerjee, if you don't want to use any reply to this, then we'll hear you right now.
Malad, regarding this, perhaps yes, because I
Then
cannot.
we'll yes. Let us
on the issue, Malad, but I
no.
can assure
If they
you-
don't want to use a rejoinder, we'll proceed on
Malad,
this.
I would expect.
Sir, Nag, please.
But if he is speaking, I would not interrupt. Malad.
I'm sorry. I'm sorry.
If you are speaking, we would not also be speaking. So you could please go on speaking. Show us the decree.
Lordship will kindly come to the judgment and decree, my lord. A permanent injunction has been granted in
Yes.
respect of the portion that he is now claiming to be his exclusive portion. My lord, I will take your lordship to the judgment that is at page number 75, lordship. Lordship will kindly come to the decree. Kindly comes to the decree. Page 91.
Yes.
My lord, in the decree, they state this is Schedule A. Schedule A has the main entrance in it, apart from the other portions. And Schedule B is the portion from which my eviction has been prayed for. Lordship will kindly see what the judgment says. The very next page. It is ordered. My lord, I am skipping over the what is the judgment in respect of Schedule A? Lordship will get this 1, 2, 3, 4, 5. In the 5th paragraph from the top, defendant numbers 1 and 2 do get a decree of permanent injunction restraining the plaintiff and or his men, agents, servants, associates from disturbing the peaceful possession of the defendant numbers 1 and 2 in respect of a scheduled property to the counterclaim. This is not a decree for eviction. This is a permanent injunction that they have got.
If they get an injunction that you are restrained from disturbing their possession, that means they're in possession.
But why did they get a permanent injunction? Because the possession in respect of this portion, it lies common in between the parties. I am restricted from, but now this is under execution.
Saying, Mr. Banerjee,
Malad,
you are
now,
restrained permanently from disturbing their peaceful possession over a property which includes the main door.
Kindly permit me to make my submission. If I am incorrect, Lordship will kindly correct me. Malad, they have not got a decree for, eviction, but a decree for permanent injunction. Malad, this prayer or this decree that has been passed by the trial court, Malad, somewhat, Malad, my lord's order has interfered with it. My lord's order says, page number 140. Lordship will kindly come to that order, my lord. Page number 140, my lord.
Yes, 140.
Malad, the learned senior counsel gives an undertaking or assures the court that the respondent shall not change the nature and character of the suit property during the process of mediation, as well as disturb the existing possession in respect of the suit property until further orders passed, either by mediation council or this court, whichever is earlier. Malad, if this is to be accepted, Malad, we are disputing the possession. We are before the appeal court. Now, if this happens, but this will not cause any inconvenience to them, the portion that I have been using, but this will, if Lordship decides, the parties balance of convenience and inconvenience, this will not cause any inconvenience to them. The portion that I have been using, I have been compelled to use the entry and exit of the house helps. But that is simply not done. I am not going into their portion of the property. Lordship, the second, there is no partition. That is my sole ground in the appeal. In terms of the settlement deed of the father, there is no partition decree. Lordship will kindly see the next date's order also, page 142. Last two, but I am perhaps not impressing your Lordship, my lord. I won't extend further.
Third learned counsel for the parties. Learned counsel for the appellant submits that in violation of the assurance recorded in the court's order dated March 27, 2025, the respondent numbers 1 and 2 have locked the main entrance to the suit property. So it is submitted that by virtue of such padlock being put, the appellant's entry to his portion of the property is also debarred. Next para, learned counsel appearing for the appellant contends that the order passed by the trial court at a stage after passing of the impugned decree, where it was recorded that it has been agreed by the, it had not been disputed by the appellants that the respondents were in possession of their portion of the property was somewhat interfered with by the order of this court. Full stop. Next para, learned counsel appearing for the appellant places particular reliance on the orders dated March 26, 2025 and March 27, 2025, where it was recorded that learned senior counsel appearing for the respondent numbers 1 and 2 assured the court that the respondent shall not change the nature and character of the suit property during the process of mediation, as well as disturb the existing possession in respect of the suit property until further orders passed either by the mediation council or this court, comma, whichever is earlier. Full stop. Next para, learned counsel also places reliance on a letter allegedly issued by the learned advocate on behalf of the respondent numbers 1 and 2. Full stop. It is argued that the threat issued in the said letter was executed by putting a padlock on the main entrance door to the property. Full stop. Next para, it is submitted that the main entrance has traditionally been used by both the parties for ingress and egress to their portions of the property. Full stop. The side doors, comma, being the other entrances to the respective portions of the parties, comma, have been used by domestic aids. Full stop. As such, comma, it is argued that the respondents 1 and 2 be directed to remove the padlock to the main entrance of the property. Full stop. Learned counsel appearing for the respondent numbers 1 and 2 seeks to file a supplementary affidavit which is filed today and kept on record. Full stop. On specific query of court to learned counsel for the plaintiff stroke appellant, comma, as to whether the appellant wants to use any rejoinder thereto, comma, learned counsel for the appellant submits that the appellant shall not file any such rejoinder and seeks to argue the matter on the materials already on record. Full stop. Next para, we find from a photograph annexed to the supplementary affidavit that there are separate entrances for the appellant's portion as well as that of the respondents. Full stop. Next para, also, comma, as evident from the schedule of the suit property as mentioned in the decree, impugned decree, comma, permanent injunction was granted restraining the possession of the plaintiff stroke respondent numbers 1 and 2 in respect of Schedule A. Full stop. Schedule A categorically includes the main entrance leading from the common passage to the property. Full stop. Next para, thus, comma, the permanent injunction which has been assailed before this court in appeal also covers the main entrance. Full stop. Thus, comma, there cannot be any doubt that that by the impugned decree, comma, the respondent numbers 1 and 2 are already enjoying permanent injunction restraining the plaintiff appellant from disturbing the respondent numbers 1 and 2's position in respect of the property. Full stop. Next para, as such, comma, we also do not find any threat in the letter of the learned advocate for the respondent numbers 1 and 2 which has been alleged to be executed. Full stop. By the said letter, comma, the purport was for the appellant to maintain the possession in terms of the impugned decree. Full stop. Next para, we do not find any conflict between the impugned decree and the assurance given before this court by the learned senior counsel for the respondent numbers 1 and 2 to the effect that the existing position shall not be disturbed by the respondent numbers 1 and 2. Full stop. Next para, since the main entrance door was a part of the Schedule A property in respect of which permanent injunction was granted by the impugned order, which is yet to be tested in the appeal, comma, we are of the opinion that there is nothing on record to substantiate the allegation of the appellant that subsequent to the assurance being given by learned counsel, comma, the respondent numbers 1 and 2 have violated the same by putting a padlock afresh on the main entrance door. Full stop. As per the impugned decree, comma, the said main entrance was all along in the position of the respondent numbers 1 and 2, comma, which position has not been deviated from till date by any court of law, including the appellate court, that is us. Full stop. Next para. Thus, comma, we do not find any merit in the this can 3, Mr. Banerjee, is for vacating that implementation.
It's titled
for appropriate
for
Acha.
appropriate orders, my lord. Only for the door.
Merits in can 3 of 2025, comma, whereby the appellant has sought for an order restraining the respondent numbers 1 and 2 from obstructing the entrance and ingress and egress of the appellant in respect of the suit property through the main entrance. Full stop. Thus, accordingly, comma, can 3 of 2025 is dismissed on contest without any orders to cause. Can 1 is still pending.
Yes. Stay.
May I say one thing? Well, the father of our this party was very wise man, and if deed of settlement is produced, I think everything will be clear, and there is nothing to look.
Will examine the wisdom of your father at the time of final hearing.
It is partition.
Now
It's
let
very
us
partition, even common.
now let us direct both of you to
Spent, right?
in terms of the assurance, Mr. Nag, will dispose of can 1.
Do anything.
We'll dispose of can 1 and we'll put it, we'll make it an order of the court that both of you will maintain your respective positions in terms of the impugned decree.
Just to expedite the
We'll do that. What is can 2?
Can 2 was
Section 5
that was allowed on the first.
Can 1 of 2025 is now taken up for hearing. Full stop. In view of a prima facie case having been made out for hearing the appeal on merits, comma, we direct both parties to maintain status quo with regard to their respective positions in terms of the impugned decree till disposal of the appeal. Full stop. There will be no orders to cost. The trial court records shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who is of liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
I'm grateful, man.
Lordship has only said possession, kindly makes it nature and character also.
In my position, if somebody.
But both the parties.
If my position, it's a very old house, if something is.
They say I am in possession. I will make
But
constructions.
I am not saying something. If there is something in the ceiling and I have to come back again, I have to come back.
Mr. Banerjee, you have not made any prayer for
No, that is not-
partition in the suit.
No, no.
So therefore, why should we
But
direct?
it is there in the appeal, one of the grounds in the appeal. That is there. But I can.
You did not make any prayer before the trial court for partition. There was no relief of.
Not really.
Then how can we restrain them from constructing on their portion?
They cannot make also. I am in that property, my lord. I am in that property.
I'm grateful.
But they are all. I am also staying.
बोलम ना accordingly in the light of the above observations without any orders to cost. ওটা হচ্ছে এই পেপার বুকের ডিরেকশনের আগে।
But only one thing, my lord. They say I am in possession of their portion. If I make
only in respect of one.
In terms of the impugned degree, you will maintain your position. Next.
We have to come.
What?
ঠিক আছে সেটা তো
Yes.
This is my petition, my application, man.
For the first time,
For the first time.
serve copy and come back. Serve copies of both the applications.
Well, tell direct me to serve the copy.
Pardon?
Can you direct me to serve the copy? So I serve.
Yes, we'll do that. The appellant shall serve copies of can 1 of 2025 and can 2 of 2025 on the respondents, indicating that the applications shall be listed for hearing on July 15, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Great.
Serve both the applications.
Both the applications.
Next.
Along with the appeal.
Memo should be
Memos.
very well. যেখানে বললাম serve copies of both the application along with the memorandum of appeal.
Great.
Respondent numbers 1 and 2.
My lord,
Number 5.
1 and
my lord,
2.
I'm appearing for
1
the
and 4.
1 and 2.
pro forma respondent number 10 to 14, my lord.
Is anybody appearing for the appellant
My
also?
lordship, I am appearing on behalf of the appellants. My lordship, on the earlier occasion, I have seek for time, and your lordship has give 1 week time for filing the reply in affidavit in opposition. But my lordship, only solely on the personal ground, I was ill. For that reason, my lordship,
You yourself were ill.
yes, my lordship, so that I could not prepare the.
My lord, they prayed for
My
time,
lordship,
but
for
he
the
was
last time, kindly, my
What
lordship.
was the reason in the previous occasion?
No. I only prayed for 1 week time for filing the
No,
reply.
it was extended.
Yes.
Yes, my lordship.
No, my lord, may I?
We'll give them 1 minute. What may?
My lord, I have some objection. Normally, I do not object, but
Everybody says that when objecting.
the lordship may kindly takes up my opposition. Kindly. For a minute.
Why? What is your objection to his sickness?
No, not to his illness, my lord. My objection is that, my lord, there is a suppression of a material fact. I don't know.
We'll hear when we hear the application. We'll take care of that.
The difficulty is that, my lord, they are enjoying an interim order. My lord, the entire
We'll give them a last chance. We'll make that
the
clear.
entire construction has been stalled, my lord, and there is already an order of probate by this honorable court, my lord, way back in 2006. That has been suppressed in the plaint and also in this application. And by suppressing that fact, that interim order was obtained. And I have pointed out everything, my lord, in my opposition.
Then counsel for the appellant seeks an extension.
May I submit one thing, my lord? I pray before your lordship that I am the plaintiff number 1 to 4 in the title suit, my lord. So, my lord, I want to make a reply to their opposition, my lord. If your lordship kindly direct them to serve a copy upon us, it will be convenient for us to make a reply, my lord.
Very well. Let counsel for the pro forma respondent numbers 10 to 14. You are for 10 to 14.
Yes,
10 to 14 seeks an opportunity to file
Great.
an opposition, file a affidavit in reply, stroke rejoinder to the affidavit in opposition used by the respondent numbers 1 and 2, TO2 Can 1 of 2025. Full stop, next para. Learned counsel for the appellant seeks an extension of the time to file affidavit in reply on the ground of sickness of learned counsel for the appellant. Full stop, next para. Learned counsel for the respondent numbers 1 and 2 seriously opposes the prayer for adjournment and contends that the construction intended by the respondent number 1 and 2,
It has already been started, but it has
which has already been started, comma, is being unnecessarily stalled indefinitely due to the prolongation of the matter on adjournments sought by the appellant. Full stop, next para. It is further submitted that a probate was granted long back, but
it was granted, my lord, on
the
31st
said fact was suppressed by the appellant in their application. Full stop, be that as it may, comma, since the pro forma respondents, comma, who are the plaintiffs in the suit in the trial court, have every right to use a rejoinder and put their own pleadings on record, comma, the respondent numbers 1 and 2 is directed to serve a copy of their affidavit in opposition on the learned advocate for the pro forma respondent numbers 10 to 14 during the course of the day, full stop. Opposition rejoinder stroke reply, comma, if any, shall be filed by the pro forma respondent numbers 10 to 14 to the said opposition within a week from date, full stop. The time for filing reply by the appellant is also extended for a week, full stop. Next para. The issues urged by learned counsel for the respondent numbers 1 and 2 are kept open for being adjudicated at the time of disposal of the application and or the appeal. Full stop, next para. The application shall next be listed for hearing on short date, very well, July 8, 2025.
Grateful, your lordship.
Madam.
Thank you.
That I am for the petitioner.
Yes.
I am
You're
for the
first.
respondent.
Right.
But pursuant to my lord's last direction, Lord, they have used an opposition to my application.
They've used an opposition.
They have used, Lord,
File it.
beyond time, but Lord, that has been accepted, Lord.
Is on the record.
You have filed already?
Yeah, already filed.
What is that?
No, no, file করেনি তো এখন ফাইল না এটা অপোজিশন না ফাইল করে দিয়েছি কোথায় ফাইল করেছি আর ডিপার্টমেন্ট
What is in your hand then?
ডিপার্টমেন্টে ফাইল করেছি
এই তো অপোজিশন আপনার কাছে অরিজিনালটা দিয়ে দিন জজ সাহেব
অপোজিশন
You thought so? You said it, you have already filed? Yes, reply, no reply.
Yes.
Lord, my case in the, kindly remember, Lord, my case.
Yes, they are saying that let them be permitted to harvest the crop which has already been sowed there.
First of all,
let him start then. If you have any objection, we'll hear him, then hear you.
Lord, I will bank upon their opposition itself.
Yes, show
Lord,
us.
the plaint case filed by them itself suggests that yes, both the parties, according to their joint plot decision by meets and bounds, are enjoying the property. That is the plaint case. Lord, now takes up Lord, the opposition.
This is against what? Preliminary degree?
No, no, no.
Oh,
Lord,
injunction.
Injunction, Lord, so far as regards Lord, the nature, character,
Status quo has been granted.
Status quo, Lord, with regard to possession, alienation, Lord, I am agreed, Lord, that can be, Lord. But with regard to the harvesting of crops,
Nature and character
nature
also.
and character, if status quo to be maintained, nobody. Comes to Lord, page 3 of the opposition.
Yes.
Lord, point number C. I said that this deponent along with his two brothers are entitled to get 6 anna share out of LR plot number such and such, measuring 92 decimals of land, while the appellant defendants, the appellant before hereof, are entitled to get 10 anna share. Now, Lord, kindly takes up point number D, that by filing this suit, the deponent filed an injunction application seeking direction to the appellant. So, Lord, these are the direction they have sought for. Now, kindly takes up E. I say that the appellant forcefully took possession of 82 decimals of land out of 92 decimals of land, and allowing this deponent and co-sharer only to hold about 10 decimals of land, wherein the deponent has plantation and carrying on cultivation of the vegetable. Kindly next paragraph. I say that according to the LR record of rights, the deponent co-sharer are entitled to 34 decimals of land, while the appellant are entitled to 58 decimals of land. But last 20 years, the appellants are enjoying the major portion of the land. Recently, they have sold out almost 200 to 250 bamboos. Lord, I am not troubling your lordship regarding that. That is the allegation of cutting of bamboos. Now, Lord, kindly now takes up point number H and I. The standing trees are being enjoyed by them, and yearly plantation stroke cultivation over 82 decimals of land are carried on by the appellants, and showing utter reluctance of to get the property in
They admit that you are cultivating that 82.
And for Milord, last 25 years, point number I also. So Milord, I say Milord, on their Milord admission, Milord, at least to the effect of Milord, the changing the nature and character.
Admittedly, they have sowed over that property. They are harvesting crops over 82 decimals. So we'll permit them to harvest the crops regarding that 82.
Not a totally cultivable land.
Cultivable? We understand
only
that they are only owners of 58.
Let me please. Only a single part, minimum 10 decimal was permitted to cultivate. Where I am entitled to get 34 decimals of land to cultivate. They are not allowing me. They are not allowing me. For the last 20 years, they are enjoying the issue rights of the land in questions. So then they should restrain for this year.
They have cultivated the land and they will not crop harvest the crop.
This is it.
You will harvest the crop.
No, they are cultivating. They are enjoying their.
Admittedly, they are over in position over 82 decimal for last 25 years. Therefore, of course, this cultivation was done within these 25 years.
They may be, but
so if they have harvest, they have sowed the crops.
My lord,
they won't be permitted to harvest it. You will harvest.
My lord, they are enjoying the issue facts for the last 20 years without paying their share.
It will be decided in your partition suit.
Later directions. Partition suit. There is a partition suit, my lord.
That will be decided in your partition suit, not at the injunction stage.
But if they want to cultivate, the later direction be made that as per our 6 annas
we definitely won't dispose them, since you have admitted they're in occupation of for about 25 years.
My lord,
you will get a partition degree, that will be done. You have to get a degree before the court will.
Total land is not cultivable land. It is.
They get to harvest what they have sown. You won't get their crops. Admittedly, they have harvested. They have cultivated.
Well, unnecessary. They have no right to enjoy 58 decimals of land.
Yes.
And allow me only 10 decimals and enjoying the
That will be taken care of in the suit.
until they restrain.
Then we'll ask them, we'll have to dispose them during pendency of the suit
No.
and grant the partition degree from here.
Later direction we pass.
You have admitted they are in possession of 82 decimals for last 25 years.
My lord, they are forcefully.
Your admission.
They are forcefully enjoying.
They are forcefully enjoying. But your allegation is forcefully, but your admission is that they are in occupation. Whether forcefully or not, that will be decided by the trial court. But it's an admitted position that they are in possession. So they have sown the crops.
Can they deny their share? More than
we are deciding the appeal. What is the use of keeping the appeal pending? We are deciding the appeal. We are directing.
Direction we passed.
Will permit both of you to harvest the crops in respect of your respective the portions occupied by you.
Only 10 decimals, which
that will have. You are saying that you
are. No, my lord. If justice should be subserved upon both the parties, my lord. Allow me to cultivate minimum 6.
We cannot disturb the existing position at this stage.
And
the present appeal has been preferred against. It is an ad interim status quo or the injunction application. We'll direct the injunction to be decided. Have you filed your objection, Mr. Mukherjee?
Objection. Yes.
Check up.
No, my lord, I'm sorry, my lord. It's
within a week. Within a week. Within a week.
No, my lord, it's contested.
You have filed or not?
It is a contested injunction, my lord.
Contested that does not necessarily mean that you have filed your objection. You can contest without filing. We'll record that you have filed.
Objection.
Oh, the order is contested. That's right. Injunction. Let the suit to be expedited.
Yes.
The present appeal arises out of a status quo order passed while disposing of the application for injunction filed by the plaintiff stroke respondents. Full next para. Learned counsel for the appellant submits that admittedly the appellants are in occupation of 82 decimals out of the total 92 decimals of the suit property as per the pleadings of the affidavit in opposition filed by the plaintiff's opposite parties in court today for the last 20-25 years. Full stop. As such, the appellants may be permitted to harvest the crops which have been sown SOWN by them in their portion of the property. Full stop. Next para. The affidavit, learned counsel appearing for the plaintiff's respondents files an affidavit in opposition which is kept on record. Full stop. By relying on the same learned counsel argues that the appellants are in unlawful occupation of a majority portion of the suit property, whereas their share is restricted to 58 decimals. Full stop. The rest 34 decimals, it is argued, are owned by the plaintiff stroke respondents. Full stop. As such, it is contended that the forcible occupation of the appellants should not be permitted to continue by allowing them to harvest the crops sown in respect of the extra land occupied by the appellants. For the next para, upon a careful consideration of the contentions of the parties, we find that the issues involved in the appeal as well as the application are identical. As such, we take up the appeal along with the application for being adjudicated together. Together, upon dispensation of unnecessary formalities. Next para. The fact remains that the learned trial judge passed an order of status quo with regard to nature and character, possession and transfer of the suit scheduled property till disposal of the suit. The plaintiff's respondents have not challenged such order. As such, the plaintiffs have acquiesced to the portion of the impugned order whereby status quo has also been directed to be maintained in respect of the current possession of the parties in respect of the suit property. Next para. In the affidavit in opposition filed before us, the plaintiff's respondents have admitted that the appellants are in occupation of 82 decimals of the property, whereas 10 decimals are in occupation of the plaintiff's respondents. In the absence of any challenge to the status quo regarding current possession by the respondents, the respondents cannot now argue that the appellant's possession in respect of the suit property, to the extent as held by them on the date of passing of the impugned status quo order, can be disturbed. Next para. It is only just and proper that the person who has cultivated a particular portion of a land is permitted to harvest and reap the crops so grown on the said property. Thus, we deem it just and we deem it appropriate to modify the impugned order to the extent that the parties shall be permitted to harvest the crops sown on their respective portions of respective possessed portions of the suit property. Accordingly, FMA 858 of 2025 is allowed on contest, thereby modifying the impugned order bearing order number 8 dated March 24, 2025, passed by the learned civil judge, senior division at Ghatal, district Poschim Medinipur, in title suit number 69 of 2024, to the extent that the parties shall continue to maintain status quo in respect of nature and character, possession, and regarding transfer of the suit property till disposal of the suit, however, nothing in the said status quo order shall be deemed to prevent the respective parties from harvesting the crops sown on their respective possessed portions of the suit property till disposal of the suit. Next para. It is consequentially, can 1 of 2025 is also disposed of. It is made clear that this court has not entered into the merits of the contentions of the parties, which shall be decided independently in accordance with law at the final hearing of this suit. Bas, urgent certificate copies.
Great.
Thank you.
Great.
Next. Take it in act.
I'm for the appellate.
In this matter, I am for the respondent number 2, Lordship. 1, Lordship.
Respondent 1.
Yes, Lordship.
I'm for the.
You are for 2. Yes.
My lord, this is affidavit in reply, my lord.
Opposition
Lordship, may I file appeal?
Opposition already filed by them.
going to be filed.
I did not get the copy, my lord.
You have got a copy. That's why you have filed a reply.
No, that is for respondent number 2, bank.
Oh.
Bank gave me the affidavit in opposition. This is respondent number 1, who is the landlord.
কি করছেন আমাকে দুটো রিপ্লাই দিয়েছেন ওনাকে দুটো অপোজিশন
আমি
দিয়েছেন
I have given you the affidavit reply against the respondent number 2.
এক্সচেঞ্জ করে নিন একটা কপি না না এটাও তো রিপ্লাই সব তো রিপ্লাই এগুলো ফেরত দিন ওনাকে আপনারা বেশি দিন ফেরত দিয়ে দিন ওরা দেখতে বেঁচে দেবে দিন ফেরত দিন ওরা বুঝিয়ে দেবে yes please clarify what is what
My name is written, my lord. This is affidavit in reply against the respondent number.
is also there in the back sheet reply is written
I am for the respondent 1, sir. Lordship.
no sir will do but how,
Reply,
how
Lordship.
can the respondent file a reply he will file an opposition
Pardon me, Lordship.
that's meant to be an opposition
Yes.
you have given a copy to them
No, Lordship. I will serve the copy, Lordship.
reply to
May I
আবার ফেরত দিয়ে দিন ফেরত
My lord, this is against the bank, my lord. This is separate.
you are not using any opposition
Yeah, he has given.
Reply is there against my opposition. On the last occasion, they did not even ask for any extension to file their opposition. And now, today, at the time of hearing, they are coming up with this opposition without even search.
This is
who is coming up with the opposition
My respondent number 1, and my lord, I am the worst suffered.
Respondent number 1 is the landlord, my lord.
you file a reply today to the opposition of the bank
Yes, my lord. Opposition to the respondent number 2.
Who is the bank?
Bank. Yes, my lord.
Well, the affidavit in reply filed to the affidavit in opposition filed by the respondent number 2 bank today be kept on record. Full stop. Learned counsel appearing for the respondent number 1 seeks to use affidavit in opposition to the application. Full stop. Time for filing such affidavit is granted for a week from date. Full stop. Reply thereto, if any, shall be filed. You also want to file a reply to their opposition. Reply thereto shall be filed by the appellant as well as the respondent number 2 within a week thereafter. Full stop. Copies of the affidavit in opposition filed by the respondent number 1 shall be served both on the appellant as well as the respondent number 2 by tomorrow. Full stop. Next para. The matter be listed under the same heading on July 16, 2025.
My lord, ad interim injunction is vacated in 30th June, my lord. Bank is in surfacey, my lord.
No, we'll extend the interim order for a limited.
Yes, my lord.
I can proceed in accordance with law at least, my lord.
No. Ad interim order granted
I have made a specific performance of
is extended till July 31, 2025 or until further order, whichever is earlier.
Deeply applies.
No, what was the injunction passed?
The order of injunction restraining the respondent number 1 to maintain status quo.
So how are you affected?
Not the respondent number 1. The respondents will maintain status. Now, being a bank, my lord, I am suffering because I cannot.
Wait till 16.
Yes,
Bank
my lord.
has
This is
so
a specific
much other business.
contract, my lord. Unregistered sale agreement. I will argue on 40.
Registered agreement.
Section 49. I will interpret, my lord. Possessory title is a.
We will decide on 16.
Possessory title is a good title against all except landlord.
You argue among yourselves. We will come back on.
No, my lord.